ಮೇಲೆ ಬರಿಬೋದು ಬೇಕಿಲ್ಲ ಇಚ್ಕೊಂಡು ಹೋಗ್ಬೋದು ಇದ್ಮೇಲೆ ಮೇಲೆ ಇಚ್ಕೊಂಡು ಹೋಗಿ ನಡೆಯುತ್ತೆ ಇದು ಮಾತ್ರ ಚೇಂಜ್ ಆಗ್ತದೆ ಕಾಡ್ ಮೇಲೆ ಬರಿಬೋದು ಕಾಡ್ ಮೇಲೆ ಕಾಣಿಸಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಇಲ್ಲಿ ಬರೀಬೇಕಾಗ ಇಲ್ಲಾಂದ್ರೆ ಹಿಂಗೆ ಬರ್ಕೊಂಡ್ರೆ ಅಲ್ಲ ನೋಟ್ ಪೇಪರು ಪ್ಯಾಡ್ ಮೇಲೆ ಬರಿಬೋದು ಕಾಣಿಸಲ್ಲ ಪೇಪರ್ ಲೆಸ್ ಅನ್ನೋದು ಅದು ಇದಾಗಲ್ಲ ಪರ್ಪಸ್ ಅಲ್ಲ ಜೀರೋ ಆಮೇಲೆ 22770 ಅದೆರಡು ಫೈಲ್ ಅಲ್ಲಿಂದ ಬಂದಿಲ್ಲ ಅಲ್ಲ ಹೇಳಿ ತರಿಸಿ ಅಂತ ತರಿಸ್ತೀನಿ ಯಾವ್ದು ಫೈಲ್ ಮಾಡಿ ಹೇಳಿ ಅದು ಅದರಲ್ಲಿ ಇದೆ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ತರಿಸಿ ಅಂತ ತರಿಸ್ತೀನಿ.
Some of the matters are listed, there were two matters that got been listed where you have filed statement of objections one and all.
Let's see that.
Connected matters are disposed ಆಗಿದೆ ಅಂತ ಇದಾಗಿದೆ ಬಂದಿಲ್ಲ ಲಾಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ಹುಟ್ಟಿದ್ದಾರೆ
ನಾ ಫೈಲ್ ಸಿಕ್ತಿಲ್ವಾ ಅಂತ ಲೆಟಸ್ ಸಿ
Statement of objections that's a part matter.
ಫೈಲ್ ಸಿಕ್ಕರೆ ಎಲ್ಲ ಬರುತ್ತಾನೆ
ನೆನ್ನೆ ಫೈಲ್ ಮಾಡಿದ್ವಿ.
ಅಬ್ಜೆಕ್ಷನ್ ನೆನ್ನೆ ಫೈಲ್ ಮಾಡಿ
ಆ ಫೈಲ್ ಒಂದು ಬಂದು
ಲೆಟಸ್ ಸಿ
Your Lordship's kind permission.
yes
Lord, serial number,
adjournments page number 7 seal number 25 to 28 page number 8 page wise page number 8 seal number 29 to 34
Lord, 33 and 34.
ಒಂದು ನಿಮಿಷ 31 33 and 34
Weeks time may be granted, my lord. Weeks or 2 weeks time because I have a little pain in the ear. That is why.
ಲಿಸ್ಟ್ ಅವ್ರು ತಿಳಿಸ್ಬಿಡಿ ನಿಮ್ಮ ಎದುರು ಪಾರ್ಟಿಗೆ
Please, after 2 weeks, my lord.
19 page number 9 seal number 35 to 38
ಲಿಸ್ಟ್
19 page number 10 seal number 39 to 42
you are for whom list
20 page number 11
serial number yes list
page number 11 seal number 43 to 48 Page number 12, seal number 49 to 53.
We informed him. Realist.
Page number 13, seal number 54 to 58.
You are for? Realist.
Page number 14, seal number 59 to 61. Page number 15, seal number 62 to 65. Page number 16, seal number 66 to 71.
Realist.
Fresh matter, seal number 1.
No. Other. This is the gas. So. Yes.
I think all property find that but because any reasoning compensation has been enhanced.
Page number?
Page number 108 paragraph number 37. He accepts all the conditions and then he accepted all class with the deputy commissioner also. But in the 110 minutes, he gives a finding that there is compensation increased by 1.5 times market or reduced by
1 crore 82 lakhs is per acre by the SLO.
Sir, it has been determined. Because what happened is, after the line was drawn, number giving the compensation, we will this there was an obsession we made to the deputy commissioner. Deputy commissioner by an team member, he passed an order after obtaining the reports from the SLO based on the average 3 years market value of the lands.
What is the guideline value?
Is that he has given a guideline value? Yes, SLO was given a guideline value.
No, what about the-
Guideline is 1 crore.
How does the district judge come to the conclusion?
No, there is no finding yet to that effect. He says that he meets the ends of justice that 1 crore 82 lakhs can be enhanced by 1.5 times. 110, page number 110.
Where is the SR value determined? Where is the guideline?
So guideline is page number 41, it's a value between page number 39.
No, in the order of the district judge, where is the reference to the guideline value?
That they have not, he has
What is the guideline value according to you?
not, probably to meet out 1 crore 82 lakhs as of 80.
Ah,
Guideline value of 93 lakhs as determined by the deputy commissioner. He said.
what is the guideline value fixed by the sub-registrars?
Submission fee and 1 crore 82 lakhs.
Ah, so if you are going to acquire it under the 2013 Act, it should be twice that, isn't it?
It is not allowed like this.
Where is the guideline value?
No, it is page number 39. I will read the deputy commissioner order, page number 39.
No, where is the guideline value? Where is the notification?
Notification is not there. It is the deputy commissioner. Deputy commissioner.
You should produce it, isn't it?
No, it is the deputy commissioner. So I obtain the guideline value.
Deposit this money into court. The enhanced company deposit into court.
First,
Deposit into court. What is the problem for you to deposit? They will not take it.
what is happening is when we submit is a compensation determining another land acquisition, another legal act. By the deputy commissioner. Based on the applying the guidance.
Here is an enhancement. You are challenging it.
We have paid the, yes, sir, we have paid the.
Deposit the enhanced compensation into this court.
And compensation. We did not deduct it, but whatever compensation you already paid also.
Therefore, the enhanced compensation minus whatever has been paid, deposit into court.
3% of the enhanced compensation.
That we will decide, but until then you please deposit the amount into court. I will direct the registry to invest in a fixed deposit. Why should you keep the money? If ultimately I dismiss the petition, liability to pay interest will be there on you. Isn't it? So deposit the enhanced compensation before this. Until that, you deposit the amount into the High Court.
We already paid you.
Issue notice. HCGP accepts notice for R2. This is an interim stay of the impugned award, subject to the condition that the petitioner deposits the enhanced compensation before this court within a period of 8 weeks by 4 weeks. On such deposit being made, the amount deposited shall be invested as a fixed deposit. It is made clear that the petitioner would be liable to deposit the difference in the enhanced compensation only, and the amounts already paid under the award passed by the SLAO need not be deposited by the Deputy Commissioner. It need not be deposited. Only the difference. Whatever is deposited by the enhanced by the DJ, that you will deposit. That 2 crore something, that you will deposit into this court. 1 crore 82 lakhs was by DC. 2 crore something is by the Deputy Commissioner. The difference of about 70 lakhs, that you will deposit.
Preliminary hearing, C number 2, Shri Mohammed Dastagir.
No, to withdraw the illegal resolution. To withdraw the illegal resolution. That lady auto rickshaw. Notice order ಮಾಡಿದಲ್ಲ ಅವರಲ್ಲಿ.
ಉದ್ಯೋಗಿ ಅಂತ ಯಾವ ರೀತಿ ಡಿಸೈಡ್ ಮಾಡಿ ಮಾನದಂಡ ಏನಿರಬೇಕು ಎಕ್ಸಾಂಪಲ್ ರೇಷನ್ ಕಾರ್ಡ್ ಮತ್ತೆ ಬಿಪಿಎಲ್ ಲೈಕ್ ಬಿಎಲ್ ಯಾವ ಸ್ಪೆಸಿಫಿಕೇಶನ್ ಬೇಕು ಉದ್ಯೋಗಿ ಅಂತ ಡಿಸೈಡ್ ಮಾಡೋದು ಹೇಗೆ ನಂಬರ್ 49
This is what he has also produced. This can't be the reason for you to sit on the permits. Madam, you will defeat the very purpose of this granting of permit to lady auto rickshaw.
ಬಿಪಿಎಲ್ ಕಾರ್ಡು ಮತ್ತೆ ಬಿಎಲ್ ಅದೆಲ್ಲ ಇರಬೇಕು ಅನ್ನೋದು ಕೆಲವೊಂದು ಕಂಡೀಷನ್ಸ್ ಇದೆ.
My lord, DL is already exempted for.
You are concerned about granting permits to unemployed ladies. And find out the means of ensuring whether they are unemployed or not. ಅದಕ್ಕೆ ಏನಾದ್ರು statutory rules frame ಮಾಡಬೇಕಾ? And that is what you are saying.
DL ಇರಬೇಕು ಅವರೇ ಡ್ರೈವ್ ಮಾಡಿ.
DL is already exempted, my lord, by an Annexure B notification. My lord, for a moment, kindly go through Rule 58, my lord. The answer will be found very much there itself. What is the procedure to be adopted?
Next year.
application. सारे ऐसे ही taken 2016. But in voting, valid driving license, dispatch drive auto rickshaw cab.
There's an exemption for unemployed women.
Yes.
So what you want to find out as to what is the means to determine whether she's unemployed or not?
Yes.
How can she prove the negative?
ఇప్పటికే ఆపాలి. కార్డు వల్ల వెరిఫికేషన్ మాత్రమే.
So you will say she is doing tailoring work at the house, therefore she is employed. She is doing some other work, therefore she is employed. What is it? According to the man. Let the commissioner file an affidavit.
My lord, for a moment, kindly see rule 58 of KME rules, my lord. The answer will be found very much there itself.
What is this first government notification dated 26/3/2018?
Annexure A, my lord. My lord, there also the requirements are already given in condition number 6. An individual applicant is required to produce any one of these in mentioned in annexure, sorry, condition number 6, my lord. My lord, rule 58 of the Karnataka motor vehicles rules.
58.
58, may I read, my lord?
Yes.
Disposal of applications for contract carriage, goods carriage and private service permits. I submit that auto rickshaw is a contract carriage, my lord. When an application for contract carriage permit or goods carriage permit or private service permit is received by the Secretary of the Regional Transport Authority, he shall examine whether the powers to deal therewith has been delegated to any other officer under Rule 55 and forward the same to him for disposal. In case where the application referred to in the preceding sub-rule is required to be considered by RTA, the Secretary shall scrutinize whether the application is in order and call for such further particulars and make such other inquiries as he may consider necessary, and shall, subject to any general directions of the Regional Transport Authority, decide whether the application be disposed of by the circulation procedure or at the meeting of the Transport Authority. Normally, the application referred to in sub-rule 1 shall be disposed of within 1 month of the receipt thereof. My respectful submission, my lord, identifying a unemployed woman is not a hilarious task, so that the government should fix up the criteria for that. Rule 58 itself provides sufficient power to the Secretary to make inquiries or call for such other information.
Please come back to annexure A.
Annexure A, my lord. Yes, my lord.
This reservation for women, is it only for that condition number 4, 500 permits?
No, my lord, that is a separate kind of permit. That is a pink auto rickshaw. But this scheme has not been successful now, and we don't see any pink auto rickshaws at all. For pink auto rickshaw, the women are required to have their own license. It is for women and driven by women. That scheme itself has been a failure, my lord. No woman has.
Secretary that is referred to in the rule.
My lord.
Secretary of RTA.
Yes.
Let him file an affidavit.
Respondent number 2, my lord.
By the notification dated 26/3/2018, the government, in excess of its powers conferred under section 74 subclause 3 subclause A of the MV Act, decided to enhance the existing quota of auto rickshaw permits from 1,25,000 to 1,55,000 for the next 5 years. One of the conditions imposed was that the applicant should be a holder of a valid driving license with a badge to drive the auto rickshaws, cab for LPG/CNG/electric auto rickshaw permits. Over 2 years after the notification, by another notification dated 69/2020, the government exempted the requirement of the applicant being the holder of a valid driving license with badge insofar as it related to unemployed women. Next, it is the case of the petitioners that though they are unemployed women, their applications are not being considered. The learned High Court submits that the criteria for deciding as to whether an applicant, that is an unemployed woman, is actually unemployed or not, is not very clear. And therefore, clarification is sought for from the government regarding the criteria to be adopted to identify and ascertain whether the applicant is in fact an unemployed woman. Learned counsel for the petitioner places reliance on Rule 58 subclause 2, which indicates that for every application that has been filed, it's the obligation of the secretary to scrutinize the same and also consider making such an inquiry as he deems fit. In this view of the matter, it is clear that the secretary of the RTA has the obligation of determining whether an applicant woman is unemployed or not. And for that purpose, he may hold any inquiry that he deems fit. In this view of the matter, the calling for a guideline from the government may be unwarranted. The Secretary RTA is therefore directed to file an affidavit as to in what manner he would construe the applications in the light of 58(2) by the next date of hearing. Relist on. Let him file. It's his responsibility. If he does not do it, how many women applicants are there? 20 ಜನ ವಿಚಾರಿಸಕ್ಕಾಗಲ್ವಾ ನೀವು? You don't want to give on the concept, that is all. For the past 4 years, you've done nothing.
ಆಯುಕ್ತರಿಗೆ ಅರ್ಜಿ
The
ಕೊಟ್ಟಿದ್ದಾರೆ.
enhancement of permits was from 2018 for a period of 5 years. That 5 years is over now. Then what is the point in you sitting on this? You ensured that the reservation is not given to anybody. List.
19.
My lord, could it be on 18th, my lord? Thursday,
19.
Thursday.
I have too many matters on.
My lord,
18th.
ME matters will be on Thursday.
ನಾನು 18ನೇ ತಾರೀಕು ಜಾಸ್ತಿ ಹಾಕೊಂಡಿದ್ದೆ ಮ್ಯಾಟ್ರ್.
Okay. 19th, my lord.
See number 3.
Obliged.
Apology, my lord, I failed to take my lord, drag the attention of my lord, sir, to page number 38, my lord, in similar case.
ಕೊಟ್ಟಿಲ್ವಾ?
In the similar case, page number 38,
I
Balraj
will
has
not
been.
grant an interim order in respect of our dues unless you deposit.
I'll deposit, my lord, my submission is.
I will consider your arguments after a year then. Without that, you will not get an unconditional interim order.
Please, ma'am.
Survey copy.
My lord, in the
Nandikeshwar.
similar case, Balraj has been taken notice, my lord, another 2 cases in page number 38 and 40.
Balraj idhar hai.
In the similar notice has been challenged.
Have they
my
filed objections in that case?
In not yet filed, my lord.
Serve it on or let us see.
Please, ma'am.
There shall be an interim stay.
Hmm?
Of annexed sheriff, subject to the petitioner depositing a sum of rupees 2,74,091 before this court within a period of 2 weeks. Relist on.
19. See number 4. Vamshi Krishna.
The petitioner, my lord. No, this is the back billing notice, my lord, of Bescom, which was listed yesterday, and I served a copy to the other side.
ಏನು ಮೇಡಮ್ ನೋಡಿದ್ರ?
The tech premises, they are running one cafeteria, restaurant, my lord, and the Apollo pharmacy is there, provision stores are there. Those are running under the LT2, my lord. And STP is there, it is always on the LT5, that is also running in LT2 only.
This is a part of an apartment complex.
It's a part
part
of
of-
apartment complex, my lord, but there's STP is always on the LT5 only, my lord. It is not, it comes under the LT2A only. As per the tariff rules, my lord, STP comes under
Now, if the
LT5.
STP is a part of an apartment complex, also the same criteria is adopted. STP independently, you're right.
Yes, my lord.
But if the STP is a part of the apartment complex, which is necessitated by a bylaw, can you
Yes,
still say it's a separate unit?
no, my lord, it is a separate unit only, my lord,
No,
because.
it can't be. The sewage treatment plant services only the apartment, nobody else.
Yes,
So then how can you consider it to be an independent unit? If they don't put up an STP, you will not grant them license.
Yes.
If they form an STP, you want,
Initially, when they are taking the services, my lord, they will take it in LT2 only, my lord. Subsequently, they have to take it in LT5 only for a STP, my lord, as per the tariff.
No, that is if the STP is separate, independent of an STP which services the entire locality is one thing.
Yes.
But an STP which is internal to the residents only, how can you equate this the same?
My lord, it is the number of people are staying, my lord, it is considered as a LT5 only, my lord.
STP is a requirement because of a building bylaw.
My lord, in LT2, my lord, LT2A, my lord, there is no specification stated that. In LT2, it is stated if the premises are using in the ground floor for a commercial and the upper floors are a residential, it will be considered as domestic only, my lord. But however, my lord, STP will be even in the big apartment in the separate premises, my lord, it will be considered as a commercial only, my lord, LT5 only. The
My-
tariff says like that only, my lord. As per the
Show
tariff.
me the tariff. That is a major demand, that STP is the
Yes,
major
my
demand.
lord. There are two demands, my lord. One is related to the,
Clubhouse.
clubhouse, my lord, where there is Apollo pharmacy is there, provision store is there, and the restaurant is there, you know. For that, one building is done, my lord. For the STP, another building is done. Two demands are there.
But that pharmacy and the restaurant
Yes, my lord.
is restricted only to the use of the members of the apartment complex?
Yes.
Or is it open to,
STP is for the members of the apartment only, my lord.
then the clubhouse is also only for the members of the apartment, isn't it?
Yes, my lord, but it is in a different premises, my lord, in the same apartment, in the different building, my lord. I'll show the photographs also there
Which is a tariff?
for STP, my lord.
LT5,
LT5, my lord. Page number 292, my lord. Last page. Drainage water treatment plants, my lord, independently.
Kindly see this, effluent treatment plants and drainage water treatment plants
Yes, my lord.
independently service outside the premises of the installation for which the power supply is availed.
Yes,
This is a large complex.
yes, my lord. It is.
This is a part of that complex itself. It's not independent.
Sir, my lord, outside premises, my lord, the outside the building, my lord. that is.
No, premises in the sense of an apartment complex would indicate if it's outside the apartment complex completely. In some other property, you're right.
No,
You are just harassing them.
no, my lord, not harassing, my lord. The STP will be comes under the LT5.
It is
only.
independent.
Outside premises, my lord, the
No.
which will be not,
That STP is not restricted to the only to the members in that case. STP is used by the entire area.
this STP is for the only for the apartment.
ಇದು ಇನ್ನೊಂದು ಯಾವುದು?
LT2, my lord. LT2, they are using the restaurant and the pharmacy and
Which is that,
provision stores.
which is that demand? But that is only a portion of the entire clubhouse, isn't it?
No, my lord, separate building only.
No, correct. But that is a portion of the clubhouse. The clubhouse does not run entirely on those three.
The works runs, every is three only. my lord. The major portion of the clubhouse is, my lord, the cafeteria, there is the restaurant, I have given the photo also. my lord. This is the separate building, my lord, they runs the restaurant there, my lord, the restaurant is using, my lord, all the club members and the guests who comes from the houses, they are also using, my lord. They are receiving the.
Madam, my understanding is the clubhouse is formed out of the monies of the members of the apartment complex. It's a common service that they provide for themselves. It's not a commercial transaction.
My lord, even my lord in the clubhouse, they will do the functions and all the receipts will be.
That is of the
commercial.
members.
Yes. The only that premises will be considered as a, my lord, as per the tariff, my lord.
How can you bifurcate the restaurant, the function hall separately?
My lord, they themselves has produced, my lord, the tariff, 2016 tariff is not applicable. Even my lord, 190 and my lord, page. One 192, my lord.
One is 21 lakhs, the other is, this 18 lakhs is for the STP.
Clubhouse, my lord, 25 lakhs is for the STP.
25 lakhs is for the AC.
I will state this 25 lakhs and ask them to deposit 50% of 18 lakhs. 18 lakhs, 50% you deposit. There should be an interim stay of annexures B and C. Of annexure B, subject to the petitioner depositing a sum of rupees 50% of the demand of rupees 25,08,400.
STP, that is the
Next year, fee is the STP.
Other 50% I'm asking you to deposit.
Next year, C my lord is the clubhouse.
Annexure, shall stay of annexure B. This will stay of annexure C subject to the petitioner depositing a sum of rupees 9.5 lakhs. On the complete stay in on the 9.5 lakhs. I think you're wrong. You can't, affluent plant, I don't think.
For orders, number 5, if you notice, order.
Naglilva? Nagli. Yes. Where's the complaint?
There happens to be land owner of Proceedings number 16 Usually about 2 years. Sharing ratio is 57% to developer, 43% is land. And there is confusion with regard to the fact that whether the deposit of refundable or non-refundable. But it is pretended that you're supposed to do so, as it is, you are going to pay back.
Your allegation is they forge your signature on the bond? Investigation ಆಗಿದೆಯಾ? Yes.
Genesis of the complaint is this law, development agreement law, it is key potential. What is the key effect of the annexure? Annexure is. But here, the creating our public construction, signed by way of managing partner.
No, the first allegation is you have sold 100 flats without giving them their share of 43% flats. The second portion is that you have forged a signature in the indemnity bonds that you had lodged with the bank. This is the allegation.
Allegation that you have sold that. But this is at home not retained in the piece of partner.
No, if your intent was to get into the agreement and thereafter cheat him by not conveying any property to him, and on the other hand, conveying the entire apartments to somebody else, that is a clear case of cheating.
They only say 20% excess is what you are not in 20%.
No, that is not the complaint. The complaint is clear. Praveen Kumar avaro Anna, no, page 20. Special GPA ಮುಖಾಂತರ ಆತ ಫ್ಲಾಟ್ ಗಳನ್ನು ಮಾರಾಟ ಮಾಡಿರ್ತಾನೆ. ಈ ರೀತಿಯಾಗಿ ಒಟ್ಟು 100 ಫ್ಲಾಟ್ಗಳನ್ನು ಮಾರಾಟ ಮಾಡಿದ್ದಾರೆ. ಆದರೆ ನಮಗೆ ಸೇರಬೇಕಾದ ಶೇಕಡ 43% ಸೂಪರ್ ಬಿಲ್ಟ್ ಅಪ್ ಏರಿಯಾ ಒಪ್ಪರಣೆಗೆ ಸರಿಯಾಗಿ ಸೇರಿದೆ. ಯಾವುದೋ ಫ್ಲಾಟ್ಗಳು ನಮಗೆ ಹಂಚಿಕೆ ಮಾಡದೆ.
You are not going to see that in the context of what is our page 19, page 19.
That is reiteration of the contents of the
Not just your question, yes, set it. ನಮ್ಮ ಜಮೀನು ಅಭಿವೃದ್ಧಿ ಮಾಡಿ ಅಪಾರ್ಟ್ಮೆಂಟ್ ನಿರ್ಮಾಣ ಮಾಡಿದ್ದೇವೆ ಅಂತ ಹೇಳಿದ್ರು. ಅದನ್ನ ಮಾತನಾಡಿ ನಮ್ಮ ಜಮೀನನ್ನು ಬಿಟ್ಟು ಅದನ್ನು ನಾವು ಅಪಾರ್ಟ್ಮೆಂಟ್ ನಿರ್ಮಾಣ ಮಾಡಲು ಪ್ರಾರಂಭಿಸಿದ್ದು ಈ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿಕೊಂಡು ದಿನಾಂಕ 23/7/2010 ಯೋಜನೆ ಮಾಡಿದ್ದೀವಿ. ಯೋಜನೆ ಪ್ರಕಾರ 8 ಮಹಡಿಗಳ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಮಾಡಿ ಅದರಲ್ಲಿ ಶೇಕಡ 43% ಸೂಪರ್ ಬಿಲ್ಟ್ ಅಪ್ ಏರಿಯಾ ಕೊಡುವುದಾಗಿ, ಇದರಲ್ಲಿ 20,000 ಗಿಡಗಳಾಗಿ ವಾಣಿಜ್ಯ ಬೆಳೆಗೆ ಮಾಡಿಕೊಡುವುದಾಗಿ, ಜಾಯಿಂಟ್ ವೆಂಚರ್ 2 ಕೋಟಿ ಹಣವನ್ನು ಕೊಡುವುದಾಗಿ ಮಾಡಿಕೊಂಡಿದೆ. ನಂತರ ಈ ಬಗ್ಗೆ ದಿನಾಂಕ 3/2/2010 ಜಾಯಿಂಟ್ ವೆಂಚರ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿಕೊಂಡಿದೆ. ಸಮಿತಿ ಜಾಯಿಂಟ್ ವೆಂಚರ್ ಅಗ್ರಿಮೆಂಟ್ ಅನ್ನು ಮುಂದಾಗಿ ತೋರಿಸುವುದು ಏರಿಯಾ ದಿನಾಂಕ 3/2/2010 ಪ್ರಕಾರ ನೋಂದಣಿ ಮಾಡಿದೆ. ಅದಕ್ಕೆ ಜಾಯಿಂಟ್ ವೆಂಚರ್ ಅಗ್ರಿಮೆಂಟ್ ನಲ್ಲಿ ನಾನು ನನ್ನ ಅಣ್ಣ, ನನ್ನ ತಮ್ಮ, ನನ್ನ ತಂಗಿ ಸಹಿ ಮಾಡಿದೆ. ಸದರಿ ಅಗ್ರಿಮೆಂಟ್ ಅನ್ನು ಪ್ರವೀಣ್ ಕುಮಾರ್ ಅವರೇ ಸಹಿ ಮಾಡುವುದು ಅಗ್ರಿಮೆಂಟ್ ಆಗಿರುತ್ತದೆ. ಪ್ರವೀಣ್ ಕುಮಾರ್ is not the active service, not petition withdrawal. ಪ್ರವೀಣ್ ಕುಮಾರ್ is active number 1. ಅಗ್ರಿಮೆಂಟ್ ಮತ್ತು ಯೋಜನೆ ಪ್ರಕಾರ ದಿನಾಂಕ 13/2016 ಅವರಿಗೆ ಕೆಲಸ ಮುಗಿಸಿ ಫ್ರಮ್ ಇಯರ್ ಅಲಿಗೇಷನ್ ಸರ್ ದಿನಾಂಕ 17/10/2016 ದಿನಾಂಕದಿಂದ ಅನ್ವಯವಾಗಿದೆ. ಅವರಿಗೆ ಕೆಲಸ ಮುಗಿಸಿ ಫ್ಲಾಟ್ ಕೊಡುವಂತೆ ನಿಬಂಧನೆ ಆಗಿದೆ. ಅದರಂತೆ ಈ ಪ್ರವೀಣ್ ಕುಮಾರ್ ಅವರು ಕೆಲಸ ಪ್ರಾರಂಭ ಮಾಡಿದ್ದು ಅಗ್ರಿಮೆಂಟ್ ಪ್ರಕಾರ ಆತ ನಮಗೆ 2 ಕೋಟಿ ಹಣವನ್ನು ನೀಡಿರುವುದು. ಕೆಲಸ ಪ್ರಾರಂಭ ಮಾಡಿದ ನಂತರ ಮುಂಗಡವಾಗಿ ನಮಗೆ ದಿನಾಂಕಗಳಂದು 1 ಕೋಟಿ 40,00,000 ಹಣವನ್ನು ಮಾತ್ರ ನೀಡುತ್ತಾರೆ. ಕೆಲಸ ಆದ ನಂತರ ಕರಾರಿನ ಪ್ರಕಾರ ಶೇಕಡ 33% ಸೂಪರ್ ಬಿಲ್ಟ್ ಅಪ್ ಏರಿಯಾ ಕೊಡದೆ ಈ ಪ್ರವೀಣ್ ಕುಮಾರ್ ಅವರು ಅಪಾರ್ಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಫ್ಲಾಟ್ಗಳನ್ನು ಮಾರಾಟ ಮಾಡುತ್ತಿದ್ದರು. ಕರಾರಿನ ಪ್ರಕಾರ ಫ್ಲಾಟ್ಗಳು ಬಿಲ್ಡರ್ಗೆ ಮತ್ತು ಜಾಗದ ಮಾಲೀಕರಾದ ನಮಗೆ ಇರುತ್ತೆ ಹಂಚಿಕೆ ಮಾಡುವ ಮೊದಲೇ ನಮಗೆ ತಿಳಿಸಿದಂತೆ ಫ್ಲಾಟ್ಗಳನ್ನು ಮಾರಾಟ ಮಾಡುತ್ತಾನೆ. ಪ್ರವೀಣ್ ಕುಮಾರ್ ಅವರು ಅವರ ಅಣ್ಣ ಶ್ರೀನಿವಾಸ್ ಗೋಕಾಪಟ್ಟಿ ಮತ್ತು ಶ್ರೀನಿವಾಸ್ ಅವರು ಸ್ಪೆಷಲ್ ಸಿಪಿಎ ಮುಖಾಂತರ ಫ್ಲಾಟ್ಗಳನ್ನು ಮಾರಾಟ ಮಾಡುತ್ತಾರೆ. ಈ ರೀತಿಯಾಗಿ ಒಟ್ಟು 100 ಫ್ಲಾಟ್ಗಳನ್ನು ಮಾರಾಟ ಮಾಡುತ್ತಾರೆ. ಆದರೆ ನಮಗೆ ಸೇರಬೇಕಾದ 43% ಸೂಪರ್ ಬಿಲ್ಟ್ ಅಪ್ ಏರಿಯಾಗೆ ಸರಿಯಾದ ಯಾವುದೇ ಫ್ಲಾಟ್ಗಳನ್ನು ನಮಗೆ ಹಂಚಿಕೆ ಮಾಡಿ ಮಾರಾಟ ಮಾಡುತ್ತಾರೆ. ಆದರೆ ಇನ್ನು 60 ಫ್ಲಾಟ್ಗಳ ಕೆಲಸವನ್ನು ಸರಿಯಾಗಿ ಪೂರ್ಣಗೊಳಿಸದೆ ಪದವಿ ಫ್ಲಾಟ್ಗಳು ವಿಂಡೋ ಮೆಶ್ ಫ್ಲಾಟ್ ಹಾಗೂ 4 ಕೆಲಸ ಮಾಡಲು ಕಂಡುಬಂದಿದೆ. ಉಳಿದ ಫ್ಲಾಟ್ಗಳನ್ನು ಸಂಪೂರ್ಣವಾಗಿ ರೆಡಿ ಮಾಡಿ ಮಾರಾಟ ಮಾಡುವುದು ಕಂಡುಬಂದಿದೆ. ಈ ಬಗ್ಗೆ ನಾವು ಕೂಲಂಕುಷವಾಗಿ ವಿಚಾರ ಮಾಡಿದಾಗ ಈ ಪ್ರವೀಣ್ ಕುಮಾರ್ ಅವರ ಶ್ರೀನಿವಾಸ್ ಅವರ ಜೊತೆ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದ ಶ್ರೀನಿವಾಸ್ ಅವರು ದಲ್ಲಾಳಿಗಳಾದ ಈ ಶ್ರೀನಿವಾಸ್ ಮತ್ತು ಕೇಶವ್ ಅವರು ನಮಗೆ ಮೋಸ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಒಳಸಂಚರಿಸಿ ನಮಗೆ ಬರಬೇಕಾದ ಅನುಪಾತದ ಪ್ರಕಾರ ನೋಡಿದಲ್ಲಿ ನಮ್ಮ ಪಾಪು ಇರುವ ಬಿಲ್ಟ್ ಏರಿಯಾದಲ್ಲಿ 20,000 ಅಡಿಗಳನ್ನು ಸಹ ಮೋಸದಿಂದ ಮಾರಾಟ ಮಾಡಿ ಅವರ ಹಣವನ್ನು ಸಹ ಲಕ್ಷಾಯಿಸುತ್ತಾರೆ.
Without selling, without conveying any flat to them, you have sold all the flats that were constructed. That is the allegation which requires investigation. And the second part is the most dangerous part, which says that you forged an indemnity bond. No, let them investigate. Yes.
Also, there is perhaps not even an iota of that a single actual election duration is equal to the court of a civil as well as human being. Each of these will be pursued regardless of their degree and if the actual question is not whether a human case is pursued in the presence of.
Is there a civil suit pending?
They are fighting
By whom?
landowners.
No, is the complainant person who's instituted a suit? You instituted a suit?
We are not instituted, we are going to arbitration, because JV consists of arbitration. That is in CMB 15 of 2017.
All right. Yes, good.
And that we are not disclosed yet.
Yes. This was not a case relating to a forgery of an indemnity bond. That allegation will hold you. Even if I accept this judgment, the first part of the complaint is right. They may have to go, anyway they have gone to the arbitration, that will be resolved. But insofar as second part of forging an indemnity bond, in order to secure a loan from the bank, that ಇನ್ನೇನು ನಾನು ಇಂಡೆಮ್ನಿಟಿ ಬಾಂಡ್ ಸೈನ್ ಮಾಡಿಲ್ಲ, ನಮ್ಮ ಸಿಗ್ನೇಚರ್ ಫೋರ್ಜ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಅದಕ್ಕಿಂತ ಇನ್ನೇನ್ ಬೇಕು? ಸಾಕಲ್ವಾ? What else do you want? Who submitted the loan application? You submitted the loan application. Then who are you? How are you related to accused number 1? They will investigate, Sharath, then they'll find out whether you did it or somebody else did it. They'll file a B report against you. They'll give you off from the charge sheet. I'll consider that. I have already decided. I gave you an opportunity so that you will settle and save yourself from a criminal prosecution. You don't want to do it, you will suffer the consequence. Settlement should be anything else? Shadana? The complaint was lodged.
And they themselves say, that 2014 the construction after being completed and another. The complaint is lodged in 2018. There is delay of nearly 5 years. Because for the court is paid to initiate where cognizance is airport, there is a bar. For an offense of 3 years, that is breach of offense, it is 3 years. Even so when there is a delay in lodging the complaint, it is usually an officer and another official. It was Supreme Court has taken again in that.
The complaint was lodged contending two complaining that an MOU had been entered into on 3/2/2010 under which 43% of the built-up area should be conveyed to the landowners, that is the complainant, and the builder was entitled to the remaining 57%. But the builder had conveyed all the flats that he had constructed without discharging his obligation of conveying 43% of built-up area to the landowners. In the complaint, it was also stated that the builder, in order to secure loans from the banks, had forged the signatures of the landowners in the indemnity bonds that had been submitted to the banks, on the basis of which loans had been raised. Next slide. On the basis of this complaint, a crime was registered for offence under section 406, 471, 420, 465, 468, read with section 134 of the IPC. Next part. Being aggrieved of this registration of crime, the present petition has been filed. Shri Sharath Gowda, learned counsel appearing for the petitioner, contends that the entire set of allegations in the complaint are directed against A1. Who is he? Praveen Kumar, who is the managing partner of the builder, and the petitioner is only a partner, and therefore the allegation against him was without any basis. Secondly, he submits that the complainant has also initiated arbitration proceedings to enforce the terms of the MOU and therefore initiation of a criminal prosecution was unwarranted and is therefore vitiated. Thirdly, he submits that the allegation regarding forgery of the signatures of the landowners in the indemnity bond are extremely vague, and they are made only to enforce the terms of the contract. Learned counsel places reliance on the judgment of the Supreme Court rendered in Criminal Appeal number 1285 of 2021. Sorry, reported in AR online 2021, Supreme Court 936. Learned counsel for the complaint on the other hand submitted that there are specific allegations that though the MOU indicated a certain percentage of the built-up area to be handed over, the developer of which the petitioner was one of the partners had cheated the landowners by conveying all the flats and not offering any flats that they had constructed to the builders. And this clearly indicated there was an intent to cheat from the very beginning of the execution of the MOU. He submits that the second part of the complaint, that the indemnity bonds were forged, is by itself a serious offense which requires to be investigated and should not be impeded by entertaining this petition. Next paragraph. As could be seen from the complaint governments, the allegations against the developer of which the petitioner is a partner is that there was an MOU under which a certain specified percentage of the built-up area was to be conveyed. But notwithstanding the MOU, the entire built-up area had been conveyed. And this indicated that the intent of the builder was to cheat the landowners from the very beginning. The reading of the complaint insofar as relates to forgery also would indicate that the builder, in order to secure a loan from the banks, had forged the signatures of the landowners in the indemnity bond, thereby trying to create a financial obligation on the part of the owners, even though there was none. In my view, these allegations are serious and are required to be investigated. And this is not a fit case to entertain under section 482 and impede the investigation. The petition is therefore dismissed. Now, the reliance placed on the judgment of the Supreme Court would be of no avail, since this was not a case of mere non-performance of the terms of the MOU, but one of complete cheating, in as much as the allegation in the complaint is that not a single flat had been conveyed. Whereas in the case of the Supreme Court, the only dispute was regarding the extent of flats that would be conveyed.
See number 6, is done.
He was here, isn't it? This apartment complex. There's a stay. What is the complaints? There's no date. The demand has been stayed. That is all. 2 weeks. To them only, who else?
See number 6, Dhananjay Kumar.
Yes. What is it they're challenging? Reinvestigation. In B report hakidara. Where is the complaint? You were assaulted by this Santosh, Vinod, Yatish, Sharat, Rakesh.
Thereafter, we had that.
Who's a police officer?
Number two, one word is
Santosh is the inspector.
Not the inspector, he is a constable.
constable and the CCB.
Then
I made a complaint at page number 80. So I have noted that they not. I made a complaint to the commissioner.
They only
Member of the error page, annexure D.
what is the reason, madam, that he has given up from the charge sheet? Did he have an alibi? What exactly was, he made a specific allegation that so and so assaulted me. For you to exonerate him by not charging him, what is the reason? On very constable antana illa? No. When a complainant makes an allegation, X assaulted me, for you not to charge him, there must be some material, isn't it? That he was not in town on that day, whatever, so that I'm not charging him. What is the reason for not charging him? ಏನಿಲ್ವಾ? ಅಲ್ಲ ಯಾವ ಆಧಾರದ ಮೇಲೆ ಹೇಳ್ತಾರೆ ಮನ್ಸಲ್? On what basis does the IO say that he did not have a role to play? There was a statement of the complainant, isn't it? You should say that the complainant is lying for this reason, therefore I investigate. What is it that he has done? If a constable decides to assault on a civilian, there must be a consequence, isn't it? If a civilian assaults a constable, even if he is in a cricket team, would you keep quiet? ಅವ್ರ ಮೇಲೆ ಏನ್ ಹೇಳಿಲ್ವಲ್ಲ ನೀವು stab injuries. In the complaint, you have not said Santosh stabbed you. Second complaint, but first complaint alli, did you state that? What is there, madam? What is the statement on the basis of which he was given up? Complaint ಇದೆ. Investigation ಅವ್ರು ಕೈ ಬಿಡೋದಕ್ಕೆ what is the reason? ಅಲ್ಲ ಏನ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್? ಅವ್ರ ನೀವು ಇಷ್ಟ ಬಂದ್ರೆ ಮಾತ್ರ ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡ್ತೀರಾ? If I were to make a specific allegation against a particular person, should you not say why he should not be charged? Against that pity must. Accused number one constable ಅಂತ ಹೇಳಿದ್ರೆ A1 ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಂಡಿದಾರಾ? ಇವನ್ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಂಡಿಲ್ವಾ ಕಾನ್ಸ್ಟೇಬಲ್ ಮೇಲೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್? Show me from the investigation, also get the IO before the court and let him explain as to why he was given up. A constable does not have any immunity, isn't it, from crime? In excess of his authority agidre 170 ಬರೋದು. Nothing to do with his duties. If you have no argument, I'll allow the writ petition and ask him to be included in the charge sheet. Get the investigating officer and ask him to explain as to why he has not been charge sheeted. I will hold that the investigation is motivated. ನಿಮ್ ಡ್ಯೂಟಿನೇ ಮಾಡಿ ಆಮೇಲೆ ಕೋರ್ಟ್ ಡ್ಯೂಟಿ ಆಮೇಲೆ ಅವ್ರು ಮಾಡ್ತಾರೆ 19th I have to be present.
Number 7.
ಅವರೆಲ್ಲ ಹೋಗ್ಬಿಟ್ಟು ಅವ್ರು ಇಂಪ್ಲೀಟ್ ಮಾಡೋಣ.
Ananjay Kumar.
ಆಮೇಲೆ ಹೇಳಿ. Yes.
Number 7. See number 8. Shri Manjunath KV.
Who's R3?
Whose complaint the electricity was affected?
Restore ಆಯ್ತಾ ನಿಮ್ದು?
Properties in the father's name, but in the type of partition that is there. But let the electricity be restored in the father's name and not.
ನೀವು ಯಾರಿಗೆ? Sir, complete service owner. Post after service of notice to R3.
See number 9. Shri.
ನೀವು ಯಾವತ್ತು ಮೂವ್ ಮಾಡ್ತೀರೋ ಅವತ್ತು. Who's R5 to R7? Who's R5 to R7? TMC, Konnappa Agra, Agrachappa. Bengaluru South Taluk. Complete service on R5 to R7. ನೀವು ಯಾರು ಮೇಡಮ್? Post after service of notice to R5 to R7. Service ಆಗೋರ್ಗು ನಾನು ಡೇಟ್ ಕೊಡು.
See number.
You know, she buy for responding to over.
5 to 7.
Municipal. TMC.
5 to 7, Town Municipal Council.
Yes.
See number 10. Shri Ravi Kumar. Sia.
Not to grant license. Why? What is your representation? How are you interested? How are you interested in this?
Are opening a liquor shop. In my premises, I'm just objecting that. That's all.
What is your objection?
They shall see my, I've done my representation before the. One number 2 and 3. Yes, but Deputy Commissioner of Excise and Excise Inspector.
ತುಂಬಾ ವೇಗ್ ಕಂಪ್ಲೇಂಟ್ ಇದು. ರಿನ್ಯೂವಲ್ ಆಗಿದೆಯಾ ಮೇಡಮ್ ಅದು? Pay the court fee and then let us see. Is the pages, other objections? I am not inclined to entertain your petition because there's nothing indicating that there's a violation of Rule 5. You are merely saying that it is apayakari. Yengi anta helata illa. Every bar is dangerous. You should state as to why it is objectionable. You should state that Rule 5 there's a violation. Nothing is forthcoming. 2 weeks to do the need.
For hearing is number 11, Shanti Bhushan.
You file the amended cost rate. Relist.
19. Number 12. Number Sinchana Emma. Number 12.
The application seeking for dispensation of the production of the original notice is allowed.
Number 13, Shri Jay Prakash Reddy.
Yes.
Criminal case, where the lodging by complaint is made by the deputy commissioner. The outcome will become what is the answer.
We present the office bearers of the Kupara Sangha. The accused of the S12 office bearers, the backward community welfare department granted 1 crore rupees when they are directors of the Sangha. And that 1 crore rupees which are related to their individual accounts. And now we are the office bearers getting difficulty to run the Sangha because there is a hostel. Students are studying there. We have to provide them to accommodation, food, shelter, everything. Therefore, that whatever the amount sanctioned by the government, which is misused, and that should be recovered by the accused. And the investigation report says that the Tapasana Vati, there is no any work.
Investigation stay agidya. On what ground? What is your ground of attack?
There is no objection against this bit starts.
Let us see the complaint.
You are not going to see the election 3 at place 17. The entire complaint does not result to the offense. The logic is only they have stated. Page 20. Sir, I 18 your lordship can see.
ನೀವು ಯಾರು ಕೆ ಮುನಿಸ್ವಾಮಿನಾ? ನಿಮ್ಮ ಹೆಸರು? You are the vice president. Then Ramesh. Ramesh ಇದರ ಇದೆ. Internal auditor. Ramesh ಆಂತರಿಕ ಲೆಕ್ಕ ಪರಿಶೋಧಕರು. ನಾಗೇಶ್.
Petition number 1 is
Saha
vice
Karyadarshi.
president. Petition number 2 internal auditor.
Nandini
Petition number 3
is
fourth secretary.
treasurer.
And petition number 4 president.
As well, the date of this incident, my lord, they are not the office bearers. 2017 it is, there is the allegation. Even your lordship, you say page 20 at para 18.
Paragraph 18 indicates P. Krishnappa, T. N. Rupa, Nandini, Nagesh, R. Muniraju, PPR Construction, Real Metals and Cinemas. ಅವರ ಹೆಸರಲ್ಲಿ ಹಣ ಸೆಳೆದಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. 1 crore ರೂಪಾಯಿ from the bank statement. Bank manager, Corporation Bank, RPC layout. ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಆಗ್ಲಿ ಬಿಡಿ, ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡೋದಕ್ಕೆ ಯಾಕೆ ಅಡ್ಡ ಬರ್ತೀರಾ? Yes.
ಈ ರಮಪಟ್ ಅದೇ ದೇಶಗಳು ದಿನಾಂಕ 25/20 ಹಣ ಬಳಕೆ ಪ್ರಮಾಣ ಪತ್ರ 175 ಬಗ್ಗೆ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಬೆಂಗಳೂರು ಜಿಲ್ಲೆಗಳ ನಿರ್ದೇಶಕರು ಸಮಸ್ಯೆಗಳು ಸಲ್ಲಿಸಿರುವ ಅಂದಾಜುಪಟ್ಟಿಯ ಅಂದಾಜುಪಟ್ಟಿಯಲ್ಲಿ ಕಾಮಗಾರಿಗೆ ಶುಲ್ಕ ಕಪಾಟಿ ವರದಿಯನ್ನು ಸಲ್ಲಿಸುವ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು ನಿವೃತ್ತ ಕೇಂದ್ರ ಬೆಂಗಳೂರು ಸೂಚಿಸಲಾಗಿದೆ. ಯೋಜನಾ ವ್ಯವಸ್ಥಾಪಕರು ನಿವೃತ್ತ ಕೇಂದ್ರ ಬೆಂಗಳೂರು ನಿರ್ದೇಶಕರು 22/3/21 ತಪಾಸಣೆ ನಡೆಸಿ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸದರಿ ವರದಿಯಲ್ಲಿ ಕಾಮಗಾರಿಗಳಲ್ಲಿ ಯಾವ ಸಾಧನ ಆಗಿದೆ ಎಂಬುದರ ಬಗ್ಗೆ ಮಾಹಿತಿ ಇರುವುದಿಲ್ಲ. ಕಾಮಗಾರಿ ಆಗಿದೆ, ನಾವು ಯಾವಾಗ ಮಾಡಿರೋದಂತೆ ಇಲ್ಲ. Building was constructed.
The amounts was released in 2019. 22-19. What is that issue that you are not the office bearer in 2019 when the money was released and remitted to your account? On what basis are you saying that they are not the office bearers? Yeah, what is the basis for you to say that? Illen helidira. What is it you have produced? Not a case for interference under 482. Investigate ಆಗ್ಲಿ ಬಿಡಿ, ಆಮೇಲೆ ಗೊತ್ತಾಗತ್ತಲ್ಲ. ಮಾಡ್ತಾರೆ ಬಿಡಿ, ಅವ್ರು ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡ್ತಾರೆ. The amounts have gone to the bank. If any amount of that 1 crore has gone to any of the office bearers, it requires investigation. We don't know, let them, you are not able to show prima facie that you were elected, because the allegation, the complaint is the members as well as the existing committee were both using the same letterhead. And there was a dispute as to who is the office bearer. Investigate ಮಾಡಲಿ, ನಿಮ್ಮ ಅಕೌಂಟ್ ಇದ್ರೆ ಅದರಲ್ಲಿ. Let it be investigated. No ground for staying the investigation. There must be some clarity as to you are not at all involved. It's a clear case of the amount going to the bank account of the Sangha. From there, as there may be withdrawal or not, they'll find out why. I don't know.
There should be an audit report for that. For audit comes since 18 to 19. So far, they have not obtained the audit report.
That is because the committee is not formed. There's some dispute amongst the members regarding the committee. ಅವಾಗಲೇ ನಿಜ ಬರೋದಲ್ಲ. ಮನೇಲಿ ಜಗಳ ಆಡಿದ್ರೆ ಗೊತ್ತಾಗತ್ತೆ ಯಾವ್ದು ಏನು ಗೊತ್ತಾಗತ್ತೆ. ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಆಗ್ಲಿ ಬಿಡಿ. Let them investigate, Mr. Sajid. ಈ ಕೇಸ್ ಬೇಡ. ಗೊತ್ತಿಲ್ಲ, ಗೊತ್ತಾಗತ್ತಲ್ಲ. ಅದೇ that they will investigate. If they find there's nothing going into your account, you're out. The allegation is that there were amounts gone to certain office bearers. So that requires some investigation. Bitbud ಈ ಕೇಸ್ ಅಲ್ಲಿ ಬಿಟ್ಬಿಟ್ರೆ ಇನ್ನೇನು? The complaint was lodged by the. Who was the complainant? Who was the complainant? District officer.
District officer of the backward community.
The district officer of the backward classes department, alleging that a sum of rupees 1 crore had been granted to the Kumbara Sangha, and this amount granted to the Sangha had been misappropriated into the personal accounts of the office bearers. On the basis of this complaint, a crime has been registered for offence under section 403, 460, 406, 417 and 420, section 34 of the IPC. Next, sir. Being agreed of the registration of this crime, the present petition is filed by the four petitioners contending that the registration of the case and arraigning them as an accused is without any basis. Then a senior counsel submits that the petitioners were not the office bearers at that point in time. And furthermore, the building has been constructed by incurring huge sums of money. And merely because a sum of rupees 1 crore was granted, it cannot be alleged that the amount meant for the construction was misappropriated. Next, in my view, in regard to the specific governments in the complaint, that the amount of rupees that this bank statement reveals crediting of the amount of rupees 1 crore to various personal accounts of the persons named in the complaint. This would not be an appropriate case to invoke section 482 and impede the investigations. And therefore, the view that there is no justification under the petition therefore dismissed. View the dismissal not necessary to consider.
Number 14, Shri Prasanna Beer.
I have filed an interim application to recall the order dated 1/7/2020. For the reason that it has been framed by fraudulent means. Petition number, respondent number
That
8.
Change of counsel.
This
This is an exchange of counsel.
petitioner and the respondent number 8 are political and filed a memo before this honorable court of which I have no knowledge at all. There was no compromise deed also. And GPA, it was not executed by me, therefore my.
You had engaged R8 with the counsel for, you had engaged D. Hanumantraya.
We are not engaged, my lord. We are not engaged. We are not given any instructions also to you. But they have filed a memo stating that its matter is being compromised and this honorable court was pleased to pass an order.
Where is your application? Where is your application for recalling? You do not dispute the fact that you engaged the counsel. Please read para 4. Your only contention is that you had not instructed him to file a memo.
Power of Wakalat Nama. I am not tendered any instructions.
My power of attorney.
Council represented me to file such a memo. Most of the signatures entrance in such memo. Prevailed to me has not been signed or executed by me.
If you are counsel, you do not dispute the fact that you had engaged a counsel.
We are engaged a council to file a caveat, my lord. I am not engaged a council to appear in this matter.
So there is a, now you engage a counsel to file a caveat, you engage a counsel to defend you subsequently. Where have you said so? And you have lodged any complaint to the bar council saying that I had not engaged the bar council?
And also to the police.
I am only asking, have you engaged? When?
2016.
Recently,
Yes.
not when you made the application. I will not look into that. You filed the application, you filed the complaint only because I asked you, have you filed any complaint?
May I make one submission? The Lord may also see the conduct. Criminal petition 9356 is filed. they, in the same petition, they attached the memo, they attached the compromise. Having not been, not able to succeed in getting a stay, they then filed this.
What is the criminal petition?
Criminal petition 9356 challenging the FIR, which the respondent number 7 was the accused.
Criminal petition was filed by whom?
By the respondent number 7,
Against?
challenging the FIR that was lodged by the Basargudi police station.
For what? On whose complaint was the FIR registered?
It's on one BA Rathama.
Because property belongs to the citizen, they paid fraud and they want to pay to the property. To that effect, I will compare. They, regarding that, they filed a forwarding petition. In that petition, this is all, order of Islam report and compromise has been preferred.
Reading also very clearly stating.
That petition itself, they have said that is filed in on 69/22.
They solely rely on this memo that is filed and the compromise for the state.
There is no compromise memo at all, deed at all, compromise deed at all by filing the memo.
And this was, there's another council engagement also in this criminal petition. So it's not a case that the same council has, without any instruction, filed this case.
R8 was the GPA holder of R6 and R7. What is the affair that you were talking about? Who was the complainant in that affair? Ratnamma. Against, the complaint was lodged against? Natraj, R7. And in the.
This para 19, they specifically said that
ಎಲ್ಲಿದೆ?
On page 12,
Yes, madam. I'll impose costs on your client.
The deed at least should have.
You were R7. You had filed this criminal petition 9356, in which you affirmed the joint memo that was filed by you. Then how can you ask for recalling on the ground that you did not sign the memo? You want to rely upon the joint memo to get over the FIR registered against you. And now you are coming and saying that the order that was passed on the basis of a joint memo was a forced memo? That is not what is stated in the application. 5 lakhs cost for making the application. You should have thought about this when he filed the application.
Because he could not come before the court also because.
If he comes before,
Proceedings when the FIR was filed.
if he comes before the court, it will become 10 lakhs. You cannot take the court for granted like this. On the last occasion when this topic came up, the earlier counsel said he'll take instructions. He advised them to withdraw the application. At that stage, there was a change of counsel. So now that you have come, you're inviting costs. No liberty. the learned counsel of the petitioner seeks liberty to withdraw the application that has been filed for recalling. Said submission is accepted and the application filed for recalling is dismissed. Recalling, consequently, the application for conveyance delay is also dismissed.
Number 15. Ramchandra Reddy.
What is the impleading that you are filing? What is the application for impleading?
So our partner, of course, we have in good order with partner. And we finally could take notice for our implementing application.
Shri so-and-so accepts notice on behalf of the proposed respondent. I'll allow the application for impleading.
Yes, madam.
Since the proposed applicant is a proper and necessary party, the application is allowed. What is the amendment that you sought for?
Consequential prayer was not made.
The application for amendment is allowed since by the proposed amendment, an order which ought to have been challenged, but was not challenged by the time of filing the writ petition, is now sought to be challenged. No prejudice as such is be caused to the respondent by allowing the accordingly IA 2 or 24 is allowed. Amended petition to be filed. Are you ready?
No, my lord, because my lord, with the order they challenged for 2014, 10 years
Yes.
back order. And here
Yes.
my lord, there is no action, they are doing.
19th.
19.
Next week I am not available. 19th.
Number 16.
Permit direct to, copy of the petition.
Okay.
Realist. Realist.
Number 16. Jyoti.
Memo is filed seeking for permission to withdraw the writ petition, criminal petition. As requested, criminal petition is dismissed as withdrawn.
Your Lordship, for petitioners, my lord, it is with liberty, my lord, memo for withdrawal.
Liberty for what?
Liberty, yesterday, your Lordship had expressed that if ever charge sheet is filed, to challenge the charge sheet, my lord.
Liberty is above reserved to the petitioner to file a fresh petition in the event a charge sheet is filed against the petitioner.
Grateful, your Lordship.
Number 17. Shri. Gurata.
Yes. Where is he?
B.S. Prasad.
In madam. The petitioner, counsel for the petitioner seeks permission to withdraw the petition since the proceeding to the trial court is at the stage of cross-examination of the witnesses. His request is granted, petition is dismissed as withdrawn.
Number 18. Shri Rajesh Kumar.
Fire, we find a charge sheet that is filed. The complaint is by the police. What they do, they come to my office. I'm the director of a security company. They come to my office. For their case, as per the complaint that in page 22 and 8, is that they have induced me by using a record to sell what they call a spyware software. And then they seize.
Where is the complaint? Where is the complaint?
In page 22, my lord. Fire 30 and 2013. I wrote, may I request my name to be.
all post state COVID liability under Section Information Technology Act, the report Indian Telegraph Act against ಕಾನೂನು ದಿನಾಂಕ 29/10/2013 ಮಧ್ಯಾಹ್ನದ ವೇಳೆಯಲ್ಲಿ ಸಿಸಿಬಿಯ ಮಹಿಳಾ ಮತ್ತು ಮಾದಕ ದ್ರವ್ಯ ದಳದ ಸಹಾಯಕ ಪೊಲೀಸ್ ಆಯುಕ್ತರಾದ ಶ್ರೀ ಎನ್.ಸಿ. ನಾಗರಾಜ್ ಅವರಿಗೆ ಬಾಕಿದಾರರು ನೀಡಿದ ಮಾಹಿತಿ ಏನೆಂದರೆ ಪ್ರಿಮ್ರೋಸ್ ರಸ್ತೆಯಲ್ಲಿರುವ ಸಿಂಕ್ ಸೆಕ್ಯೂರಿಟಿ ಅಂಡ್ ಡಿಟೆಕ್ಟಿವ್ ಸರ್ವಿಸಸ್ನ ನಿಖಿಲ್ ಕೆ ಎಂಬುವವರು ಹಣವನ್ನು ಅಕ್ರಮ ಸಂಭಾವನೆ ಆಗಿ ಪಡೆದು ಕಾನೂನು ಬಾಹಿರವಾಗಿ ಮೊಬೈಲ್ ಫೋನ್ಗೆ ಯಾವುದೋ ಒಂದು ಸಾಫ್ಟ್ವೇರ್ ಹಾಕಿ ಸದರಿ ಮೊಬೈಲ್ ಫೋನ್ನಿಂದ ಮಾಡುವ ಕರೆಗಳು, ಕಳುಹಿಸುವ ಇಮೇಲ್ ಸಂದೇಶಗಳು, ವಾಟ್ಸ್ಆಪ್ ಸಂದೇಶಗಳು, ಕರೆಗಳಲ್ಲಿ ಮಾತನಾಡುವ ಸಂಭಾಷಣೆ, ಕಾಂಟ್ಯಾಕ್ಟ್ ಟೆಕ್ಸ್ಟ್ ಸಂದೇಶಗಳು, ಮೊಬೈಲ್ನ ಸ್ಥಳ ನಿಶ್ಚಯ ಮತ್ತು ಮೊಬೈಲ್ ಆನ್ ಆಗಿರುವ ಪಕ್ಕದಲ್ಲಿ ಆಗಿರುವ ಎಲ್ಲಾ ಶಬ್ದಗಳು, ಸಂಭಾಷಣೆಗಳು ಮತ್ತು ಮೊಬೈಲ್ ಮೂಲಕ ಆಗಿರುವ ಎಲ್ಲಾ ಚಟುವಟಿಕೆಗಳನ್ನು ಪಡಸಾಲಿಕೆ ಮಾಡಲು ಹಣ ಕೊಟ್ಟಿರುವವರಿಗೆ ಅನುವು ಮಾಡಿ ಕೊಡುತ್ತಿದ್ದಾರೆ ಎಂಬುದಾಗಿದೆ. ಆ ಮಾಹಿತಿಯನ್ನು ಅನುಸರಿಸಿ ಎಸಿಪಿ ಸಿ ನಾಗರಾಜ್ ಅವರಿಗೆ ದಿನಾಂಕ 29/13 ನನ್ನೊಂದಿಗೆ ಒಬ್ಬ ಪಿಕಾಯನ್ನು ಸಿದ್ಧಪಡಿಸಿ ಅವರಿಗೂ ಸಹ ಮಾಹಿತಿಯನ್ನು ತಿಳಿಸಿ ಸದರಿ ಮೊಬೈಲ್ ಕದ್ದಾಲಿಕೆಯ ಸಾಫ್ಟ್ವೇರ್ ಖರೀದಿಸಲು 65,000 rupees ಹಣ ಕೊಟ್ಟು ಕಳುಹಿಸಿಕೊಟ್ಟಿದ್ದರು. ಅದರಂತೆ ನಾನು ಮತ್ತು ಪಿಕಾಯಗಳು ಸದರಿ ವಿಂಡೋ ರಸ್ತೆಯಲ್ಲಿ 15/9 ಸಿಂಕ್ ಸೆಕ್ಯೂರಿಟಿ ಅಂಡ್ ಡಿಟೆಕ್ಟಿವ್ ಸರ್ವಿಸಸ್ ನಿಖಿಲ್ ಕೆ ಎಂಬುವರನ್ನು ಭೇಟಿ ಮಾಡಿ ಅವನಿಗೆ ಹಣ ಕೊಟ್ಟು ಸಾಫ್ಟ್ವೇರ್ ಅನ್ನು ನಾವು ನೀಡಿದ ಸ್ಮಾರ್ಟ್ ಫೋನ್ಗೆ ಅಳವಡಿಸಿಕೊಂಡು ಮಾಹಿತಿ ಖಚಿತಪಡಿಸಿದ ನಂತರ ದಿನಾಂಕ 30/9/13 ಎಸಿಪಿ ರವರು ಮೇಲಾಧಿಕಾರಿಗಳಿಗೆ ಮಾಹಿತಿ ಖಚಿತವಾಗಿರುವ ಬಗ್ಗೆ ತಿಳಿಸಿ ಅವರ ಅಪ್ಪಣೆ ಪಡೆದು ಸಿಐಡಿ ಘಟಕದ ತಾಂತ್ರಿಕ ಸಿಬ್ಬಂದಿಯವರಾದ ಕಿರಣ್ ಕುಮಾರ್ ಸಿ, ಶಿವಕುಮಾರ್ ಎಸ್ಕೆ ಸಿಪಿಸಿ ಹಾಗೂ ಸಿಸಿಬಿಯ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಎಂ.ಎಚ್. ಸತೀಶ್ ಹಾಗೂ ಸಿಬ್ಬಂದಿಯವರಾದ ಎಸ್ಸಿ 4898 ಪಿಸಿ 8499 ಪಿಸಿ 10,076 ಹಾಗೂ ಶಿಕಾರಿಯಾಗಿ ಬಂದಿರುವ ವ್ಯಕ್ತಿಯ ಜೊತೆ ಪಂಚಾಯತ್ ಸಮಕ್ಷಮ ಕಚೇರಿಯ ಮೇಲೆ ಮಧ್ಯಾಹ್ನ 2 ಗಂಟೆಗೆ ದಾಳಿ ನಡೆಸಿ ಕಚೇರಿಯಿಂದ ನಿಖಿಲ್ ಗೆ ತಂದೆ ದೇವೇಂದ್ರ ಕುಮಾರ್ 31 ವರ್ಷ, ಬೆಂಗಳೂರು ಎಂಬುವರನ್ನು ವಿಚಾರಣೆ ಮಾಡಿ ಆತನ ವಶದಿಂದ ಕೃತ್ಯಕ್ಕೆ ಬಳಸಲಾದ 2 ಮೊಬೈಲ್ ಹಾರ್ಡ್ ಡಿಸ್ಕ್ಗಳನ್ನು, ಆತನ ಕಚೇರಿಯಲ್ಲಿ ದೊರೆತ ಕೆಲವು ದಾಖಲಾತಿಗಳನ್ನು ಅಕ್ರಮವಾಗಿ ಸದರಿ ಕೃತ್ಯದಿಂದ ಮತ್ತು ಅಕ್ರಮವಾಗಿ ಡಿಡಿಆರ್ ಪಡೆದು ಸಂಪಾದನೆ ಮಾಡಿದ ನಗದು ಹಣ ಇವುಗಳನ್ನು ಮಹಾಜನ್ ಮೂಲಕ ಅಮಾನತುಗೊಳಿಸುತ್ತಿದೆ. ಆರೋಪಿಯನ್ನು ವಿಚಾರಣೆ ಮಾಡಲಾಗಿ ಆತನ ದಿನಾಂಕ 29/13 ಸಿಪಾಯಿ ಅವರಿಂದ 65,000 ರೂಪಾಯಿ ಹಣ ಪಡೆದು ಅವರು ನೀಡಿದ ಸ್ಮಾರ್ಟ್ ಫೋನ್ಗೆ ಕದ್ದಾಲಿಕೆಯ ಸಾಫ್ಟ್ವೇರ್ ಹಾಕಲು ಹುಲಿಯಲ್ಲಿರುವ ತನಗೆ ಪರಿಚಯವಿರುವ ವೀರೇಂದ್ರ ರಾವತ್ ಎಂಬುವನಿಗೆ ಸಿಪಾಯಿ ಅವರು ನೀಡಿದ ಸ್ಮಾರ್ಟ್ ಫೋನ್ನ IMEI ನಂಬರ್ ಅನ್ನು ನನ್ನ ಮೊಬೈಲ್ ನಂಬರ್ ತೋರಿಸುವುದರಿಂದ ವೀರೇಂದ್ರ ರಾವತ್ ಮೊಬೈಲ್ ನಂಬರ್ ತೋರಿಸು ಮೆಸೇಜ್ ಮಾಡಿದರು. ಈ ವೀರೇಂದ್ರ ರಾವತ್ ಮರಳಿ ನನ್ನ ಮೊಬೈಲ್ ನಂಬರಿಗೆ ಒಂದು ಲಿಂಕ್ ಅನ್ನು ಮೆಸೇಜ್ ಮಾಡಿ ನನಗೆ ಕರೆ ಮಾಡಿ ಲಿಂಕ್ ಅನ್ನು ಬಳಸಿ ಕದ್ದಾಲಿಕೆಯ ಸಾಫ್ಟ್ವೇರ್ ಅನ್ನು ಅಳವಡಿಸಲು ನನಗೆ ಕರೆ ಮಾಡಿ ಲಿಂಕ್ ಅನ್ನು ಬಳಸಿ ಕದ್ದಾಲಿಕೆಯ ಸಾಫ್ಟ್ವೇರ್ ಅನ್ನು ಸೂಚನೆಗಳನ್ನು ನೀಡಿದೆನು. ಅದರಂತೆಯೇ ನಾನು ಸಿಪಾಯಿ ಅವರಿಂದ ಪಡೆದ ಸ್ಮಾರ್ಟ್ ಫೋನ್ಗೆ ಲಿಂಕ್ ಮೂಲಕ ಕದ್ದಾಲಿಕೆಯ ಸಾಫ್ಟ್ವೇರ್ ಅನ್ನು ಅಳವಡಿಸಿದ್ದೇನೆ. ಸಂಜೆ ಸಿಪಾಯಿ ಅವರು ನನ್ನಿಂದ ಸ್ಮಾರ್ಟ್ ಫೋನ್ ಅನ್ನು ಪಡೆದುಕೊಂಡು ಹೋಗುವಾಗಿ ನಾನು ಅವರಿಂದ ಒಂದು ಪೇಪರ್ ನಲ್ಲಿ URL ಅಡ್ರೆಸ್ ಮತ್ತು ಯೂಸರ್ ನೇಮ್.
Yes, what is wrong?
First of all, please complaint is investigation is all completed. Even before the FIR is lodged. FIR is in 24. That is lodged subsequently on 31/10/2013.
Yes.
It is not against the company. Accused manner as per English 25 is only indicated to the petitioner here and not Rahul.
Yes.
That one aspect. Thereafter, there will be filed a charge sheet. The heads of charge sheet are on English 28, column 7. It's a repeat of the contents of the complaint. My submission to my office is first of all, without an FIR being registered, they could not have conducted any investigation. They have usually got, and they know according to them, I'm assuming that the complaint to be entirely true in order to test my case. They knew that I'm selling the software, or I'm selling the software by procuring it from one Virendra Rao to the second entity. According to them, they come to my office and tell me, please contact Virendra Rao, ask him to download one software for free. Thereafter, in page 23, they also in the unnumbered paragraph 2, they seize all the devices, they access the password. At which stage there was no FIR. There's no FIR, no investigation for conducted. Thereafter, they filed the complaint. From the entire material what they have procured, there is nothing to show that I have committed an offense. But there are cases that committed an offense on the page 72 of the Information Technology Act. The section 72 of the Information Technology Act, I must be an officer appointed under the Information Technology Act. This is how it reads now, section 72. Penalty for breach of confidentiality, and privacy, same as otherwise provided in this act or any other law prescribing in court. If any person who in pursuance of any of the powers conferred under this act,
No, forget about 72. What about the other provisions?
section 24 of the Telegraph Act, that's the other allegation.
No, 420, 66 B and 66E.
I think, with reference to computer related offense.
Yes.
If any person dishonest or fraudulent does any act referred to section 42, he shall be punishable with an imprisonment for a term of one year. I will read of section 43. The reference to section 43. Penalty for damage, penalty and compensation for damage to computer and computer system. If any person, without the permission of the owner or any other person who is in charge of a computer system or computer network, therefore, my lord, if it was in a computer or computer system.
No, the allegation is you are securing information by using a software from somebody else's phone.
With respect to they interact, saying that here, I'm going to give you 65,000. And irrespective of judging my morality, my lord, if I say, okay, I'm getting 65,000 rupees, I make a call to the second. And they buy the software. My lord, the software, the only software which I have understood, my lord, which is very secure, that Pegasus software, which my lord is recall, which is subject matter of.
There is that element of cheating always. There's that element of cheating that you wanted money for.
If you look at Google Store and all, or look at iStore.
Not a case for invoking for it.
If you look at Google Store, you look at the iStore, I can download any software for like Truecaller and spyware, etc. They don't need me as a technologist or any other person to come and access their code. This is one aspect. The second aspect, my lord, is we see the other offenses what they say that section 66B, that is in reference to receiving stolen computer resources. But I have not done anything. Somebody comes.
At a trial, Rajesh.
But I'll just submit it. You see again.
You want me to conduct a trial now at this stage?
Not trial, I'll show my lord even of the charge sheet material. You see for a moment. Section 24. Unblocked under the Telegraph Act. Unlawfully attempting to learn contents of messages. This has to be an offense under section 23. Intrusion into signal room, trespass in telegraphic office, or obstruction in any person without permission of the competent authority enters the signal room of a telegraphic office. In fact, there is a judgment of the Supreme Court. So far, the Telegraph Act is concerned. This is in the case of R.M. Malkani.
No, 24 is unlawfully attempting to learn contents of messages.
Yes, my lord, it's not the case that I walked into any office of the telecom department Lord, I cannot go there with, I'm not an employee of the telecom department. I cannot enter a telecom office without any, Lord, unless there's a officer from there who is named as an accused, who says that he gave this information to me. It doesn't arise, my Lord. At best, it could be, my Lord, under 25 of the Telegraphic Act to intercept or under 25B, to intercept or acquaint himself under 25B of the Telegraphic Act with the transmission or delivery of any message.
This is if he damages or removes or tamper. I think 24 is attracted because you're attempting.
24 is an offense under 23 for an act under 23. They make me, my Lord, and another private person. They make me and another private person an accused. They do not make any person in the telegraphic department an accused. My Lord, this is the definition under Malkani's case, R.M. Malkani's case, paragraph 20. It starts in the second sentence, third sentence, my Lord, the substance of the offense under section. Para 20.
Yes.
So the first sentence is the police officer, the present case, fix the tape recording device. Thereafter, the fourth sentence, substance of the offense. I'm coming to that. Substance of the offense under section 25 of the Telegraphic Act. If damaging, removing, tampering, touching, machinery, battery line, or
Seek for discharge there, Rajesh.
one submission. But the other aspect, my Lord, is I'll just show, my Lord, because Lord, please ask me to review the material to show whether there's any material as against you. My Lord, please see the charge sheet as against the material. They themselves say there's no incriminating material. Volume 1, page 203. Sorry, 251. Water.
$251.
Yes. This is my inbox. Volume 1.
This is something about there are sensitive emails in the inbox.
Next sentence, mails in the inbox were checked for any incriminating material, and no such material was found.
In this particular inbox, that is all.
Page 109.
You're asking me to conduct
I'm showing, my Lord, there's no material. My Lord, there's absolutely no material.
you for discharge.
No respect to me, my Lord. What happened to that? I'll tell you. They come to my office and they conduct a raid. I'm a registered security company with a license from the commission. They come to my office and they do this raid without even there being an FIR. After that, my Lord, they file this complaint. And before even filing the complaint, they seize all the material. The matter is kept pending, my Lord, and the trial court, my Lord, starts issuing notices to the show cause notice to the police officer, saying for 8 years, why you not file a charge? Please see, my Lord, in page 59 to my petition. It is only for this reason, for 8 years, my Lord, I will place reliance on the judgment of this honorable court, my Lord. It shows that there is a delay of more than 8 years, my Lord. In page 59, accused number 1 present, accused number 2 absent, EP file, the present case is more than 5 years. Still, IO has not filed final report. Therefore, you should show cause notice to concern.
Therefore, I am saying go and seek for discharge.
My entire life, my Lord, has come to a standstill because of this. Please see even the cognizance in page 34. It's just, my Lord, the IO has been forced to file a charge sheet from 2013, other than that particular race, my Lord. No material has been covered for 8 years. This case has just been pending because they have taken this much of time to file the charge sheet.
I'll direct them to conclude the trial as early as possible.
Rather than that, I can see some judges which I'm facing reliance on.
At the stage of 482, don't ask me to go there. Any observation I make here would have some telling effect on you. You're going to take a risk of arguing and me making an observation. It'll harm you when you seek for discharge.
I just, some of my judgment, can I just request to be taken on Monday? Why is this? No, no, I'll just.
You argue for discharge is much more easier than this.
He said, it's not even an iota.
I will ask them to consider your application if it's filed expeditiously. That's a better alternative. Don't take the risk of,
From the.
I can't give you a broader end than this.
No, I request for our Prime Minister that a police officer who is acquainted to the law cannot conduct an investigation without registration of an FIR. That my lord is a clear violation of law.
The allegations are serious that you facilitated the procurement of some software which could eavesdrop on other mobile phones. This is a matter which requires some investigation.
They come, in fact, in terms of entrust.
It's already done and dusted now. It's quite some time now. Why do you want to take the risk of?
In so far as entrust is concerned, Supreme Court says that there is no provision where they can induce me. My lord, here they are inducing me to commit an offense. They are inducing me to commit an offense. And based on that, they are now telling me you have committed a crime.
All the more reason for you to argue for a discharge.
Police officer, it's
The magistrate would have the benefit of going through all this, examining it in detail and then coming to a conclusion. Why do you want me to go through that? And suppose they say something against you.
let them point out to my lord, only one submission. Let them show even one material matter. It shows that I have done any act other than this police officer's self-serving, my lord, even there was no life and death threat. My lord, I'll put this for my lord's time. This is my last submission. I'll put this for my lord's time. Consideration. I sell a knife, my lord. The knife can be used to cut vegetables or kill somebody. How can they? My lord, that's the same software. The same software could have been used for a productive purpose. Truecaller is there as a software. We all download it professionally to make sure that we don't get spam calls, etc. Then at least I'll file an application for.
You want to withdraw with liberty to file an application for discharge or you want to pass an order on merits? Counsel of the petitioner seeks permission to withdraw the petition and also seeks liberty to file an application for discharge. Petitioner is dismissed as withdrawn. Liberty is granted to the petitioner to make an application for discharge. If such an application is made, the learned magistrate should consider the same as expeditiously as possible and pass appropriate orders.
Say number 19.
Selectively only.
Firearms against 21 odd people. The petitioners hearing challenge it. And the complainant is issued no petition to court.
FIR, my lord, sees the FIR Ch-16. There are a total of 24 individuals arrayed as well. The instant petition was filed by accused number 19 and 20. Stay was granted on 15/12/2021.
What is the allegation of the complaint?
My lord,
What is the allegation of the complaint?
my lord, cheating essentially.
What was the cheating regarding?
My lord,
Property, 3 acre of land, the original landowners had issued a GPA in favor of the complainant. Thereafter, the laws they cancelled the GPA and issued another GPA in favor of Shivappa. The petitioners hearing purchased the property through the GPA order of Shivappa and are in a position of the property. The complainant filed this complaint against the landowners, the GPS holder, and total extent of land was 3 acres. The petitioner said in purchase only 1 acre, 38 and a half acres. My lord, yesterday, the complainant has issued a deed of confirmation after receiving the consideration, confirming the title over that 1 acre, 38 and a half.
ನಿಮ್ಮ ಕಾಸು ಕೊಟ್ರೆ ನೀವು ವಿಡ್ರಾ ಮಾಡ್ತೀರಾ? This is a dangerous strategy because if I were to accept this memo and the other accused will say that you have accepted the GPA, in that case, then you are in trouble. Your entire complaint will go.
I am repeating.
I am the company. I am the company.
You are challenged.
Members, and the confirmation deed.
You are sure your complaint will suffer a consequence because you are basically now admitting the GPA.
But I was requesting that let the be clarified, members, let the investigation go on against the other accused.
It's according to me, this is not good strategy. Your complaint would virtually go because you are now admitting the execution of GPA in favor of that person and also confirming the transaction.
Between the petitioners and me. That is all.
Your choice. I don't think this is right. I should not be entertaining this petition when you're seeking for caution only as against 19 and 20. The entire gist of the complaint is different. That the cancel of GPA was incorrect. And the execution of GPA in favor of somebody was incorrect. That amounted to cheating. If you're going to accept a part of the cheating,
Well, only to the extent that the
How?
petitioner is concerned.
it is one transaction, isn't it? The execution of GPA in favor of that other person is one transaction. They are the beneficiary of that transaction. If you admit this, then your complaint will go according to me. Your choice.
It's not a- Take instruction.
ಎಷ್ಟು ಕಾಸು ಕೊಟ್ರಿ ಇವಾಗ ನೀವು? How much money have you paid?
$20,000.
19. Think about it. There must be a better way of getting this done than
22nd.
no civil suits.
There are 2 significant injunction suits against.
If I accept this compromise in one case, and if they come up in a petition, the other complainants, other accused, I don't think I'll have a chance to say no to them.
Confirmation and the affidavit specifically appeared only when end the amount has been paid.
He probably does.
Compounding of the offense.
He probably does not realize the consequences for the entire transaction.
Yeah. I have sought modification of the interim order to restrict it only with the respect of the two petitions.
I have no problem, but I'm warning you because once I pass an order, it will affect all the other accused.
So that thing is not. But
Your list.
22nd.
I'm great.
See number 20.
Application.
Promise code.
See number 20.
Yes. BBR. You are? Use number 1, 2, and 3. Yes.
The facts of the case are that the petitioners run foundation. Part of it is the education. It's under Indian trust and they're basically a non-profit organization for economically weaker. What they do is they take they do not appoint anyone or collection agents. They actually for weaker sections they buy a land if they become a member. And the complainant respondent number 2 became a member in 2007, and she has subscribed for a plot of land and paid amount for the same. Later on, she cancelled her membership and has taken a refund in cash on 28/7/2020, which is at page number 31.
Then what happened? Self-help group, not profit, you're engaging in the business of selling sites
We buy land from the.
and you're a self-help group.
And so she has received rupees 92,150 as full and final settlement, which is the cancellation amount, is a page number 31 of the petition. And later on, but after cancellation, the complainant and the husband, Mr. Sayed Ali, have been partially harassing the petition by putting the false allegations against them. So for that, the petitioners have already filed a complaint before the Superintendent of Police and also the Commissioner regarding the same records, which is the page number 40. Three months. One complaint is given to the Police Commissioner and other complaint to the Superintendent of Police. Later on, the complainant has filed a PCR record and referred the matter. They referred to PCR and I also had filed a 200 application for the transfer, wherein the 409, 420 of IPC and 21 and 23 of Birth Act has been registered.
What is this consumer forum proceedings?
Regarding the that we on the state court we have lost it. Then we have filed an appeal statement.
What has happened to the appeal?
Because of what dismissed, there was a review that talks about dismissed, so that has come to. It has been demanded.
You already approached the consumer forum, then why the criminal complaint?
Oh, she's a totally fraud lady. No, she's telling that she has refunded the money. That her modus of operandi only on paper. Only paper. There will be no. This is an idea filed by the investigation officer to vacate the stay order. They have sufficient material. The Honorable Court has reported that there are sufficient material to proceed with the case. No, the IA has filed an IA to vacate the stay order that the investigation has been conducted, material has been collected. Due to that stay, they cannot file the charge sheet. My lordship, the petitioner has been deceiving the members of the public, falsely advertising and allotting and selling housing site which does not exist at all. As evidence from the annexure E at page number 35 and 39, my lordship.
When did you approach the consumer forum?
In the year we have, but when we approached in the 2020.
So before you filed a complaint, you approached the
No,
consumer.
The consumer forum ruled in favor of me, directing to allot the.
When did you approach the consumer forum? Before the PCR or after the PCR?
No, before the PCR.
Yes.
After the, before the PCR. Before the PCR.
So you already approached the appropriate forum, contending that you are a consumer and you have been cheated.
Yeah.
You succeed there, and there in pendency those persons you also file a private complaint.
No, she was the entire proceeding. Someone has been served in various way. We have even sent to the WhatsApp, and she did not intentionally appear before the court. And ex parte, she suffered ex parte. When she confronted, when we filed the execution petition, in order to wriggle out from the situation, she has fabricated a document. She said that she is not available on the said date. In bear her signature, it is an evidence from the at bear her signature, she is not available, and in absence she has retained the money. And also, my lordship, if the Honorable Court consistently seeking for that. We have paid the entire self-consideration. She has given two unregistered agreement. It is a only namesake agreement that said.
What is the amount that you have paid?
In the year 2007, I paid 1,65,000 rupees. In the year 2005.
That amount is not given back to you now.
No, not given. That is my lordship. I will.
However, there are no specific allegations against the petitioner. Only like they have cheated showing some people this that they are telling.
This 92,000 that you paid, was it cash or was it check? Then let the proceedings go on. Let the proceedings go on, whether it was given or not, that's a matter for trial. If this cancellation of the voucher is a fraudulent document, then there's a case for investigation. If you have something to show that you have given the money, by way of a check, I would have watched the proceedings.
My lord, if we.
Moreover, there is no specific allegation.
My lord.
Only like and they have already approached the district court.
They may not file a charge sheet against you. If what you say is correct, they may file a B report. Why should I stop the investigation? Your case is one of refund.
Since the applicant's husband is a lawyer, they are just receiving the law.
Then what will his wife think? You're a lawyer, you can't get me back my money, therefore. Correct alva? Lawyer ಆಗಿ ನೀವು ಏನು ಮಾಡಕ್ಕಾಗಿಲ್ಲ ಅಂತಂದ್ರೆ let them investigate. This is the first time that I'm seeing a self-help group engaged in the business of and you're talking about weaker section and they collect 1,60,000 from the weaker section in Mysore for a site. Then the fact that you refund 92,000 indicates that the money was paid.
You have produced receipt, my lordship.
Shalva. No, that is a matter for investigation. If you establish that they have in fact received, that is for deficiency in service. That was for deficiency in service. This is for cheating from the inception. Your entire approach was to take money from poor people in the name of Sintu. When the petition. 60? Yes.
ಆರೋಪಿ ಸಲ್ಮಾನ್ ಸಿದ್ದಿಕ ಹಾಗೂ ಅವರ ಸಹಚರರು ಇದ್ದು ಟ್ರಸ್ಟ್ ನಲ್ಲಿ ಒಂದು ಟ್ರಸ್ಟ್ ಅನ್ನು ರಚಿಸಿ ಮಧ್ಯವರ್ತಿಗಳನ್ನು ನೇಮಕ ಮಾಡಿ ಅವರಿಗೆ ಗ್ರೂಪ್ ಲೀಡರ್ ಹೆಸರನ್ನು ಕೊಟ್ಟು ಇವರುಗಳಿಂದ ದೊಡ್ಡ ಪ್ರಚಾರವನ್ನು ಮಾಡಿ ಸಾರ್ವಜನಿಕರಿಗೆ ಸೈಟ್ ಅಪ್ಲೈ ಮಾಡಿ ಎಂದು ಹೇಳಿದರು. ಮೇರೆಗೆ ಸಾರ್ವಜನಿಕರು ಹಾಗೂ ಫಿರ್ಯಾದಿ ಸೈಟ್ಗೆ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿತು. ಹಣವನ್ನು ಪಡೆದುಕೊಂಡಿರುವುದಕ್ಕೆ ಹಣದ ರಶೀದಿ ಹಾಗೂ ಹಿಂಬಾಲವನ್ನು ಸಹ ನೀಡಿತು. ಆ ಸೈಟ್ ಹಣವನ್ನು ನೀಡುವಾಗ ಯಾರು ಸೈಟ್ಗಾಗಿ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೋ ಅವರಿಂದ ಬಾಹ್ಯ ಉದ್ದೇಶದಿಂದ ಹಲವಾರು ಪ್ರಿಂಟೆಡ್ ಹಾಗೂ ಖಾಲಿ ಪೇಪರ್ಗಳನ್ನು ಸಹಿಯನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದು ನಿರ್ದೇಶನದ ವಿಚಾರವಾಗಿ ಗ್ರೂಪ್ ಲೀಡರ್ಗೆ ವಿಚಾರಿಸಿದ ಸೈಟ್ಗೆ ಎಲ್ಲ ಹಣವನ್ನು ಸಂದಾಯ ಮಾಡಿ ಇರುವುದು ಮುಗ್ಧ ವ್ಯಕ್ತಿಗಳಿಗೆ ಮಂಡ್ಯ ತಾಲೂಕಿನ ಬೇರೆಯವರು ಕೃಷಿ ಜಮೀನನ್ನು ತೋರಿಸಿ ನಿಮಗೆ ಹಂಚಿಕೆಯಾಗಿರುವ ಸೈಟ್ ಎಂದು ತೋರಿಸಿ ಮೋಸ ಮಾಡಿದ್ದು. ಈ ವಿಚಾರವಾಗಿ ಯಾರಾದರೂ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಅಥವಾ ಪೊಲೀಸ್ ದೂರವನ್ನು ಸಲ್ಲಿಸಿದರೆ ಸಹರಿಯವರು ನಿಮ್ಮಿಂದ ಈಗಾಗಲೇ ಖಾಲಿ ಫಾರಂಗಳಿಗೆ ಸಹಿಯನ್ನು ಪಡೆದುಕೊಂಡಿರುವ ಫಾರಂಗೆ ದಿನಾಂಕಗಳನ್ನು ಅನುಕೂಲವಾಗುವಂತೆ ದೂರ ಪ್ರಯೋಗ ಪಡೆದುಕೊಂಡು ನಿಮಗೆ ಹಣವನ್ನು ವಾಪಸ್ಸು ಕೊಟ್ಟಿರುತ್ತೇವೆಂದು ಅಧಿಕಾರವನ್ನು ಸೈಟನ್ನು ಪಡೆಯಲು ಅರ್ಹತೆ ಇಲ್ಲವಂತೆ ಕುದುರಿಸಿ ಬೆದರಿಕೆಯನ್ನು ಹಾಕುತ್ತಿದೆ. ಈ ಬಗ್ಗೆ ಸದರಿ ಆರೋಪಿತರ ವಿರುದ್ಧ ಕಾನೂನು ರೀತಿಯ ಕ್ರಮ ಜರುಗಿಸಬೇಕೆಂದು ಇತ್ಯಾದಿ.
When the complaint was lodged with the magistrate under section 200 of the CRPC.
But I want to also make, she has been making false claims and statements.
What do you want me to do? You want me to allow the petition or dismiss the petition? Contending that the petitioners herein had collected money from various persons, including the complainant, with a promise to give them a cost within the site. It was contended that the petitioners were running an organization and had created group leaders who were in the habit of showing somebody's property and intent and conveying to them that the land belonged to the Tipu Sultan in self-help group foundation, which was being run by them. And they were in the process of getting the appropriate approvals. But the petitioners had no title or rights over any of the lands that were being indicated to the general public. It was stated that they had drafted agreements, MOU, from a disbursement deed, showing fictional sites to the members, and these acts amounted to cheating. On the basis of this complaint, the matter was referred to the magistrate, and the magistrate and the police thereafter registered a crime, and the matter is under investigation. Learned counsel the petitioner contends that the respondents herein, the second respondent herein, had already approached the consumer forum seeking for refund of the amounts alleged to have been paid by her, and this by itself indicated that this was a civil dispute. Learned counsel appearing for the respondent on the other hand contended that the second respondent approached the consumer forum claiming deficiency of service, and that had nothing to do with the criminality involved in the entire process of duping the general public about granting sites, conveying sites. In my view, a reading of the complaint would indicate that serious allegations are made that a scheme was created to collect money from the gullible public with the promise that they would be allotted sites, and an attempt was also made to show properties over which the second respondent had no right, and intimating to the gullible public that those were the lands in which the sites were formed. In my view, since there is an ingredient of the intent to cheat from the very inception, this would not be a fit case to invoke section 482 and entertain the petition. Proceedings, petition is therefore dismissed. Connected, yeah. Connected is also same? Same. Come on.
Number 21. Srimati Maya Olla.
Yes.
Sold not 4 acres of land. They could not then pay to me.
When was the sale deed?
Not CD, you are also get that not running pay.
Yes.
There's an absolute say in favor of not cooperating. He will not talk to
4 acres, huh?
construct not corporate office in this building, in this land.
What was sold?
But the 4 acres of land, 4 acres, 13 acres, please come pay 101. 4 acres, 14 acres.
Yes.
Board of payment not resort to construct not the corporate office in this land. And what interest the matter about construction to national development board, please come to not page 65.
65. Yes.
Government name corporate material NTT. IRS under IRS under NTT or ನಿರ್ಮಾಣ ಕೈಗಳು ಅದಕ್ಕೆ ಅಗತ್ಯ NTT ಅವರ ಕೈಗಳು ಸರಿಯ ಸನ್ಮಾನ ಮಾಡ್ತಾರೆ. What happened was not they were to get not sanction plan everything. For not 2 years they did not do anything. EDA not the last contract conversion was granted. They pay 66 to 60.
Construct corporate office, alva?
Yes. But this too. Yeah. So please come to any page or any para. That's in number 8.
Yes.
There was a lot of delay, as you also see from my resolution was way back in the year 1999.
No, you purchased a property in 2008, alva?
First grant act, 1998 grant act. 84 and please come to page 2. Bill number 4.
Yes.
The grant order is at page 55.
This was the grant, 3398.
Then we got, if you are look at the grant also. There are no precondition. Page 57 will take copy. ಮೇಲ್ಕಂಡ ಜಮೀನಿಗೆ ಬೆಲೆಯನ್ನು ಈ ಹಿಂದೆ ನಿಗದಿಪಡಿಸಿದಂತೆ ಎಕರೆಗೆ 50,000 ರೂಪಾಯಿಗಳಂತೆ ನಿಗದಿಪಡಿಸಿದೆ. We paid the whole of the amount for at that time. Interested to not have a funded up to NTD, National Development Property. They were not delayed matters were not as a result which would be considered a corporate office in the milk dairy in our existing land not even dairy
What is this 79 2007, page 74?
74 word is long lease for the resolution matter. Because what happened was the land word we constructed our
This was even before the conveyance.
yes.
Conveyance was in 2008.
Yes. JD was 2008.
What
They are leased it out to Gujarat Cooperative Factory and Safal Industry Works for on a long-term basis. That's first there is an
What happened was there was a lot of encroachment. Even not in the but there's one more litigation for going on, but ultimately not be.
Now, what is the resolution of 2007?
2007 the Lord is to debit not on lock keys.
Can we read that?
Yes, ma'am. Please come to that page 75.
Yes.
Mandali Sabhege.
ಗ್ರಾಮದ ಕೋರ್ಮಂಗಲ ನಿವೇಶನದಲ್ಲಿ ಮಿಲ್ಕ್ ಫಾರ್ಮ್ ನಿರ್ಮಿಸಲು ಹಾಗೂ ಮಿಕ್ಕಿಯುವ ಜಾಗವನ್ನು ವಾಣಿಜ್ಯ ಉದ್ದೇಶಕ್ಕಾಗಿ ದೀರ್ಘಾವಧಿ ಲೀಸ್ ಆಧಾರದ ಮೇಲೆ ಜಮೀನನ್ನು ನೀಡಲು ಕಾನೂನು ತಜ್ಞರ ಅಭಿಪ್ರಾಯ ಪಡೆದು ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರಿಗೆ ಅಧಿಕಾರ ಸರ್ವಾನುಮತದಿಂದ ಒಪ್ಪಿಗೆ ಮಾಡಿದ್ದಾರೆ. Resolutions to get an opinion and thereafter consider granting a long lease for construction of a commercial complex. Then what happened? Technical consultant was appointed and actually page 76. No, was the legal opinion taken? Yes. When was it taken? You 72. In favor of the intending since there no So until the conveyance deed was to be executed, you could not have leased the property, according to this opinion. But lease the property, but we got, please come to the running pay, we put that right, 15,000. They did not lease material. This was the opinion. Yes, sir. Lease, my lords get that not running pay. 115. No, but even before that, this list of dates of yours indicates that you took a decision to appoint a consultant for grant of lease. Then you also went on to release advertisements for taking the scheduled property in long-term lease. So even before the he obtained the legal opinion in page 87 in 2008. Before that, you have done so many acts contrary to the decision of the board. The board said, take action to enter into a long-term lease after securing an opinion. Opinion is sought for and it was given only in the month of March 2008. Even before that, we proceed to start. Lease has not been given as yet. No, but you disobeyed the instructions of the. Please talk about that resolution itself. Yes. Page 75 ಅಲ್ಲಿ ದೇಶಕ್ಕಾಗಿ ದೀರ್ಘಾವಧಿ ಆಧಾರದ ಮೇಲೆ ಜಮೀನನ್ನು ನೀಡಲು ಕಾನೂನು ತಜ್ಞರ ಅಭಿಪ್ರಾಯ ಪಡೆದು ನಿಯಮಾನುಸಾರ ಕೈಗೊಳ್ಳಲು ವ್ಯವಸ್ಥಾಪಕ. So until you obtained the opinion of the legal advisor, you could not have taken any steps for grant of this lease. Lord, my submission to your Lord says, we will not put an advertisement will not vendors verified it. Please come to the next judgment, page. Please come to page 85. Sorry, 81. Another resolution has been passed. 86. ಸಭೆಗೆ ಪರಿಚಯಿಸಿದಂತೆ ಪ್ರಸ್ತುತ ಕೋರಮಂಗಲ ನಿವೇಶನವು ಅನುಪಯುಕ್ತವಾಗಿದ್ದು ಈ ಜಮೀನಿನ ಅತಿಕ್ರಮಣ ತಡೆಗಟ್ಟಲು ಈ ಹಿಂದೆ ಮಂಡಳಿ ಸಭೆಯಲ್ಲಿ ನಿರ್ಧರಿಸಿದಂತೆ ಈ ನಿವೇಶನವನ್ನು ವಾಣಿಜ್ಯ ಉದ್ದೇಶಕ್ಕಾಗಿ ದೀರ್ಘಾವಧಿ ಲೀಸ್ ಆಧಾರದ ಮೇಲೆ ನೀಡಲು ಪಾರದರ್ಶಕ ಕಾಯ್ದೆಯಲ್ಲಿ ಸರ್ಕಾರದಲ್ಲಿ ಚಾಲ್ತಿಯಲ್ಲಿರುವ ಪದ್ಧತಿಯನ್ವಯ ದೀರ್ಘಾವಧಿ ಲೀಸ್ ಆಧಾರದ ಮೇಲೆ ನೀಡುವ ಬಗ್ಗೆ ಹಿಂದಿನ ಮಂಡಳಿ ಸಭೆ ನಿರ್ಣಯಿಸಿದಂತೆ ಕೈಗೊಂಡಿರುವ ಕ್ರಮವನ್ನು ಮಂಡಳಿ ಒಪ್ಪಿ ಸದರಿ ಟೆಂಡರ್ ಹಾಗೂ ತದನಂತರ ದರ ಸಂಧಾನದಲ್ಲಿ ಅತಿ ಹೆಚ್ಚಿನ ದರ ನಮೂದಿಸಿರುವ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಪ್ರಾಜೆಕ್ಟ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಎಂಬ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಸಂಸ್ಥೆಗೆ 30 ವರ್ಷಗಳ ಅವಧಿಗೆ ತ್ರೈಮಾಸ 40 ಲಕ್ಷಗಳ ಲೀಸ್ ಬಾಡಿಗೆ ಆಧಾರದ ಮೇಲೆ ನಿಯಮಾನುಸಾರ ಅಗತ್ಯ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರಿಗೆ ಅಧಿಕಾರ ನೀಡುವ ಹಾಗೂ ಗ್ರಾಮದ ಆಡುಗೋಡಿ ನಿವೇಶನದಲ್ಲಿ ನಿರ್ಮಿಸಿರುವ ಶೀಲವಾದ ಕಟ್ಟಡದ ಮೇಲೂ ಸಹ ಹೆಚ್ಚುವರಿ ಅಂತಸ್ತುಗಳನ್ನು ನಿರ್ಮಿಸಿ ವಾಣಿಜ್ಯ ಉದ್ದೇಶಕ್ಕಾಗಿ ಉಪಯೋಗಿಸುವ ಹಾಗೂ ಗ್ರಾಮದ ಸಂಕೀರ್ಣದಲ್ಲಿರುವ ಖಾಲಿ ನಿವೇಶನ ಮತ್ತು ಮುಂದೆ ಕೊಳ್ಳಲ ಪೌಚ್ ಫಿಲ್ಮ್ ಘಟಕದ ಆವರಣದಲ್ಲಿರುವ ಖಾಲಿ ನಿವೇಶನ ಸಹ ವಾಣಿಜ್ಯ ಉದ್ದೇಶಕ್ಕಾಗಿ ಬಳಕೆ ಮಾಡಲು ಅಗತ್ಯ ಪೂರ್ವಭಾವಿ ಕ್ರಮವನ್ನು ಕೈಗೊಂಡು ಮಂಡಳಿ ಸಭೆಗೆ ಪ್ರಸ್ತಾವನೆ ಮಂಡಿಸಲು ಸರ್ವಾನುಮತದಲ್ಲಿ
This resolution was passed, no, passed without reference to the early resolution asking you to obtain a legal opinion. It was your duty to secure a legal opinion. You should, have you brought it to the notice of the board that this was the resolution that you have taken steps to obtain legal opinion? If you don't bring it to the notice of the board and the board passes some resolution, yes.
There is a reference to not the resolution of the board earlier resolution. First paragraph itself is earlier resolution. Everything would have been placed before them. This is not ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು ವಿಷಯದ ಬಗ್ಗೆ ವಿಸ್ತರಿಸುತ್ತಾ ದಿನಾಂಕ 17/9/2007 ನಡೆದ ಸಹಮತ 189ನೇ ಮಂಡಳಿ ಸಭೆಯಲ್ಲಿ ಬೆಂಗಳೂರು ಕೋರಮಂಗಲದಲ್ಲಿರುವ ಸಹಮತ ನಿವೇಶನವನ್ನು ದೀರ್ಘಾವಧಿ ಲೀಸ್ ಆಧಾರದ ಮೇಲೆ ನೀಡುವ ಬಗ್ಗೆ ಹಾಗೂ ಸದರಿ ಸ್ಥಳದಲ್ಲಿ ಅತ್ಯಾಧುನಿಕ ಜಲಪಾಲನ ಸಾಗಿಸುವ ಬಗ್ಗೆ ತೀರ್ಮಾನಿಸಿದೆ. Then what I say already said all this.
No, where have you said about the legal opinion? And what did you say about the legal opinion, steps that you have taken for securing the legal opinion? If you have not done that, that means you are.
I have said all this, that is not, these various steps have been taken.
And crucially, you did not tell them about the legal opinion. Legal opinion is also dated 17/3/2008, the date of the resolution, which said take a deed of conveyance and then do it.
What will happen is when they write a minutes, they will not write everything under the sun.
This particular page 80.
There is a reference to the resolution of the earlier resolution. Earlier resolution.
No,
that
the-
said not take legal opinion.
You were
They
the,
are not-
you were the MD, you were the MD at that point of time.
My submission you not see, they do not say, you did not take a legal opinion, but everything that
No,
in
no.
case.
You kind of state in the first paragraph that it was decided in the meeting of 17 and 2007 to give a long-term lease. But you omit to state that you are required to secure a legal opinion and thereafter consider this. If you don't state that at all.
The last page, bills period in Yaro.
ಅಲ್ಲ ನೀವು ಅಂತಾನೆ ಬರೋದು ವ್ಯವಸ್ಥಕ ಪ್ರದೇಶಕ ನಿರ್ದೇಶ ವಿಷಯದ ಬಗ್ಗೆ ವಿವರಿಸುತ್ತಾ.
Director, secretary, normally not secretary writes office. In a board, it's a secretary not write office.
There is something to indicate that this is what you said. And if you don't inform the board about
My submission you are not saying.
an argument can be advanced that you misled the board. Because you did not,
It's not that the board has been misled. We look at what is the complaint that is given. You could not have leased it, that's all. It is not that there is, I misled the board and then, this has happened. Please look at the complaint. It is not the complaint at all.
where is the complaint?
Please come to our running page, 167. Now, third party rights were not, lodge the complaint. Come to our
1 minute.
third paragraph.
Page number 1.
Third, 165.
Yes.
ನಿಯಮವನ್ನು ವಿಧಿಸಿ ಭ್ರಷ್ಟಾಚಾರಕ್ಕೆ ಪ್ರಭಾವ ಮಾಡಿದ್ದು ಕೂಡಲೇ ತನಿಖೆ ಮಾಡಿ ಸಂಬಂಧಪಟ್ಟವರನ್ನು ಬಂಧಿಸುವಂತೆ ಒತ್ತಾಯಿಸುತ್ತೇನೆ. 19/19/2014 TMF ಅಧ್ಯಕ್ಷರಾಗಿದ್ದ ಮಲ್ಲಪ್ಪನವರು ರಾಜ್ಯ ಸರ್ಕಾರಕ್ಕೆ ಪತ್ರ ಬರೆದು ಎಂಜಿ ರಸ್ತೆ ಟ್ರಾಫಿಕ್ ಘಟಕದಲ್ಲಿ TMF 40,000 ರೂಪಾಯಿ ಮಾಡಿಯ ನೀಡಿ ಕಾರ್ಯವಹಿಸಿತ್ತು. ಸರ್ಕಾರದಿಂದ ಜಾಗ ಕೊಟ್ಟರೆ ಸಭಾಖಂಡ ಕಟ್ಟಡ ಕಟ್ಟಬಹುದು ಎಂದು ಮನವಿ ಮಾಡಿದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ರಾಜ್ಯ ಸರ್ಕಾರದ ಕೋರಮಂಗಲ ಸರ್ವೆ ನಂಬರ್ 234 ಹಾಗೂ 71/4/14 ಜಮೀನಿನ ಸರ್ಕಾರಿ ಆದೇಶದ ಮೂಲಕ ಮಂಜೂರು ಮಾಡಿದೆ. ದಿನಾಂಕ 19/5/2008 ಕ್ಯಾಬಿನೆಟ್ ಅನುಮೋದನೆಯಲ್ಲಿದೆ. ನೀರಾವರಿ ಇಲಾಖೆ TMF 4 ಎಕರೆ 14 ಗುಂಟೆ ಜಾಗವನ್ನು ಒಬ್ಬನಲ್ಲಿ ಸ್ಪರ್ಧಿಸುವ ಕಚೇರಿಯಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಲಾಗುತ್ತದೆ. ಅಚ್ಚರಿ ಎಂದರೆ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ ಕೆಲವೇ ಕೇವಲ 10 ದಿವಸದ ದಿನಗಳಲ್ಲಿ ಈ ಜಾಗ ಪರವಾನಗಿ ಮಾಡಲಾಗುತ್ತದೆ. Alienation, there is not a lease. ದಿನಾಂಕ 29/5/2008 TVK ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಎಂಬ ಕಂಪನಿ ಜಾಯಿಂಟ್ ವೆಂಚರ್ ಅನ್ನು ಪರವಾನಗಿ ಮಾಡುತ್ತದೆ. ಅನಂತರ ಹಲವು ಕಂಪನಿಗಳಿಗೆ ಜಾಗ ಪರವಾನಗಿಯಾಗುತ್ತದೆ. TVK ನಂತರ ಆ ಜಾಗವನ್ನು ಆಸ್ಕೋ ಕಂಪನಿಯ ನಂತರ TVK ಕೊಡಮಂಗಲ ಕಂಪನಿಯ ನಂತರ ಹಿಂದೂಸ್ತಾನ್ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಎಂಬ ಕಂಪನಿಯ ಅನಂತರ ಮಂತ್ರಿ ಮ್ಯಾಗ್ನೆಟ್ ಕಂಪನಿ ಸತತವಾಗಿ ಜಂಟಿ ಅಭಿವೃದ್ಧಿ ರಂಗದಲ್ಲಿ ಪರವಾನಗಿಯಾಗುತ್ತದೆ. ಅಚ್ಚರಿಯೆಂದರೆ ಪ್ರತಿ ಬಾರಿಯೂ ಕಾನೂನು ಉಲ್ಲಂಘಿಸಿ KMF ಹಾಗೂ ಸರ್ಕಾರಕ್ಕೆ ಖಾಸಗಿ ಬಿಲ್ಡರ್ ಕೋಟ್ಯಾಂತರ ರೂಪಾಯಿ ವಂಚಿಸಿ ಸರ್ಕಾರದ ಜಾಗದಲ್ಲಿ ವಾಣಿಜ್ಯ ಸಂಖ್ಯೆಯಲ್ಲಿ ಕಟ್ಟಿರುತ್ತಾರೆ. ಇದರಲ್ಲಿ ವ್ಯಾಪಕ ಭ್ರಷ್ಟಾಚಾರ ನಡೆದಿದೆ. ಬಿಲ್ಡರ್ KMF ಅಧಿಕಾರಿಗಳು ಅಧಿಕಾರಿಗಳು ಸೇರಿಕೊಂಡು ಸರ್ಕಾರ 500 ಕೋಟಿ ಬೆಲೆ ಬಾಳುವ ಭೂಮಿಯನ್ನು ವಂಚಿಸಿ ಭಾರಿ ಪ್ರಮಾಣದ ಭ್ರಷ್ಟಾಚಾರ.
The entire thing has gone on like as if that particular requirement of obtaining an opinion was not at all there.
Nothing is there.
But within 10 days, this is done, ignoring the requirement of the earlier resolution.
Let us have a look at when was it got the lease, when you got it happened. Please come to the opinion. Opinion I got 10 days only, register. Opinion says get on the permission or the conveyance
No.
from the.
This is one part. This resolution passed on the same day is totally silent about the requirement of getting a legal opinion.
No, that's why I said everything will not be written about in that resolution. Resolution is, please look at what is the resolution. Please look at what the resolution itself. Resolution approves and ratifies the decision. Please come to running page 81. Act 1986.
What is the stage now of the case?
Construction
No, no.
always been state. Immediately it was state. If a company is not made a party, we got a time and again, company has been made a party. Only the managing director has made a party. There are board members who are passes. Please look at the resolution pass.
Petitioner, who is the petitioner is?
Petitioner is one
The MD at that point of time.
at that point. He has retired about 10 years, 2015, 10 years. After his retirement, his complaint was filed. Complaint itself, if you are to see, 165 months. 2017, these would not happen in the year 2008. After the lapse of 10 years, this complaint is lodged. Enough judgments are there of this one court of the Supreme Court, complaints are lodged after such a long period. It's liable to be filed.
Who made the accused in the complaint?
Please come to the page 79 for a minute. I tell you what is why. He writes to the government saying that page 79. ಉಪಕಾರ್ಯದರ್ಶಿ ಪಶು ಸಂಗೋಪನೆ ಮತ್ತು ಮೀನುಗಾರಿಕೆ ಇಲಾಖೆ ರಾಜ್ಯ ಟೆಂಡರ್ ಬುಲೆಟಿನ್ ಅಧಿಕಾರಿ ಕರ್ನಾಟಕ ಸರ್ಕಾರ ಸಚಿವಾಲಯ. It was brought to the notice of the government. ಮೇಲ್ಕಂಡ ವಿಷಯದ ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕೋರಮಂಗಲ ಗ್ರಾಮದ ನಿವೇಶನದಲ್ಲಿ ವಾಣಿಜ್ಯ ಸಂಕೀರ್ಣ ಕಟ್ಟಡ ವರ್ಗಾವಣೆಯಲ್ಲಿ ಆಧಾರದಲ್ಲಿ ಯೋಜನೆಯನ್ನು ಕೈಗೊಳ್ಳುವ ಸಂಬಂಧ ಟೆಂಡರ್ ಆಹ್ವಾನಿಸಿದ್ದು. ಟೆಂಡರ್ ಬುಲೆಟಿನ್ ನಲ್ಲಿ ಟೆಂಡರ್ ಪ್ರಕರಣಗಳು ಪ್ರಕಟಿಸಲು ತಮ್ಮಲ್ಲಿ ಕೋರಿಕೆ ಟೆಂಡರ್ ಪ್ರಕರಣ ಪ್ರತಿಯನ್ನು ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತಿಸಿದ್ದು. ಟೆಂಡರ್ ಬುಲೆಟಿನ್ ನಲ್ಲಿ ಪ್ರಕಟಿಸಲು ಮತ್ತೊಮ್ಮೆ ತಮ್ಮಲ್ಲಿ ಕೋರಿಕೆ. Published there, published in the advertisement in paper also not page 77.
notice in my tenders.
The FIR indicated who was the accused?
Nobody.
Nobody. I'll read out what it says. Details of unknown suspected, unknown accused with full particulars attached. 2007 ಮತ್ತು 8 ರಲ್ಲಿನ TMF ಆಡಳಿತ ಮಂಡಳಿಯ ಹಾಗೂ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು ಮತ್ತು ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆಯ ಅಂದಿನ ಕಾರ್ಯಪಾಲಕರು ಅಭಿಯಂತಕರು ಕಟ್ಟಡ ವಿಧಾನ ಹಾಗೂ ಇತರ ಅಧಿಕಾರಿಗಳು. It's at a very nascent stage. The investigation is not even kicked off.
Complaint is dated.
Lord's complaint is dated for 2017. He says some interloper. It's not about anybody. Some interloper. In fact, Lord, your lordships would have directed the government as to whether or not they have anything to say. They have said we have nothing to say.
But they have not taken a stand as such. They have already said that they
He's taken on the order passed by your lordships word.
they have not filed a stand as such. The honorable court had said whether there
I
is.
hear you, sir. Please.
How really? Let the government say formally.
Please,
by-
no,
by
Lord,
the-
please. But it's order dated 11/10/2023. He's speaking to Baradilla, but your lordship could ask the government. Last time also, the not paid it.
Orally they have said.
My to order.
I
Whatever I have said, I will, stand by that. I never
said.
mislead a court.
No, I never said my learned significant. No, I will never make such a statement at all. I will be saying that not filed a formal action.
Madam, have you filed the affidavit as indicated on 11/10/2023? File an affidavit.
And I will request one thing. Not please permit me to take one step. Next year, after my statement of objection, Honorable Supreme Court in Lalita Kumari judgment has said that and such issues are that there needs to be a preliminary inquiry. There is a detailed preliminary inquiry report. My lords will please have my statement of objection. Next year, from the day it was the proposal to lease it on a requisition was made by KMF as way back as 1986 to this day, what has transpired therein? What are the violations that are alleged? What are the rules of conduct which according to which they had to seek permissions to take to first execute a lease deed, sale deed, relevant portions of the conveyance deed, everything is detailed therein. And after that detailed preliminary report, they opine, my lords, that there is something that meets more than the eye. Now, my respectful submission, my lords, is all with the deepest of the respect to all that the learned senior counsel is stating. Can this honorable court, my lords, the latest judgment of the Supreme Court, I will only state, it says that, and in 482 jurisdiction, I'll only read one paragraph, my lords. What this on with the deepest respect to the with the magnificent power this honorable court exercises, it only says, citation 2020, volume 3, SCC 317. My lords may please have one paragraph at para number 8. It is no more res integra that exercise of powers under 482 to quash is only when an allegation made in the FIR or the charge sheet constitutes the ingredients of the offenses alleged. Interference by the High Court under 482 is to prevent abuse of the process of any court or otherwise to secure the end. So it is settled law that the evidence produced by the accused in his defense cannot be linked into the. Now the learned senior friend here is saying, my lords, that there were some proceedings, some of resolutions passed. Based on that, they have given a long lease. He has taken decision. These are the file note. These, with the deepest respect, this honorable court cannot look into.
Please come, Lord, take this.
I would only say, my lords, I would only say that
Office copy.
in the face of there being a preliminary report, which is detailed, my lords may permit me to read out certain portions of it. It clearly says what transpired from 1986 to this day. And at this juncture, my lords, only the conclusions may be, its conclusion is about 10 pointers they have given in the preliminary report. In those conclusions, they point out, I'll read only one paragraph. ಸಂಸ್ಥೆಯು ಕಾನೂನುಬಾಹಿರವಾಗಿ PVK ಸಂಸ್ಥೆಗೆ ಲಾಭ ಮಾಡಿಕೊಡುವ ಉದ್ದೇಶ.
Suppose as per this order, if an affidavit is filed that the state government allowed this alienation to be made by the KM, then what is your stand?
Lords, my stand would be that this preliminary report suffices that there is a certain more than
The entire thrust of the complaint was that there was illegal alienation by KMF.
Please, my lords. No, my lords, I would say,
Contrary to the terms of the grant.
please.
That was
please,
the contention.
Please,
If
please.
the state government, which is the granting authority, files an affidavit stating that they did permit this alienation to be made, then the entire base of the complaint goes,
In fact,
Whether,
I may be.
isn't it?
Secretary, my lord, of the department, my lord, is a member of the board, which has passed the resolution.
Suppose they do file an affidavit,
my lords, if the government takes a stand, I wouldn't have anything. But my lords, in my preliminary report,
let them take a stand as directed by this court, then let us see what is to be.
please, my lords.
My lord,
Because
please take, my lord, some judgment for my lord's consideration.
Whatever
I learned
judgment,
it
but-
says Document can't be looked into.
Whatever it is,
At least half a dozen judgments of the Supreme Court. holds.
I'll ask the government to comply with the order first. On 11/10/2023, this court felt it appropriate to direct the state government to state whether the KMF was entitled to encumber the property conveyed to KMF to a private entity for commercial exploitation. This court also directed the state government to inform the court whether it had permitted the KMF to alienate or transfer the property on lease in favor of a private entity. This court specified that the state should indicate whether it has any serious objection against the manner in which the KMF had transferred the land to a private entity for commercial exploitation. Ultimately, this court directed the government to secure instructions and file an affidavit of a responsible officer. Though more than 8 months have elapsed, no affidavit is filed of a responsible officer. At this stage, the SCGB seeks for a week's time to file an affidavit. Seeks 2 weeks time to file an affidavit. As a last chance, 2 weeks time is granted to the state to file an affidavit as indicated in the order dated 11/10/2023. Relist on.
22nd, please.
deeply obliged.
For further consideration, serial number 22.
The government order is issued.
Government has cleared, but the university is clear.
It's like a
ಕೊಟ್ಟಿದ್ದೀನಿ,
marathon.
copy ಕೊಟ್ಟಿದ್ದೀನಿ.
It's like a marathon for me.
Government has 27th and clear property there. University have not filed.
Next page, well, that in that table,
27.
Treasury, that clause D.
27/6/2024, the government has cleared, but the university is not clear. Now the university was blaming the government.
Sridhar avare.
Serial number 22.
I think now the real battle begins with the university. What did he say?
ಕೊಡ್ತಾರೆ, no, they'll give, I think the university will give us. I don't think that hostile standards they were taking last year. I'm hoping, my lord,
Government has done, now we are in.
ನಾನು ಹೇಳಿದ್ವಿ, I'll again put in a word.
Places on record. The government order dated 27th of June 2024, whereby the government has accorded approval for grant of aid of rupees 79,15,000, which should be the amount due to the petitioner.
In that petition, 70.
No,
79
74 lakhs 35,000.
79 ಅಂತ ಇದೆ.
And there is total amount of
79, 15,
74 lakhs 35,000.
Which should suffice to meet the claim of the petitioner in WP 10404/2023. Learned counsel appearing for the petition WP 10404/2023, however, submits that though the order was passed on 27/6/2024, the university is yet to implement the government order and make over the benefits to the petitioner. In view of this, the university is directed to act in accordance with the government order and file an affidavit of compliance by the next date of hearing. Relist on.
22nd.
Serial number 22.1.
Yes.
They take where petitioner repeated their superannuation. Age of 60. Now, after the formation of a cluster university,
under the State Amendment Act of 15 of 2019, Section 14 millets and 40T has been inserted. The age of superannuation is as per the UGC guide. UGC says 65. That's the third question.
Just get ready on that, I'm not ready for it. But whether it is.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಇದರಲ್ಲಿ
Sir,
legislation is very clear.
No, but if the matter is before the full court, why should I?
Then your lordship may refer this there.
ಇದು ಆಗ್ಬಿಡ್ಲಿ ಆಮೇಲೆ after the university files an affidavit.
In this connection, may I make a submission? If this matter is pending before the Supreme Court, even today it was before the Chief Justice. They have said the Supreme Court have implemented the past and interim order. Those who are relieved also should be reinitiated. So the government is directed. Now the case is pending before the Supreme Court. The full bench cannot decide the.
ನನ್ ಮುಂದೆ ಹೇಳಿದ್ರೆ ನಾನು ಏನ್ ಮಾಡ್ಲಿ ನೀವು ಅಲ್ಲಿ ಹೇಳಿ ನೀವು.
Grateful.
Vikram argument was also.
Please inform Sridhar.
No.
Please inform Mr. Sridhar. Vikram.
I'll inform.
Vikram argument was also full bench cannot hear.
That is true. That's why I was wondering whether he's supporting me or the other.
Don't make me a party to that controversy.
23.
It's a matter pertaining to granting of alternate site, my lords. My lords, if I take my lords to the order sheet, my lords have asked us to come in midway, whereby we have given the sites which were allotted in first sector. And my lords will kindly come to the order dated 18/4/2024.
18-4.
18/4, my lords.
Yes.
My learned counsel for petitioner files a memo which indicates that the properties in the vicinity of the petitioner site has been auctioned for an average of 1,32,000 per square feet. Learned counsel for BDA praised time to secure instructions in this regard. Then 23/4/2024. The learned counsel for the petitioner files one more memo indicating only the bid amount that the Bangalore Development Authority has received the auction conducted in respect of 3 sites in first sector, but also extent of the site auction. The learned counsel appearing for the petitioner submits that the petitioner is prepared to pay the average auction value of 1,83,834 per square meter in respect of site bearing number so which has been identified for allotment as an alternate site. The learned counsel for the BDA seeks time to secure instructions. Thereafter, my lords, what happens is on 15/6/2024, the BDA passes an endorsement when the matter is pending without giving instruction, coming back with the instructions, they pass an order on the representation which I had submitted to consider my allotment and rejecting my representation. That is when, my lords, I filed an amendment application which came to be allowed. Then, my lords, they have filed an objections without giving instructions or response to this. They filed an objection stating.
What is the prayer that you now seek for?
Now, my lords, what we are seeking is the setting aside, setting aside the order.
The first proposal was to consider. Now they have considered and
They have considered, my lords.
What is
Now they have considered on
AP?
15/6 after 1 year when the matter.
Annexure AP,
My lords,
page number annexure AP. Which is the,
my lords, that is 15/6/2024, my lords, page 47 of the amended petition, my lords.
page?
47 of the amended petition, my lords.
In 6/2024.
Please, my lords. This is after 1 year, my lords. 9/10/2023, I had filed it during the subsistence of the petition.
So you want me to decide on the merits as to whether this site can be allotted or not?
Yes, my lord.
Huh?
My lord, because, my lord, one thing is, we offered her a site, my lord. She is not ready to take that. We are telling if you don't want that also, we'll give in other layouts. That also she doesn't want. We are telling
Now,
in
the
that
ad-
case,
The admitted facts are that there is a site available in the very same layout.
yes, madam.
Not
Your-
available.
That is in HSR. madam.
Site that she had purchased, there is a site available,
Yes,
but
madam.
you are refusing to allot it to her
Yes.
on the ground that it is in the mutation corridors.
Not only mutation corridor, my lord, it's an auctionable site, my lord, under the auctionable site,
Please show me the.
site rules, my lord. My lord, the rules may kindly be seen, my lord. BDA disposal of corner sites, rules, my lord, disposal of corner site, intermediate commercial site, and other auctionable site rules, 1984, my lord. Definition is F, my lord. Other auctionable sites means a piece of vacant land not being a civic amenity site in the lands acquired for the development of a scheme, which having regard to its location, situation, or for any other reason, while preparing the plan of the layout has been vacant without forming sites therein, or in which sites are formed in the plan of the layout, but because of encroachment or other disputes, sites formed therein were not allotted, and later encroachments were created, disputes were settled in courts, or but subsequently considered to be unsuitable for use for residential purpose.
Under which category are you bringing this in?
My lord, under the first category only, my lord, because that site, my lord, as per my instructions, my lord, it was, it is next to a civic.
Show me the plan that was prepared at the time of formation of the layout,
Yes, ma'am.
in which this site is shown as vacant, this 1537.
Yes. This particular site was shown as.
That is what you are saying, isn't
Yes,
it?
yes, ma'am.
Please show me the plan. What you say in the representation is one thing.
Yes, ma'am.
What is being argued by you is another thing.
No, my lord, both.
What is the representation? What is the reply given in the representation, in the order?
My lord, we want to quote both these provisions, my lord. One is.
You are bound by the endorsement.
Yes, my lord.
You can't keep shifting your stand.
Yes, my lord.
The endorsement is clear. After reviewing the request, HSR, the plot of sector number 1, so and so.
Yes.
RMP 2015 zoning regulations, the plot is within the scope of mutation corridors.
Mutation corridor.
That is not the ground.
My lord, mutation
If it's in the
corridor.
mutation corridors, it does not become an auctionable site under the rules.
My lord, even this provision also, I will bring my lordship to that provision also. Mutation
You be
corridor.
sure about the stand that you take,
Yes, my lord.
because you are altering for your stand from the beginning.
No, my lord. My lord.
Say it is available, but you want it to be auctioned. Then when they come forward
No,
to
we
pay the
have-
auction
we
price,
have
you are
very
saying
much-
it is a mutation
My lord,
corridor.
in our endorsement, we are specifically mentioned it is auctionable site.
Where?
In the end, my lord.
Not it. You don't refer to this rules.
ವ್ಯಾಪ್ತಿಯಲ್ಲಿದ್ದು ನಿಯಮಗಳ ಅನುಸಾರ ಪ್ರಶ್ನಿತ ನಿವೇಶನವನ್ನು ಬದಲಿ ನಿವೇಶನವನ್ನಾಗಿ ಹಂಚಿಕೆ ಮಾಡಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಸದರಿ ನಿವೇಶನವನ್ನು ಹರಾಜು ಮೂಲಕ ವಿಲೇವಾರಿ ಮಾಡಬೇಕಾಗಿರುತ್ತದೆ.
So you are coming back to the rules. You are referring to this auctionable site rules.
Yes, both, my lord.
Make up your mind. You can't do this. ಅವತ್ತಿಂದ ಹಿಂಗೆ ಮಾಡ್ತೀರಿ ಈ ಕೇಸಲ್ಲಿ.
ಇಲ್ಲ, my lord, ಇದು ಆಕ್ಷನ್
Are
ಆಗ್ಲೇಬೇಕು
you saying
ಅನ್ನೋದು.
it should be auctioned only because in mutation corridor?
Yes.
Or is it because an auction is under the rules?
Both, my lord, because the rules.
You can't, I'll go only by the endorsement.
ಅದು
Not,
ಎರಡನ್ನೂ ಬರ್ತಿದ್ದೀವಿ ನಾವು
ಇನ್ನೊಂದ್ಸಲ ಓದಿ. Second paragraph, ತಮ್ಮ ಕೋರಿಕೆ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಲಾಗಿ HSR ಸೆಕ್ಟರ್ 1 ಬಡಾವಣೆ ನಿವೇಶನ ಸಂಖ್ಯೆ ನಂಬರ್ ರಿವೈಸ್ ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ ಹಾಗೂ ಝೋನಿಂಗ್ ರೆಗ್ಯುಲೇಷನ್ಸ್ ಪ್ರಕಾರ
ಹಂಚಿಕೆ ಮಾಡಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಸದರಿ ನಿವೇಶನ ಹರಾಜು ಮೂಲಕ
ನಿಯಮಗಳ ಅನುಸಾರ ಪ್ರಶ್ನೆ ನಿವೇಶನಗಳನ್ನು ಬದಲಿ ನಿವೇಶನವಾಗಿ ಹಂಚಿಕೆ ಮಾಡಲು
ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಸದರಿ ನಿವೇಶನ ಹರಾಜು ಮೂಲಕವೇ ವಿಲೇವಾರಿ ಮಾಡಬೇಕಾಗಿರುತ್ತದೆ.
So show me from the rules.
Yes, my lord.
That any site falling within the mutation corridor.
Yes, my lord.
Cannot be allotted, but will have to be auctioned. Under the rules.
Yes, my lord. Now, my lord, the zoning regulation along with Town and Country Planning Act, my lord, section.
So now you are giving up this auction rules.
No, my lord, we do rely upon that also, because, my lord, we are very reasonable to her, my lord. We have already told her that you take this site, it is opposite to a site, it is opposite to a 40-feet road, and a park is facing that. It's a very good site according to us, but she doesn't want to take that site also. Then we said, you take some other site, which you give us consent, we'll give you other site. She doesn't want that also. She want this site only.
Want to deny this site, though it is available.
No,
on
because
one or the
this,
other.
no, my lord, the reason is the BDA is not,
The
Yes,
first
my
argument that you made was you will suffer a huge financial loss.
yes, it will, that is why we are objecting so much.
Satisfy that. I
Yes, ma'am.
asked her to pay the auction value. Now she's prepared to pay the auction value.
Not auction value. What she's telling is not the auction value, my lord. Ours is 3 crores. She is ready to pay 1,83,000. That is SR.
The average auction value
Yes,
in
madam.
the same locality.
Not like that, my lord. What it is now auction value is fixed. We have also given our reply to her when she filed her memo.
I'll decide this on merits.
Yes, my lord. We'll definitely, my lord, we have also fixed our value. What is the auction value we have stated? And she is just going by 1,83,000. SR value ಮೇಲೆ ಹೇಳ್ಬಿಟ್ಟು ಅದ್ರ ಮೇಲೆ 50% ನಾವು ಇದು ಮಾಡ್ಬೇಕು.
Justify the endorsement, good enough.
Yes, my lord.
Justify the endorsement.
Yes, my lord.
As per the RMP 2015.
2000.
And the zoning regulations.
Yes, my lord. Zoning regulation.
So the RMP will determine the auctionability of a site according to you now.
Both, my lord, because it is shown as mutation corridor, my lord, in the plan. That plan I have produced along with my objection statement, my lord, and also marked that portion of the site where she is claiming. That is shown as mutation corridor, my lord. Mutation corridor, my lord, in the zoning regulations, my lord. I will only refer to 2 portions, my lord. 4.5.1, my lord. And it says, my lord, the permissible land use is, main land use is category 4, my lord. C4, my lord.
Regulation?
Zoning regulations, my lord. My lord, can I pass this on, my lord? 4.5.1, my lord. 4.5, my lord.
The radial corridors and main arteries.
Mutation corridors, my lord. My lord, can I? Yes, ma'am. Mutation corridors, my lord. Radial corridors and main arteries, corridors in the city are designated as mutation corridor zones. My lord, the permissible land use, my lord, that is number, small Roman number 2. Main land use is C4. Other land use permissible as main land use R1, R1 to 3, T3, U4, my lord. Main land use is C4.
When you formed the layout.
Yes.
Was this RMP in existence?
No, my lord. Because the site was always vacant, my lord, and.
When you formed the layout.
Yes, my lord.
You will form the layout in accordance with the then existing master plan.
No, my lord.
The subsequent master plan.
It is our interpretation, my lord. It is our submission before your lordship that the zoning regulations and the town, because we were the planning authority.
In answer to your submissions, I'm asking you.
Yes, ma'am.
How can you apply the 2015 zoning regulations when you have formed the sites much earlier to 2015?
But this because of over the period of time it was vacant, my lord, and in view of coming into the force of the RMP 2015.
Not answering my question.
Yes, my lord.
Prior to 2000, when was the site formed?
Way back, my lord. It is before 2000.
On that date, what was the master plan?
Yes, my lord. As per our master plan, my lord, that particular site.
You can apply the 2015 regulations even in respect of a site formed in the year 90.
Yes, my lord. Because it was vacant only.
All right.
Yes,
Next.
that is the interpretation. Because it was vacant, it came under the zoning regulations, and this particular land use should be commercial, and it will fetch us commercial value. This is one interpretation, ma'am. And the other rules, my lord, the rules which I just now quoted, my lord, which says that it should be auctioned because it's an auctionable site for us, for our. And my lord, this is the only interpretation we do want to submit to your lordship. Second aspect is her rate, which she is submitting, is the SR rate, my lord, sub-register's rate. As per our board resolution, my lord, we have to add 50% above the SR value, which will be for normal sites. Then we will the SR, and then thereafter, because we have to take the average
I've
of the.
already taken the view for your information.
Yes, ma'am.
That once an allotment is made and cancelled, it won't even become a stray site until all the applications for alternative sites are satisfied. So since you are arguing like this, I'll be forced to allot this site at the same rate as before. You're not here to make money. Your first job is to see that these allottees are given the site that you allot.
My lord, in fact, on the point
you
of.
appear to be under the impression that if by chance some site becomes available, you can make a fast buck. You are
No,
not a real estate agent.
that is not, my lord. My lord, BDA doesn't have their own source of income which does not come from
Amend
the
the rules.
government, my lord.
Amend the rules to say
And
that.
we only may, our BDA is maintained through the sale of sites only, my lord. This particular site will fetch us value as per the rules also. Therefore, we have submitted that fact. And that is one aspect, my lord. Second aspect is her rate at which she is submitting is not suitable for us, because it should fetch far more for us. We have also given our objections to her memo. And I have also submitted before the court with regard to the calculations, how we arrive at with regard to that particular site. And my lord has already stated that at the old rate, it will be allotted to her. And that is not permissible under is our humble submission to lordship. Reserved. My lord, one more point is, my lord, my lord, just one point for a lordship consideration. She is not a original allottee, my lord. She went for trial, full-fledged trial. She so purchased that site in 2015, 2016. Civil suit was pending on that case in 2015 itself. After purchasing that site, after losing the decree, then she comes back regarding the.
Then why did you accept her offer for alternative site?
And my lord, because my lord, when matter was pending, lordship, we have.
One submission, serial number 42, my lords, appear for the petitioner.
Yes.
Seek a short accommodation in the matter.
57, your lordship.
42.
Yes, ma'am.
57, your lordship.
57, I represent
Short accommodation.
petitioner.
50?
7, first, final hearing.
Ah.
Short accommodation, your
I
lordship.
represent petitioner.
ಏನಾರ ಆ ಮ್ಯಾಟ್ರ್ ತಗೊಂಡ್ರೆ KB ಮ್ಯಾಟ್ರ್ ತಗೊಂಡ್ರೆ ಮೋಸ್ಟ್ ಯಾವ್ದು ನಡೆಯಲ್ಲ.
It is regarding daily wages. I will have to seek instruction.
42.
One day, please. You lost time for the
Date-
petitioner.
date code.
Yes, sir. Junior.
Serial number 50.
Serial number,
Yeah, no, I'm not, I was just trying to take.
serial number.
Okay, thank you. So serial number 24, next matter, so serial number 24, has it gone to Monday, sir? 24, we made a mention for his last. Monday, no, sir?
Sir, I will,
Okay, so after
serial
that,
number 62.
90.
Serial number 62. Court of sir.
ಇಬ್ರು ಕೇಳಿದ್ದು ಒಮ್ಮೆ ಯಾರ್ದಪ್ಪ ಅಂತ. Sir,
Serial number 62.
Sir, 25. 25. 40.
so serial number 4 ಅಲ್ಲಿ
62.
ಸೀರಿಯಲ್ ನಂಬರ್ 4 ಅಲ್ಲಿ ಹೆಸರು ತೋರಿಸಿಲ್ಲ ನಂಗೆ ಒಂಚೂರು ಅದು ಹೇಳಿದ್ದೀರಾ? ಯಾಕಂದ್ರೆ ಮಿಸ್ ನಿನ್ನೆ ನಂಗೆ ಬಂದೇ ಇಲ್ಲ ಅನ್ಕೊಂಡೆ, ಬೆಳಗ್ಗೆ ನೋಡ್ಸ್ಕೊಂಡೆ. ಆಯ್ತು sir.
Sir, 57.
So, sir, 28.
27.
28. ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಡಿ ಸರ್. Sir, 26.
29.
Sir, 26.
Sir, 57, madam, time ತಗೊಂಡ್ರು government 57 ಅಲ್ಲಿ.
Petitioner. 25.
Sir, 57 ಅಲ್ಲಿ. Sir, 57 ಅಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ಟೈಮ್ ತಗೊಂಡ್ರು. 19th ಬಿಟ್ಟು ಎನಿ ಡೇಟ್ ಏನ್ ಹಾಕಿ? 19th ಬಿಟ್ಟು ಅದೇ ಐಒ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಬೇಕಾಗಲಿ. ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಇದೆಯಾ ಇವಾಗ?
Allowed bench matters. Serial number 1, Sri Nilopal.
Please, my lord.
Yes, Nilapan.
My lord, the petitioners, my lord, need another 15 days time, my lord, as a last chance, my lord. Because everything was ready, my lord, but some, my lord, DD was ready, my lord. Some, there are some litigations, my lord, say that will be over by next week, my lord. 15 days.
6 for 3 more weeks time to deposit the amount as agreed in the affidavit. Relist on so and so.
25th.
By which time the deposit shall be made. 3 weeks.
Please, my lord, highly obliged.
25th. For further consideration.
My lord, this case on the last occasion, the lordship has directed me to secure the presence of the IAS officer who has been appointed as a Adhyaksha to the management. My lord, he is present along with me, my lord, through VC.
Yes, what is
And
this?
please, my lord, he says that, my lord, he wants to engage a counsel, my lord, since earlier CN Harlapur used to appear on behalf of the management. And now they want to engage a counsel and to represent before the court, ma'am.
Okay. The administrator.
And he has been appointed an Adhyaksha, ma'am, not an administrator.
Somebody said he was the administrator.
No, no, my lord. The order itself is shown as he has been appointed as an Adhyaksha of that particular management, as per the government order.
The third respondent submits that as a matter of fact, he has been appointed as an Adhyaksha and not as the administrator. He is present in person through video conferencing, and he submits that he would engage the services of a counsel to represent him. In that view of the matter, relist on so and so, by which time the third respondent shall engage the services of a counsel to represent him.
25th.
Date, my lord.
25th.
Please, please.
Serial number 3, Vishwanath Padigar.
Yes.
Your Lordship, I appear for the respondent in this matter, Your Lordship.
Yes, madam. Ready, na?
Lordship, I seek a week's time, Your Lordship.
ನೀವಿಬ್ರು ಮಾತಾಡ್ಕೊಂಡು ಬನ್ನಿ ಒಂದಿನ ಯಾವತ್ತು ನಡೆಸ್ತೀರಾ ಅಂತ.
All question is, the matter is heard with the 3 judgments, 1 division bench judgment and 2 judgments of this one.
You decide as to when the 2 of you will be available. I'll have it on that particular day. ನಿಮ್ಮನ್ ಕೇಳೋದು ತಿರ್ಗಿ ಅವ್ರನ್ನ ಕೇಳೋದು, it's going up and down. Both of you decide and let my court officer know, it will be called on that date. You talk to Desai.
See, sir,
Then
in the VC, 21st will it be okay?
Sunday anta.
Sunday, sir. 21st Sunday.
Sorry, 19th.
19th.
19th. What of inform?
Madam, 19th.
Madam, 19th ಅವತ್ತು ಇರಬೇಕು. No further adjournments.
Please, Your Lordship.
My lord, one submission in serial number 2, my lord.
Yes.
My lord, our government advocates may kindly be dispensed in this case, lord, since government is not a party in the.
Since the third respondent has stated that he would engage the service of a private counsel, the name of the AG appearing in the cause list shall be deleted.
Please.
Kalburgi bench matters. Serial number 1. Ganesh Subhashan, Kalburgi.
Appearing for a petitioner.
I've spoken to the secretary at DPR. They is seeking for 7 days, 1 week, 10 days, because now the proposal is pending before the finance department.
Relist on.
90. DPN matter. Number 72.
Officer, sorry.
Did you talk to her?
Yes, Manoj, they have met the commissioner yesterday. Manoj, they have shown as to how those details that were required by us can be accessed, Manoj, to the present system itself. So I believe, Manoj, now they don't have any difficulty because they can access those details which were required. Only thing is, Manoj, I am told that they will issue a circular kind of a thing as to indicate to the, Manoj, the persons who are making that deposit, either advocates or party in person or whoever it is, as to what is the procedure to be followed. Plus that will be done from our end.
So there's no doubt in your mind.
There is no doubt as of now, no, Manoj. Nothing as such.
Doubt idea, madam, or now High Court orge. They are the ones who have
Sir, we can arrange for a formal training, sir. A manual was issued in the stage 2015. We'll update it for the report generation and also share it with them.
So I'm told that they had a discussion, so whatever doubt they had or confusion that was there must have not been sorted out.
The Commissioner of Treasuries is present before the court.
Director Treasury.
Director of Treasury is present with the court. She states that the requisite details sought for by the High Court has been provided for already in the system. She also states that an updated manual would be furnished to the High Court, and the officials of the High Court would also be provided suitable training. Shri Rajendra, Learned Counsel appearing for the High Court, submits that the manner in which the details are to be accessed has now been made known to the High Court. And the High Court would in turn be issuing a circular to the persons who are to make a deposit as to the manner in which deposits are to be made and details are to be uploaded. So, recording this statement, the matter is that we relisted on so and so to place on record the circular that is to be prepared by the High Court. Thank you. And it is to be places on record. Another manual.
All system generated reports under manual.
Same is taken on record. On that date, you produce it or close it.
Very well.
Other Sakagattala.
19.
19, Manoj, may I request for a little bit more time? 26th, if Manoj, we can see.
You should be in an anxiety.
Correct, Manoj. That will be done. Manoj, I don't want to, because I'm told that Manoj, they will have to speak to the registrar and then that procedure has to be followed.
26th.
It will be done, please.
Thanks for Namimden.
Thank you.
Procedural matter. Seal number 7.
Refund.
Only issued section 11 order for the that. But I am also not the state supply. That issue not resolved for held that not it is not applicable. They have filed rate of fee that interim would have told the state today. But not in addition to that, my contention was not the government has directed that not there shall be a rebate of 2%. Not which not the government cannot direct not that they are entitled for rebate for the payment that they make to. Not can we see not the order?
You had, I remember that this was withdrawn. Therefore, your claim was for the rebate that they had.
Yes, the notification is withdrawn. Now, there was an order of learned single judge which their challenge is pending before the division bench. Now, my lord, the issue which before my lord is with reference to whether or not the government by section 11 but can direct that
They are entitled to discount 2% out of the bills payable to me
For prompt payment.
for prompt payment. How can not the government, one just not to see section 11? So power not is very limited. You can direct supply not of power in extraordinary situations. Don't have it.
Yes.
11. Appropriate government may specify that a generating company shall, in extraordinary circumstances, operate and maintain any generating station in accordance with the directions of that government. Explanation: for the purposes of this section, extraordinary circumstances mean circumstances arising out of threat to security of the state, public order, or natural calamity, or such other circumstances arising in public interest. 2. Appropriate commission may set off the adverse financial impact of the directions referred to in subsection 1 on any generating company in such manner as is considered appropriate. Now, please turn to note the order review, which is page 52.
Yes.
So relevant portion would be page 54, bottom.
In exercise, in the circumstances explained in the preamble and in exercise of the power conferred on section 11 of the Electricity Act, the state government in public interest hereby issues the following directions with immediate effect until further orders. All generators in the state of Karnataka shall operate and maintain their generating stations to maximum exportable capacity and supply all electricity generated to the state grid, subject to the following conditions. 1. ESCOM shall pay at the rate of rupees 4.86 per unit provisionally, subject to KERC orders beyond. Therefore, my lord, the tariff has to be determined now, my lord, by KERC, which is matters pending. Now, my lord, I am concerned with clause D there. Rebate of 2% shall be allowed on the bill amount if payment is made within 5 days from the date of presentation of bill, or otherwise 1% shall be allowed if payments are made within 30 days. Now, my lord, government decides what should be the discount that, my lord, is to be given to them. But that is not the scope of power under section 11.
But this could also be a subject matter of the KRC.
No, my lord, it will not be, my lord, because my lord, if my lord should see clause A,
no, the adverse financial impact would include this 2% rebate.
No, that is why, my lord, clause A says, ESCOM shall pay at the rate of 4.86 per unit provisionally subject to KRC orders.
So
only tariff will be determined there.
No, even if this is also an adverse financial impact to you.
No, it will be an adverse financial impact, we no doubt
So
about.
they can consider this also as to whether this has to be compensated or not.
But then not the issue only would be, but KERC will not be able to sit on appeal against the order of the government under section 11. Because the scope of power of KERC is only as per subclause A herein.
Now, is it not open for KERC to say that this grant of rebate of 2% under the section 11 order has an adverse financial impact on you, even that is to be compensated?
Lord, KERC has no power to say section 11 order is wrong. It cannot say that this portion of the order.
Only decide the adverse financial impact that is caused to you, the generating company, by virtue of this direction. Now, this direction creates a further financial loss to you at 5%, 2% of the amount. So why can't that be considered by KERC?
Lord, the scope of power of KERC, Lord, under subsection 11(2), Lord, is limited to the question as to what should be the tariff fixed.
No, financial impact, not tariff, adverse financial impact.
Adverse financial
Suppose you were
impact.
able to establish that you could have sold it for 10 rupees a unit.
True.
They are giving you 486. True. The difference is what the KRC.
No, my lords are right. No, that, my lords, I'm completely, my lord, I bow down to what my lords are saying. And that's already subject matter, my lord, I'm agitating my rights there. My only concern is under this rebate clause is concerned. But KRC will not be in a position to say, I will decide whether or not. Because KRC has no jurisdiction. on this issue.
But that issue, my lord, that aspect can be, my lord may say that that issue will also be considered by the commission. But how can you pass such an order under section 11? You can only issue a direction to operate and maintain the generating station in a particular manner. Can you impose conditions regarding the rebate that you yourself will be conferred with? No, government, my lord, this order is passed by government. My lord, I am beneficiary in the sense that I get the power for the state. Now, my lord, 11 says that an order of this nature could be passed. No, my lord, Section 11 between simply says that the direction can be issued by the government. May specify that a generating company shall, in extraordinary circumstances, operate and maintain any generating station in accordance directions of that government. Operate and maintain a generating station. This power in accordance with the directions of that government. Lord, what happens is, there is 11.1, there is 11.2. No, the direction can only be in respect of operation and maintenance of a generating station. Not what? Lord, how can the government say, no, this is the rate I will pay subject to the clearance of KERC? Lord, otherwise what will happen, my lord, is it will, if that argument, my lord, is pursued, what will happen, my lord, is between the 11.1 order and deciding the adverse financial impact, my lord, there is a vacuum. Because this 11 order operates only in respect of generating stations which don't have a power purchase agreement with the utilities. There's no difference of that kind indicated in section 11. Section
It is
11
there.
General power.
No.
Issue direction to any.
No, correct. But the order itself makes it, because if there is a power purchase agreement, it my lord, does not kindly see, my lord, page 56.
But anyway, I don't think the government has the right to impose this.
Lord,
Your Lordship, I just speak to the Lordship. The appropriate government may specify that a generating company shall, in extraordinary circumstances, operate and maintain any generating station in accordance with the direction of the government. There is a scope for a government to pass.
For
the
what?
orders.
To grant rebate to yourself.
no, not.
Generating station in accordance with the direction of the government.
It is open for you to say that you will operate and maintain a particular, and the adverse financial impact will be determined by the KRC. Until then, I'll pay you so much. That I can understand. But how can you secure a rebate to yourself?
Lord, so far as rebate is concerned, Lord, this is an industry norm that either one nimsha, just for a minute, my lord, kindly see that order, government order. Lord, normally the time for payment of money under an invoice in any other normal circumstances also is 30 days.
That is a commercial transaction between two agreeing entities.
Yes.
There is no agreement here. You are forcing yourself upon the generating company. How can you import the normal commercial norms to this?
Lord, I will point out, my lord, even in tariff orders, etc. What happens, my lord, is normally, my lord, payment term is 30 days, which is not unconscionable.
This is an extraordinary circumstances.
Yes.
So even then you will impose the ordinary
No,
circumstances.
30 days is the norm, my lord, for them to get paid. Now, this rebate is only if I pay within 5 days, so that he has the benefit of that money, my lord, for the entire month. It is, I don't have that time period of.
Unless you show me statutorily that there's a time gap provided for payment, then you have no right under section 11 to avail of this benefit.
Lord, if I ask.
And you take the power from them, you are bound to pay. That the financial impact will not decide with the government because it can't decide its own cost. It's sent to the commission. But in the meantime, you impose a condition that I will also get a rebate on this.
My lord, in that scenario, my lord, the entire page 55, this entire portion of the order, my lord, if it is held to be something which is beyond the scope of 11, my lord, then the government can only say you generate and supply power to the entities so that it's available for distribution. Everything else has to be considered by the commission. So the tariff itself should go.
Literal interpretation of section 11 is what that's what it indicates. But this extraordinary situation that you are contemplating of getting a rebate for yourself, that will definitely.
No, my lord, if the government has no power to say it is, if there is a payment within 5 days of the invoice, you are entitled to a rebate, then, my lord, the government will not have any power to say that it is going to fix 4.86 also.
Yeah, it says It says so in the order. It is subject to KRC.
Correct, my lord.
Therefore,
So,
you have no
my lord,
power.
as
This is only an interim measure.
my lord, it is made as an interim measure only. Therefore, my lord, I was trying to submit last time, my lord. If 80 rupees is to be paid, there are different ways of saying, my lord, 80 is to be paid. Either it can be said that it is 80, or my lord, it is 80% of 100, or 100 minus 20%. There are different ways of fixing that particular 80. Everything means 80. Now, my lord, government, my lord, in its wisdom, as an interim measure, as my lord rightly said, fixed a tariff and said that if you pay it early, you will get a rebate subject to the decision of the commission as to what it should be. Every facet of, my lord, adverse financial impact, my lord, that they may be visited with, it will all be decided by the commission, my lord. This exercise has been done 3 or 4 times.
Does the
By-
KRC have the power to grant this rebate while determining the adverse financial impact?
No, it can.
How?
No, because whatever they show,
Whatever impact happens to them, adverse to their financial interest, will have to be compensated is the meaning of section 11(2). In that, can the KRC
what-
grant a rebate?
what has happened, my lord, is even in earlier exercises, there are many times, my lord, commission has fixed a higher rate than what is fixed by the government. Sometimes, my lord, it has fixed a lower rate.
I'm not on the
No,
rate.
in that situation, my lord, what has happened is commission has said that the amount which is not paid because of the difference in the tariff, that will be paid with interest. Lord, if today, my lord, tomorrow the commission comes to a conclusion that 4.86 had to be paid or something more had to be paid, and this claiming of rebate for prompt payment was also not something which could have been taken by these ESCOMs subject to because of the government order. Commission will pass an order to say that you pass on this amount plus interest plus what should happen to the rebate.
So, but the government had no authority to kind of grant this rebate to an ESCOM while passing an order on section 11 is what I'm trying to tell you.
No,
Commission is one thing. It is an interim measure that is made clear only. But this power to grant you a rebate while exercising the power under section 11, that will be beyond its jurisdiction is my thinking.
For that, my lord, I can only point out, my lord, is this something novel which is found by the government, or is it an industrial norm, not just the commercial thing, my lord? Even commission in its regular exercise, my lord, and in fact, the PPAs that were signed between the parties and so many orders, my lord, I have made a compilation. In all these transactions, my lord, to facilitate a quicker payment and, my lord, for immediate payment, they have, my lord, brought in this mechanism of a rebate, my lord. I can show, my lord, at least 6 or 7 instances, different my lord, instances.
You are forcing them to give you power.
Lord, that's under a very, Lord, it's like compulsory acquisition.
The normal course, they may say, I don't like your face, I will not give you power. You force them to give you power. Thereafter, you say, no, because I'm making prompt in my payment,
Interim measure.
I will get a discount.
Interim measure. Interim measure. It's just an interim
They
measure.
hold that level, this particular
Lord,
clause goes without-
kindly see, my lord, I'll try to make an endeavor to show, my lord, that this is an industrial norm. Lord, I have compiled, my lord,
Industrial norm has got nothing to do with 11(2).
no, that is what is it something?
Only on the power of the government to do this. There may be so many norms. Statutorily, there is no provision which enables ESCOMs to claim a rebate for prompt payment. This is an incentive to them to be prompt in their business. But this is an excess of power under section 11.
Lord, that's why, my lord, if it is,
Compulsory acquisition of power.
it
in
is
that you take
compulsorily
discount.
acquired, it is compulsorily acquired. The interim payment is fixed, subject to commission holding, my lord, as to what it should
That
be.
part I have no problem.
Everything else, my lord, is going to be decided by the commission. My lord, if we take that, my lord, line that, my lord, beyond passing an order for compulsorily taking power, nothing else could be done by the government. Then, my lord, the difficulty, my lord, is that interim payment tariff also cannot be fixed by the government. Then, my lord, it will lead to an incongruous situation
They are
where I
not
take
challenging-
power and they have to wait.
They are not challenging, they're challenging only this particular clause. I'll confine my judgment only to that particular clause.
Lord, that will lead
As the
to,
clause which benefits them, they've accepted, they accepted. If they're aggrieved by it, I'll consider that also. They don't seem to be aggrieved by it. They're before the KRC. This particular clause, they're aggrieved, I'll consider that.
But there is no challenge, my lord, specifically to that,
The entire order is under challenge. The specific para in
Under
the ground.
extraordinary
You want,
circumstances.
I'll ask him to file a memo restricting his claim only to that.
Lord, kindly have a look, Lord, at what normally happens in these tariff exercise.
This may be of no consequence to me.
Even in the
But you do
Lord,
normally-
tariff orders are all statutory exercises, my lord, as held by the Honorable Supreme Court. In every tariff exercise, my lord, this prompt payment rebate is something which is considered and granted. That is what has been adopted by the government also. It is in consonance with, my lord, kindly also see earlier orders that have been passed. Consistently, it has been the stand.
Tariff orders are passed on a different consideration, in a different context.
The
Suppose a
context is
tariff
this-
order in respect of a direction under section 11, which provides for such a rebate, I'll agree, because that will have statutory force. There's no tariff for the power under section 11 being exercised. No.
Lord,
So those tariff orders which relates to some other context of normal production of energy can't be imported into this.
Lord, this is also tariff fixation, although by government cannot do it because of section 62. It is only the prerogative of the commission to fix the tariff, my lord. That has been made very clear in the act. There is nobody else who can fix a tariff. Only the commissions can fix tariff. Now, my lord, this is an extraordinary circumstance where government only fixes for that particular period to say that to tide over that situation. As my lord rightly said, I am compulsorily acquiring this power. It should not be a situation where I acquire power, but I don't pay him anything because there is a vacuum. There is no PPA, there is no other norm. And 86 says that I can only take power and pay in terms of directions that are issued. Then therefore, my lord, that mechanism has been made. Now, my lord, this 2% rebate goes hand in hand, my lord, with the direction to pay 4.86. There cannot be, my lord, it cannot be disjoint. And my lord, my only endeavor is to point out, my lord, from this compilation that one tariff orders also, my lord, take such a situation into consideration, and all of them, my lord, build in this, my lord, prompt payment rebate formula into all the tariff orders. In fact, my lord, the Ministry of Power, Annexure R4, my lord, I have produced along with my compilation, considers this rebate aspect. This is an order of 15th of November 2019 at page 11. Which deals with, my lord, this reduction in cost of power due to prepayment in entire value chain of power sector.
The normal purchase. That's why I said this is more in the
If it's
of a commercial agreement whereby some incentive is granted for prompt payment. You cannot equate that situation with this kind of
Lord,
compulsory acquisition of power.
the extraordinary situation cannot be worse than normal
It
situation.
should be worse because you are now forcing somebody else's, then why do we pay solatium?
Correct. That's something, my lord, no,
Then,
my lord, both are there. Kindly see the order.
You're going to
It
acquire
is well
somebody's-
balanced.
We're going to acquire somebody's land and pass an order saying that you'll give a discount of 10% to the cost of compensation.
My lord, it is balanced in the sense, my lord, if I don't pay within time, it also contemplates interest to be paid. It is, if I pay within 5 days only, then, my lord, I get this benefit. Then, my lord, if I don't pay within the time frame, then, my lord, I have to pay interest. So they have, my lord, balanced it by providing for rebate if I'm prompt and immediate payment is made, and if I don't.
I will strike down clause D and direct KERC to consider the adverse financial impact and decide the matter as expeditiously as possible. That is all.
Not my submission, my lord, for consideration would be that this is also an aspect that could be considered, my lord, by the commission itself. Because, my lord, even I have, my lord, as my lord pointed out, in the regular, the earlier PPS that they had, they have, my lord, page 14 of my compilation, clause 5.3, very same clause is there, even in all these power transactions. Kindly also see, my lord, earlier government orders that have been passed, which I produced in 2015 onwards. They all have similar clause pertaining to, my lord, this rebate. And, my lord, in the circumstances, subsequent 11-2 orders have been passed. One such order, my lord, I have produced as Annexure R7, where the petitioners also participated with which was pertaining to government orders which had this rebate clause. my lord, they have subsumed that, my lord, so-called adverse financial impact into the, my lord, the exercise under 11.2, and orders have been passed. Therefore, my lord, this is not a novel exercise that was undertaken. And my lord, this providing of rebate is, my lord, in terms of the normal industrial practice that is followed. And in fact, my lord, Government of India, my lord, has also issued directives with regard to this developing of a mechanism for prompt payment and rebate.
Yes.
Therefore, my lord, government has taken all that into consideration in putting that condition that one, I have to pay at 4.86, and only in circumstances where, my lord, before the 30th day, if I, in 5 days, that too, within 5 days, if I pay, immediately I pay, my lord, because he has the benefit of that money, my lord, which otherwise would not be available to him. They have that way also tried to balance, because he has money in advance.
Let's assume he had a power purchase agreement with somebody for 10 rupees. Now you take away his power compulsorily and make a prompt payment within 5 days. As against the 10 rupees that he gets, you're going to pay him 9 rupee 80 paise. That is
No. This is on as an interim measure. That's what I pay, subject to commission fixing it.
You do not have that power because you're exercising 11 power, which is extraordinary. You get no benefit of a rebate. That is all. In a direction of section 11.2, you will have no power to grant a rebate.
That may, my lord, only lead to a situation where, my lord, government may not have power to even fix a rate. That will lead to a very.
This order will not come in the way of the government passing any order.
Then, my lord, then
section 11.
even for that, my lord, even then, by the same logic, my lord, for 4.86, there will be no statutory, my lord, the basis for that.
There is no challenge to other clauses. He is challenging only clause D. I'll confine
No,
the.
but that the logic on which, my lord, this will be set aside will have the impact to say that government may not be able to fix even a rate.
Speaking, if you leave it to me, I will say that they have no power. They can only issue.
But he will be the, my lord, aggrieved party so far as.
Event does not say subject to such conditions. It's a immediate power that they can exercise. Because it's a larger interest, extraordinary circumstances. The adverse financial impact, the KRC could decide either emergently or in their own speed.
Yes.
That has got no bearing for section 11. Section 11 is an emergency power.
Correct, my lord. It's a.
So for an emergency power, you
GMR power, my lord, elaborately considers it and says under what circumstances, even if it's a shortage, what kind of shortage it should be, all that, my lord, has been gone into. It's an extraordinary shortage, which will lead to collapsing of the grid possibly.
Confining it only to 11D, that D.
I can do it right away, Lord, because I will do it right away because, Lord, the other issue does not survive because, Lord, they have already withdrawn the order. The GMR order, Lord, the Honorable Court Division Bench judgment, the court that dealt with the scope of power under section 11. The issue of rebate was not subject matter there.
That is the.
Your lordship,
saying that you're confining.
Your lordship, page number 53, your lordship, kindly. 53.
Yes.
Para 8, your lordship. In the prevailing increased state demand situation, one of the options left before the government is to curtail the load to an extent of 1,500 to 2,000 MW to maintain grid stability as mandated by CERC and KERC regulations and orders. However, the curtailment of load may give rise to other unforeseen problems. Due to there is no any other option for the state government, your lordship.
I'm not, nobody is questioning your power to issue this section 11 direction. The only objection is to the rebate that you have granted.
Your lordship, operate and maintain includes.
Ashte, ನೀವು ಹೆಂಗ್ ಜನರೇಟಿಂಗ್ ಕೆಪಾಸಿಟಿ ನೀವು ಹೆಂಗ್ ಅಷ್ಟೇ ಇರೋದು ನಿಮ್ಗೆ
It is in the interest of the public, your lordship.
ಅವ್ರಿಗೆ ಅವರೇ ಡಿಸ್ಕೌಂಟ್ ಕೊಡ್ಕೊಂಡು
Only one.
I'll take the instruction, your lordship, kindly.
Lord, only one more thing, my lord, just a 1 minute, my lord, page 55, that clause, my lord, for rebate, it says rebate at 2% shall be allowed on the bill amount if payment is made within 5 days from the date of presentation of the bill. It's not from, my lord, the due date is 30 days. As indicated, my lord, in F.
You will not get any rebate is all that I'm telling.
Lord, that, my lord, my only apprehension, my lord, is that will affect the power of the government to fix the rate also.
They are not challenging. that.
Then, my lord, may kindly say that so far as fixation of rate is concerned, my lord, it's without.
If they were to make an argument, challenge that condition, that they couldn't have invoked 486. If they were to say whatever was the power purchase agreement that I had, that is to be the interim measure, not the one, not the one that the government decides, I'll consider that. They are not making that argument. They're confining the argument only to this rebate, which you already availed.
Lord, for others, Lord, for GSW, they've given 7-point order. There is a memo that they have filed before the Honorable Court.
If they were to come up with a petition saying that they cannot impose such conditions of 4.86 rupees, that's an arbitrary figure. They could not have done it. I'll consider that. They are not doing it now because you withdrew it.
No, I have withdrawn that because the government has withdrawn because that situation has gone now. It's emergency situation.
Taken the benefit, therefore.
ಇಲ್ಲ ಮಳೆ ಬಂದಿದೆ, there is power available, IP sets are running, stopped running, there, that's the situation. Lord, but I am placing before the honorable court, my lord, a situation that if that is to be the situation, 4.8, that may also be dealt with.
Manmohan makes the argument, I'll consider it definitely.
Lord, but I am making that submission before the honorable
Not
court for
you, you're not the
consideration.
petitioner, he is the petitioner, isn't it?
He is the petitioner, but my submission, my lord, is that the consequence of that would be that 4.86 can also not be fixed. That also may be taken into consideration.
2:30 PM matters.
Please.
Number 73.
Can I
Lordship
file
will take next week take the instruction regarding that
ಬೇಕಾದ್ರೆ written arguments ಹಾಕಿ.
under section 11.
Written arguments ಹಾಕಿ ಬೇಕಾದ್ರೆ.
73.
Please.
ಹೇಳಿದೆ, ಬೇಡ.
Lord, I will pass on the memo to the court officer Monday.
Give a copy to them also.
Yes, I'll give it. Please.
Reply to this.
In the other matter, this is not, Revala sir is there. Anyways, my lord, if lordship's permit, my lord, that could be taken up instead of this. Lordship's permit.
We are okay, Your Lordship.
Whatever you, who's to, Mr. Walla was supposed to give a reply.
ಅಲ್ಲ ಅವ್ರದ್ದು
He has to reply. He has
ಅಲ್ಲ
filed in-
ಅವ್ರದ್ದು
he has filed in
ಏನ್
additional-
ಸಂಬಂಧ ಇದೆ?
Let
It's a
me
different
submit. He has filed additional statement of facts in this matter. We are filing a reply to that. And then it's for his submissions, Your Lordship.
That is the challenge to the central government rules.
No, in Soham matter, Holas's matter, there's no challenge to the central government. I'm talking about Soham.
Sir, I believe that central government rules.
Yes.
He is
yes.
arguing on the central
Yes.
government. Yes.
Adರಲ್ಲಿ, lordships may see, my lord, they have filed an objection. Now, in the before your lordships,
Who has filed objections?
ಅದೇ central government has filed objection.
Mention ಮಾಡಿದ್ರು, file ಬಂದಿಲ್ಲ ಅಂತ.
ಇಲ್ಲ ಪರವಾಗಿಲ್ಲ, ಅದು ಇದ್ರಲ್ಲಿ ಬೇಕಾದ್ರೆ ತಗೊಂಡು ಅಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಕಾಪಿ ತಾವು ನೋಡಿ ಸರ್. ಅದು ಯಾವ್ದ್ರಲ್ಲಿ ಬೇಕಾದ್ರೆ.
Let's hear. Didn't come as to come and after the matter. He's on his legs.
ಅದು-
It could be pass over and.
ಈಗ before your lordships, my lord, hears this matter, they are not giving open access in any of the matters. And there are 2 sets of interim orders operating, my lord. ಅದು ಯಾವ್ದು ತೋರಿಸಿ.
What does the central government say regarding the rulemaking power?
Yes, lordships may see, my lord, they say that the power of the central government is not under the electricity, not under the constitution, so not under the normal provisions of list 3, but they have signed some international covenants and agreements. Central government. Copy.
It will pass over and because he'll come, he's on his legs. I'll just. It's very difficult.
Well, in the meantime, my lord, in the meantime, it could be taken up any other day also, my lord, I have no objection. They are not giving open access at all. Lordships may see, my lord, in the connected matter that my learned friend appears, there is an interim order passed by this honorable court. In my case, my lord, the direction is not to precipitate. They are not giving open access at all. I have signed the GOA agreement. I brought it to the notice of my learned friend. They say, my lord, ನಾನು phone ಮಾಡಿ ಹೇಳ್ತೀನಿ ಅಂತ. Even to this date, my lord, there is an interim order. Lordships may see, my lord, the
Please wait.
ಅಲ್ಲ writ petition ತೋರಿಸ್ತೀನಿ, interim order ತೋರಿಸ್ತೀನಿ.
ಅವ್ರು ಹೇಳ್ತಾರೆ ಕೇಳೋಣ ಇರ್ರಿ.
Your Lordship, to my instructions, wherever there is an interim order is being followed and open access is being allowed. Just 5 minutes back, he informed me that in one of the matters, open access is not being allowed.
None of
I'll have to take instructions. I'll have to seek clarifications. If they are not allowing, for what reason they are not allowed.
I'll pass it over, get instructions.
Yes, I'll get it.
what lordships may allow me, my lord, why they are not allowing is in 16088. I'm just making
Your Lordship,
my submissions.
I've got the.
ಮುಂಚೆನೆ ಪ್ರಿಯಂಟ್ ಮಾಡ್ತಿರೋದ ನೀವು.
ಅಲ್ಲ ಒಂದ್ರಲ್ಲಿ ಒಂಥರ interim order
May I
ಇದೆ,
submit?
ಒಂದ್ರಲ್ಲಿ ಒಂಥರ
Allah,
ಇದೆ.
Allah, may I submit? The matter that is referring to Godawat, we have data to show that they are willing. Wheeling is being allowed, open access is being allowed.
ಇಲ್ಲಪ್ಪ, ಕೊಡ್ತಾ ಇಲ್ಲ. Why will I make that
Now we
submission,
actually
my lord, if I have to?
I'm on
ಇದೇ
instructions I'm
problem.
stating.
Lordships
I
may
can
clarify
show
in the
through
order.
data, I can show through data that wheeling is being
Today
allowed.
they are
open
not
access
allowing
being
is
allowed.
what I am submitting, my lord. Today, the client is, my lord, in the SLDC.
After inform me, we just took instructions from the client. Client has informed us that they are wheeling the energy for Godavari. They have not stopped them.
BESCOM is not processing the bill, my lord. That's what I'm saying. The BESCOM, my lord, is the ultimate authority where open access is granted. The bills have to be adjusted, my lord. Ultimately, OM, it is something is known as, my lord, OM. It is not being done, my lord, is my submission.
Wheeling ಮಾಡಕ್ ಬಿಡ್ತಿದ್ರೋ ಬಿಡ್ತಿಲ್ಲ?
ಅಲ್ಲ, ವೀಲಿಂಗ್ ಮಾಡಕ್ ಬಿಡ್ತಾರೆ ಸರ್, ಅದ್ರಲ್ಲೇನಿಲ್ಲ. ಅದು ದುಡ್ಡು ಅಲ್ಲಿ OM ಅಂತಂದ್ರೆ ಅಲ್ಟಿಮೇಟ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್, my lord. The bill has to be adjusted. The GOA charges are being collected is what I am submitting.
What is his grievance regarding this billing?
BESCOM, ತಡೀರಿ, don't finish.
Allah,
The
he
fact
asked
is,
me-
my lord,
Allah,
the
your lordship
BESCOM,
asked
I'm
me-
sorry, my lord, I'm saying, my lord, the BESCOM is the ultimate authority, my lord. I am the consumer of BESCOM, my lord. The wheeled energy has to be credited in my bill, and bill has to reflect that the wheeling has been done. Permitting wheeling in the sense, my lord, in a notional sense, the power is flowing. No doubt, they are allowing the power to flow. The bill at the final financial adjustment is not happening. I am only saying, my lord, this.
Let me ask him now.
Yes.
You can sit down for 2 minutes. Let him also.
Yes.
Your lordship, in these matters, we appear for KPTCL. The wheeling and the billing that he's talking about is done by BESCOM. We don't represent BESCOM. Nevertheless, we've sought instructions from BESCOM. They said they are doing everything that they are required to be done under law for open access. But if they're saying some fine,
Including the billing problem that he is saying.
I'll just, specific to the billing problem, I'll just take instructions. It may be passed over by 5-10 minutes, your lordship. I'll take instructions.
In the meantime, my lord, even if it may be taken up on some other day, my lord, if the file itself has not come, and I am ready with the arguments, whatever your lordships.
Yes,
I have no problem in hearing the matter today or
Yes,
some other day.
I am also, my lord.
You are the one who is jumping up and down because.
Your
of
lordship,
the interim order.
Jump.
Therefore, I am taking up this.
No,
matter
no, my lord.
without-
No, my lord. I am only saying, my lord, the file has not come. I am not in the, but in the meantime, the problem is, my lord, may I point out again at the cost of repetition, in one set of writ petitions, one set of interim order is operating. The query seems to be, my lord, from BESCOM.
I expressed my mind openly to you.
Yes,
My intent is to dispose it of finally.
please,
Not consider interim prayers. Therefore, this Friday was fixed.
once and for all.
If
Yes.
they were to argue,
I am
consider
ready, my
all
lord.
them.
I am ready to address the arguments, my lord. Kindly have the objection statement. Let them argue their objections, my lord, or I can address the. ಅಲ್ಲಿ ಪ್ಲೀಡಿಂಗ್ಸ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ. ಅದರಲ್ಲಿ ವಾಟ್ ಎವರ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇಸ್ ಆಪರೇಟಿಂಗ್, my lord, if a uniform interim order is passed, BESCOM or nobody else will have any issues, my lord. I am saying they have a correct, ನನ್ನ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಪ್ರಕಾರ ಇಲ್ಲಾಗಿದೆ. ಅದೇ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಅವರು ಈಗ ಮಾಡಿಫೈ ಆಗಿದೆ, ಅದು ನೋ ಪ್ರೆಸಿಪಿಟೇಟಿವ್ ಆಕ್ಷನ್ ಅಂತ ಹೇಳಿದ್ರು, ವೀಲಿಂಗ್ ಮಾಡೋ ಅಂತ ಎಲ್ಲಿದೆ, ಬಿಲ್ಲಿಂಗ್ ಮಾಡ್ಬೇಕಂತ. ದಿಸ್ ಇಸ್ ದ ಡಿಫಿಕಲ್ಟಿ, my lord. I am not finding fault or, my lord, saying anything else. In one set, there is clear saying that the demands are stayed, my lord, in Lund Senior's case, which is based in turn on my case, as it then existed. The interim order then existed. Then, my lord, lordships modified. That interim order is not modified. In my set, ನೋಡಿ, ಅವ್ರದ್ದು modify ಆಗಿಲ್ಲ, ನಿಮ್ದಾಗಿದೆ, ನಿಮಗೆ ಕೊಡೋದಿಲ್ಲ. This is only the difficulty. I am not saying anything.
You have to conclude the arguments today.
Yes, I will.
Till
If
I
your
pronounce the
lordship,
judgment.
sorry, my lord.
If you conclude the arguments
I
today.
will.
Pass an interim order or an interim arrangement in all the matters till I pronounce the judgment.
ಅಲ್ಲ, ಫೈನಲ್ ಮಾಡ್ಬಿಡ್ತೀನಿ.
Your lordship,
Because
50%,
lordship,
your
it
lordship
fell
had
to me, my
indicated
lord,
last time that 50% of the transmission charges are to be paid. For 6 months, they've not paid. Balance of equity requires that they pay
I
something
will
at
address
least.
that. I'll address that. First, my lord, lordships may see
And-
the objections filed by the.
Before he starts, my lord, it may be difficult for, because he's held up in other matter.
ಅದೇ,
where
ಅದಕ್ಕೆ
he's
ನಾನು
like, so
I will conclude the
Lordship
arguments
start-
from my side. I will not. Yes,
No,
lordships.
This is only on the interim arrangement now.
ಅಲ್ಲ, ಬೇಡ, ಫೈನಲ್ ಮಾಡ್ಬಿಡಿ, ಮುಗಿಸ್ಬಿಡಿ. ಅಲ್ಲ, ಏನಾಗುತ್ತೆ?
Interim arrangement ಮಾಡ್ಬೇಕು ಅಂತೀರಾ?
ಅಲ್ಲ, ನಾನು ಫೈನಲ್ ಆಗಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ನಾನು ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟೇ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ನಾನೇನು ಹೇಳ್ತೇನೆ.
Please get him.
He's on his legs, my lord, I just.
On set copies today, I'll have it at 4 o'clock. Ask him to come at 4 o'clock.
Your lordship, I just got the instructions from BESCOM. They are doing wheeling. Last month, what happened is, more than their schedule, they took power from the grid of BESCOM. Their consumers withdrew excess power from the grid of BESCOM, and that is the reason why they have not done billing, not given the accounts for them, because they have not violated the terms of wheeling and banking agreement, not because of any other reason. Wheeling and banking agreement is there, and we are fulfilling it as per the interim order of this honorable court.
ಇದು ಕಿರಿಕಿರಿನೇ ಬೇಡ.
Beda, so we can.
ಕಿರಿಕಿ ಅದು ಸುಮ್ಮನೆ, it will be oath against oath, my lord. Therefore, I am. Now,
I am ready to argue the matter, my lord. Lordships, the objections are before your lordships. I'll argue the matter on the rules. The objections are filed, my lord, and served on us on Lord 4/7/2024, which your lordships have.
Yesterday.
And the objections say,
So I make one request, my lord. But what my colleague is telling, my lord, it's be taken up at 4 o'clock. But my request is this, my lord, we have filed a counter in only one matter, my lord. The other matters also we need to file our counter. Sir, one ನಿಮಿಷ.
ತುಂಬಾ ಅವಸರ ನಾನು ಏನ್ ಮಾಡ್ಲಿ ಅವ್ರು. He's always in a hurry.
Therefore, my lord, by Wednesday, my lord, we'll complete all our pleadings, my lord. Wednesday, can it be taken up, my lord, subject to your lordship's convenience?
But what about he'll ask for an interim arrangement? That is a problem.
That's already there.
It's already there, my lord. We are not asking anything extra. We are ready to conclude the arguments today itself.
Then
We are going down to whatever lordships.
Already there? Interim order is
I am
okay.
It should not be seen as.
They are not ready, I can't force it.
ಅದೇ ನಾನು ಅದಕ್ಕೆ ನನ್ನ anxiety is that my lord, lordships are inclined to dispose of the matter. We are not cooperating. On behalf of all of us, my lord, I am anxious. I am not anxious, my lord. I have nothing to lose.
I'm not available next week. I'll have it on the 19th.
ಆಗ್ಬೋದು.
List on 19th.
ಅಲ್ಲ ಈ ತರ ಒಂದು interim
Lordship,
order ಮಾಡಿ ಅದು ಸುಮ್ಮನೆ
50% let them pay your lordship by the.
No, no.
Let them pay something, your lordship.
Argument.
ಅಲ್ಲ, ನಮ್ ಕಡೆಯಿಂದ ನಾವ್ ರೆಡಿ ಇದೆ.
ಸರ್ಕಾರದವ್ರು ಕೇಂದ್ರ ಸರ್ಕಾರ
ಅದು ಅವ್ರವ್ರು ಮಾಡ್ಕೋಬೇಕು. That is their lookout.
Lord, let it be taken up at 4:30, my lord. 4:30. Will, Leonard ASG is up here.
Grateful.
Grateful.
And your lordship. Your lordship, there is one batch of matters here where the other side advocate is also present, and similar matters were disposed of by a coordinate bench with a direction to KERC to determine the transmission charges having regard to the forum of regulators appointed by central government. Under the central government rules, transmission charges and the wheeling charges are to be determined after consultation with the FOR. FOR is forum of regulators. KERC had passed transmission charges as an interim measure in the tariff order. They had challenged that. It was challenged before this honorable court. This honorable court directed KERC to look into the FOR rates determined by the central government and then decide transmission charges. In the interim, whatever charges KERC has decided that are to be paid. So, those orders have been passed in 3 similar matters by this honorable court. My learned friend is there for the other matters. This is in serial number 74,
74,
75.
78.
This applies to all the cases?
78. No, he is not challenging GOA rules or the regulations. He is trying to further the central government rules which say that wheeling charges should be as per the FOR.
We don't have anything to say in this.
No,
right?
no, he is not pressing on it.
ನಾನು ಯಾವ ಮಂತ್ರಲ್ಲೂ ಇಲ್ಲ.
Okay. 94 ಈ ಎಷ್ಟು ಈ ಲಿಸ್ಟ್ ಗೊತ್ತಿರೋ ನಮಗೆ ನಾವೇನು ಆನ್ಸರಿಂಗ್ ಇಲ್ವಾ? ಆಯ್ತು.
So this is at 1,60,000 per megawatt.
Yes, yes. They are paying also. The other generators are paying also. So in terms of that section, serial number 74, 75 and 78 may be disposed of.
70?
475 and 78.
I think it's covered by this decision.
74?
75, 78.
Both learned counsel submit that the issues raised in this petition are covered by the decision rendered by a coordinate bench of this court in WP 27505/2023, in which this court ultimately passed an order in the following terms. In the light of this submission, these writ petitions are disposed of in the above mentioned terms. 74, 75 and 78.
78, yes, sir.
May I make one submission for consideration? Because my learned friend was saying 19, ನಂದ್ರಲ್ಲಿ pleadings complete ಮಾಡಿಲ್ಲ, ಅವ್ರ ಕಾಪೀಸ್ ಎಲ್ಲ ಕೊಟ್ರೆ I will look into it. 19th ವರೆಗೂ interim order extend ಮಾಡಿ 19th final disposal ಇಡಿ, ಯಾರು adjournment ಕೇಳಲ್ಲ.
But if everybody else is paying transmission charges, by virtue of an interim order, only you, this batch of petitioners are not paying transmission charges, that will not.
Paying as per the old,
As per old, there were no transmission charges.
So this, if you are
demand
pre-
notices are
if you are
stayed as of
prepared-
now.
If you are prepared to pay 50% transmission charges, till the 19th, I'll grant an interim order.
There is already an interim order staying the.
The matter will be heard today, even regarding that. That's why it was posted today.
Yes, my lord, but copies ಏನು
I made
ಕೊಡ್ತಾ
it clear to Sridhar also that there will be a condition imposed. I'm not going to allow transmission charges without payment of transmission charges for you to.
ಇಲ್ಲ ನಮ್ದು ಇವತ್ತು ಫಸ್ಟ್ ಟೈಮ್ ಅದು ಟ್ಯಾಗ್ ಆನ್ ಆಗಿರೋದು.
ಎಲ್ಲರಿಗೂ ಅದು ಒಂದೇ
ಇಷ್ಟು
ಮಾಡ್ತೀನಿ.
ದಿವಸ ಬರ್ಲಿಲ್ಲ.
ಎಲ್ಲರಿಗೂ ಒಂದೇ ಮಾಡ್ತೀನಿ. I am not going to make.
ಅಲ್ಲ, I can understand there should be consistency, but ನಮ್ಗೆ pleadings ಇಲ್ದೇ ಇದ್ರೆ I am handicapped ಅಲ್ವಾ?
No, this is only for the interim arrangement. Right now, all of you are having access, you injecting energy into the grid. But none of you are paying transmission charges.
Yes.
So my statement last time was, I'll put you on terms. You will not be able to do it free of cost. That is all.
May I make one?
So I'll make that interim arrangement that till the next date of hearing, all of you, all the petitioners who are injecting, who are having open access will pay 50% of the transmission charges that has been determined by KRC for non-renewable energy projects.
My lord, the problem is this. We have been having this order since 7-8 months. Final
That's a
dis-
benefit.
Final
That is a
dis-
benefit.
Final disposal ಗೆ ರೆಡಿ ಇದ್ದೀವಿ.
ನಾನು
Pleadings
ready
complete
ಇದ್ದೇನೆ.
ಮಾಡಿದ್ರೆ.
ನಾನು ರೆಡಿ
I
ಇದ್ದೀನಿ.
know ತಾವು ರೆಡಿ ಇದ್ದೀರಿ, ಯಾವಾಗ್ಲೂ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. Pleadings ನೋಡಿದ್ರೆ at least to look into it, I should get a little time ಅಂತ ಅಷ್ಟೇ.
I will grant you time, but subject to that condition only.
ಇಲ್ಲ ಇವತ್ತು
That-
ಮುಗಿದೇ ಇದ್ರೆ ತಾವು ಮಂಡೇ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀರಾ.
ನಾನು
At least
next week-
ಅವಾಗಾದ್ರೂ.
Next week I'm not available. If it's not going to be heard today, I'm going to pass an interim order in those terms. Till I pronounce the judgment also, it will be on terms that you will pay transmission charges at 50%, subject to my final decision.
ಅದೇ ಬೇಡ ಅಂತ ನಾ
May I
ರಿಕ್ವೆಸ್ಟ್
make one
ಮಾಡೋದು.
request, my lord? Lordships, my lord, there are two other matters. The one in which he has filed objections is not before your lordships. And there is one more matter. Even if that common order is to be passed with 50%, it may again, my lord, create a rift where they will continue with they are my own matters.
I will get those two matters
Also, my lord, that's what I'm saying.
I'll get it at 4:30 and pass
Ah,
it on. But this is the order that I'm going to pass, is what I've expressed.
I'm, Lord, I bow down, but I'm just saying, Lord, against my own interest, I'm saying those matters also. In one matter, my lord, Vrindavan, I may have to argue, my lord, for a little while regarding the banking issue.
Come at 4 o'clock.
4 o'clock.
Great.
E-group matters. Bill number 27.
My lords,
Bill number 27.
Yes.
my lords, the matter has been entrusted to some other advocate. I request for deletion of name of Sumana Naganand.
ಯಾರಿಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಮಾಡೋದು ಗೊತ್ತಿಲ್ವಾ?
Uttur Padmavati.
It is stated
Uttur
that
Padmavati Suresh.
the matter has been entrusted to Padma Sutur alva? Padma Sutur. Give forward. In that will matter the name of Sumana Naganan.
Grateful, my lords.
Padma Suttur. Jagan Mohan MT. 2829 Adjournment, seal number 30. Yeshagiri Ram.
My lordship, I appear for the petitioner in this matter. Additional document file ಮಾಡಬೇಕು ಸ್ವಾಮಿ next week any date my lordship please.
4ನೇ ಸಲ 5ನೇ ಸಲ ಟೈಮ್ ತಗೊಳ್ತಾರೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ next week please my lord.
19. Number 31 Adjournment, seal number 32. Satish Chandra.
This matter, senior counsel is engaged, he is held up in this matter. Passed over or not given date?
Released.
19.
19th, please.
Number 34 and 33 and 34 Adjournment, seal number 35. Certain only.
ಅಮೆರಿಕ ಹೋಗಿದ್ದಾರೆ.
Number 36, MR Rebate. MR Rebate. Well, 37 urgent, C number 38, Sri Sampath Anand Shetty.
Think for respondent 1 and 2. Kindly pass over, my lord. Scenery, sir.
Realist.
Thank you. C number 39 urgent, C number 40, Sri N Basurajaya. N Basurajaya.
I appear for the rest. Realist.
41 and 42 urgent, C number 43, Chandrasekhar C.
Realist.
C number 44, Sri Srikanth B.
Yes.
Blood. Last date of hearing, philosophy directed the respondent to get the report of that.
See, what
The respondent is not provided the electricity connection.
Then a power line ಕೆಳಗಡೆ height.
That where that construction is made under the line, let that regulation 41, let that 61, there is a bar even construction of it, let that. In order to let that avoid the electrocutions, accidents, let that the power supply has not provided. Where let that high tension line maintained by the KPTCL. That we need that from the no objection from their side. Because of they are maintaining, let that high tension line, let the, under the regulation, let that their violation in that construction was made. Under those circumstances, that way that it is the KPTCL given a, they have constructed under the line. That is not permissible under regulation 61/1 of the regulation. That is the endorsement which has been given by Hazen as per annexure that page 26, August 2020. Let the may permit me to pass on the photographs. Where that line.
Page number 26.
26 is the communication similar that the endorsement which has been challenged now.
Next
Page number 30. Annexure D. C, annexure C.
Yes.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತಾವು ಕಟ್ಟಿರುವ ಹೊಸ ಕಟ್ಟಡಕ್ಕೆ ವಿದ್ಯುತ್ ಸಂಪರ್ಕ ಕೋರಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು, ತಮ್ಮ ಕಟ್ಟಡವು 66 ಕಿಲೋವ್ಯಾಟ್ ವಿದ್ಯುತ್ ಪ್ರಸರಣ ಮಾರ್ಗದ ಕೆಳಗಿದ್ದು, ಕೇಂದ್ರೀಯ ವಿದ್ಯುತ್ ಪ್ರಾಧಿಕಾರದ ಸುರಕ್ಷಾ ಮತ್ತು ವಿದ್ಯುತ್ ಸರಬರಾಜು ಕುರಿತಂತೆ ನಿಯಮಾವಳಿ 2010-61 ಈ ಪ್ರಕಾರ ಯಾವುದೇ ಕಟ್ಟಡಗಳು ಹಾಲಿ ಇರುವ ವಿದ್ಯುತ್ ಮಾರ್ಗಗಳ ಕೆಳಗೆ ನಿರ್ಮಿಸುವಂತಿರುವುದರಿಂದ ತಮ್ಮ ಕಟ್ಟಡಕ್ಕೆ ವಿದ್ಯುತ್ ಸಂಪರ್ಕ ಕಲ್ಪಿಸಲು ಸಾಧ್ಯ ಇರುವುದಿಲ್ಲ ಎಂದು ಈಗಾಗಲೇ ತಿಳಿಸಲಾಗಿದೆ. ಹಾಗೂ ತಾವು ತಿಳಿಸಿರುವಂತೆ 2009 ನಂಬರಿನಲ್ಲಿ ವಿದ್ಯುತ್ ಸಂಪರ್ಕ ನೀಡಿದ್ದು, ಆಗಿನ ನಿಯಮಾವಳಿ ಪ್ರಕಾರ ತೆರವು 3.7 ಅಥವಾ ಪ್ಲಸ್ 0.60 ಮೀಟರ್ಗಳಷ್ಟು ಬೇಕಾಗಿದ್ದು, ಅದರಂತೆ ವಿದ್ಯುತ್ ಸಂಪರ್ಕ ಕಲ್ಪಿಸಲಾಗಿದ್ದು ಹಾಗೂ 2007ರಲ್ಲಿ ತಾತ್ಕಾಲಿಕ ವಿದ್ಯುತ್ ಸಂಪರ್ಕ ಕಲ್ಪಿಸಿದ್ದು, ಅದು ಸಹ 2010 ನಿಯಮಾವಳಿಯಂತೆ EHT ಮಾರ್ಗಗಳ ಕೆಳಗೆ ಕಟ್ಟಡವನ್ನು ನಿರ್ಮಿಸದೇ ಇರುವ ಷರತ್ತುಗಳು ಒಳಪಟ್ಟು ಕಲ್ಪಿಸಲಾಗಿದ್ದು ಹಾಗೂ ಇವು EHT ಮಾರ್ಗಗಳ ಕೆಳಗೆ ನಿರ್ಮಿಸುತ್ತಿರುವುದು ತಿಳಿದಾಗಿ ಅದನ್ನು ಸಹ ಕಡಿತಗೊಳಿಸಲಾಗಿದೆ. ಆದ್ದರಿಂದ ನಿರ್ಮಿಸಿರುವ ಕಟ್ಟಡಕ್ಕೆ ವಿದ್ಯುತ್ ಸಂಪರ್ಕ ಕಲ್ಪಿಸಲು ಸಾಧ್ಯವಿಲ್ಲವೆಂದು ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ. That regulation that very clear.
Is it a fact that for the adjoining houses, you have provided for electricity?
The adjoining, that power supply has been provided. Where that in my statement of objections, I given a tabular form. Earlier to 2010 regulations, where 1956 rules was in existence, that where under the vertical and horizontal clearance were required. That has been maintained and given.
No, but his construction was existing earlier under the
The earlier which was there, RR number was there.
Has only demolished and reconstructed.
He has demolished, surrendered. He has reconstructed building.
So the installation was serviced prior to 2000.
Prior to, there was an existence.
So whatever existed then will apply to him.
But that is not,
Pending his surrender and restoration after construction.
that has been surrendered. Then
Correct.
that you have while temporary.
Been surrendered to put up a new construction.
Yes.
Which you have accepted. On reconstruction, you cannot deny him the power. By taking recourse to the new regulations.
That taking new course, new regulations, that as on the date when the application was filed, new connection.
The surrender was to get a new connection after it was constructed. Therefore, he is bound by the earlier regulations under which you granted him power. If he is entitled for power under the old regulations, as has been done to his neighbors, you will continue the same, notwithstanding a surrender.
That has been surrendered, that is dismantled.
Notwithstanding a surrender and a fresh application,
Yes,
you will govern him by the earlier regulations.
that is not applicable as on now, that it is that earlier rules which has been.
ನಾನು ಹೇಳ್ತಿರೋದಲ್ಲ ಅವ್ರು ಫಸ್ಟ್ ನೀವು ಕನೆಕ್ಷನ್ ಕೊಟ್ಟಿರೋದ್ರಿಂದ ಅದೇ ರೂಲ್ಸ್ ಅಪ್ಲೈ ಆಗುತ್ತೆ even if they had surrendered and they adopted new connection. It is not a fresh connection that you are giving.
No, the fresh connection there.
It was surrendered and restored because of the construction being demolished.
Once it has been surrendered, that installation, all that has been seized. So
I'll consider that. Ashadane.
that is not in his name, that is a vendor which has been there.
Correct.
Subsequently has purchased.
If you had not demolished and reconstructed, you would have continued the power supply.
That too in the earlier installation, which is one good continue.
You are reading between the lines. Ashadane.
That is so far as that other grounds which has been raised, so far as the neighbors which have been granted. I specifically stated in my statement of objection para 12, which were in earlier that regulations.
I will note that that will be gone by the earlier regulation. That is all. So you will continue. Nimgu tondre agala, avungu tondre agala. I'll protect you by saying that you will apply the old regulations because it was an existing construction earlier which was serviced under the old regulations.
That
Merely because he has surrendered and obtained a fresh connection does not mean that the new regulations are applied.
even if any that it is happens, that is irresponsible, that it can't be a shift that liability on the company, sir. That because of that he has constructed in violation without obtaining plan. Without obtaining plan.
ಏನಾರು ಆದ್ರೂ ಈ ಕೋರ್ಟ್ ಬಂದ್ಬಿಟ್ಟು 5 ವರ್ಷ ಜಗಳ ಆಡಿದ್ರೆ
ಅಲ್ಲ ಅದರಲ್ಲಿ again that it is asked for compensation, all that liabilities has been. That is the why that earlier that there was a rules. That now that is the why restrictions which has been given. Not to that it is in a construct in the buildings.
These facts are not in dispute. The petitioner purchased a property which was provided with an electricity connection by RR number S9LG2.
Yes.
Correct, Tane?
ಹೌದು.
This connection was obtained by the vendor of the petitioner when he had constructed his house. In the year 2014, the petitioner purchased the house which had already been serviced with an electricity connection. And he thereafter proceeded to demolish the building and erect a new structure in its place. To facilitate this, he surrendered the existing electricity connection. And after completion of the construction, he sought for restoration of the earlier electricity connection by making a fresh application. Bescom has rejected this application on the ground that though the earlier construction had been serviced with electricity, there had been a change in the regulations in the year 2010, which prevented Bescom from giving electricity connection to the structure in question since it fell under a high tension power line. Being agreed by this endorsement, the petitioners before this court. Next one. Since it is not in dispute that the petitioner had purchased a property which contained a structure with electricity connection, the mere fact that he demolished it and reconstructed it would not ipso facto make the new regulation applicable. What is to be noticed is that essentially the petitioner had surrendered his electricity connection temporarily so as to put up a fresh construction. And on the fresh construction being made, it is but normal and inevitable that the electric supply that the building already had should be restored. In intervening circumstances of a new regulation cannot deprive such a property from denial of electricity, especially on the ground that there are no new regulations brought into force. Next paragraph. It is also pertinent to state here that it is a specific case of the petitioner that the houses abutting his house have been provided electricity connection notwithstanding the new regulations. And it is only the petitioner's house which has been denied electricity connection solely on the ground that it is a new construction put up after 2010. To this, BESCOM responds by stating that the houses abutting the petitioners were serviced prior to 2010 and therefore the present regulations cannot be applied. As stated earlier, since the petitioner had purchased a property which was already serviced with electricity, the mere fact that the petitioner chose to demolish and put up a new construction would not make the new regulations applicable. The petitioner, having had the benefit of an electricity connection earlier, would be entitled to the regulations as it stood prior to his purchase, and the new regulations cannot be made applicable to him. The impugned endorsement is therefore quashed and the writ petition is allowed. A direction is issued to the BESCOM to provide electricity connection to the petitioner as had been done to the earlier structure which existed on the property.
The new connection has to be provided. Once that has been
I have
surrendered,
interpreted that saying that it's a restoration, not a new connection.
that is not permissible under the regulation. Even once demolition is made, surrendered, all dismantled. The reason
I
that
have already held that it only amounts to restoration, it does not amount to a new connection.
that the reason why that the earlier which has been sanctioned for the shed, which in 1 kilowatt, that he has constructed more than the 2 floors, where the sanction load requires that is a more than that he has to comply all rest of the things that it is requirement of deposits, all those things. That even if that the installation once surrender, it cannot be that restoration because of all dismantle is happening.
Said according to me, it is restoration. It can't be considered a new connection. If you are putting up a connection for the first time, what you say is correct. If there was already existing structure which he had electricity, merely because he demolished and reconstructs, you cannot impose a new policy.
The new policy for the purpose of high tension that it is restrictions are concerned. For even processing the application for sanction power supply, where that earlier 1 kilowatt is there. The deposits which is that has been adjusted all that it is over, that agreement has been terminated. The new connection when he sought, that is requirement more than that is concerned. What is the regulation for existence for deposits, securities, agreement, all these process has to be followed.
The petitioner shall abide by any conditions which are necessary for securing the power connection, such as payment of security deposits, execution of agreements, etc.
Yes.
See number 45, Sridhar Prabhu.
Sorry, madam, serial number 40, madam, your lordship has already heard the matter. Madam, only the government, madam, has to reply. They have deposited the amount to the government, but it has to be refunded. Excess amount, madam, as per the order of this honorable court, the royalty amount is.
I'll file detailed objections, your lordship.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಏನಿಲ್ಲ, ಯಾಕೆಂದ್ರೆ ಅವ್ರು ಹೇಳೋದು ಅವ್ರಿಗೆ ಆಲ್ರೆಡಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀವಿ
I'll file my objections, your lordship.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡಿ next week, because
I am not sitting.
26, sir. 26.
See number 45, Sridhar Prabhu.
In this case, I appear for the respondent. I have to secure the information at the time. I have to secure the information. I have to file objections.
26. 46 adjourned. See number 47.
My lord, in serial number 45, there was an interim order kind of, that may be extended.
46, sir.
45.
Yes.
Number 47, see Ramesh Kumar Arvi. 48 adjourned. See number 49 adjourned. See number 50, Sridhar Prabhu.
Yeah, my lord, for the respondent.
Yes.
Now, this is the prayer, my lord, here is for payment of late payment surcharge. The claim of my learned friend is that LPS is due and payable for under 3 heads, one under the PPA and 2 others under the LPS rules. Based on this, they have now come before this court with a money claim. First submission, my lord, is that this is, the genesis of this is a PPA between us. PPA itself says if a dispute arises, commission has to decide it under 86(1)(f) under the provisions of the act. The governing law and the dispute resolution provision in the PPA, Article 10.3, my lord,
Page number?
64.
Yes.
10.3.1, my lord. If any dispute is not settled amicably under clause 10.2, the same shall be referred by any of the parties to the KERC for dispute resolution in accordance with the provisions of the
You
electricity.
referred it for KRC?
No, my lord. What has happened is he's issued a notice making a demand on me. I've replied, Annexure A is my reply, where I say I'm not liable to pay you any LPS at all. In fact, the history, my lord, of this is there was a PPA.
You could have also said, I'm not accepting your claim, I'll refer it to the KRC.
We have said take whatever action is required to be taken, but we are denying this, my lord.
If you had sought for reference to KRC under this clause, I would directed KRC to consider.
Lord, it's for him to approach. According to me, I am not liable to pay him LPS because what has happened, my lord, is there was a PPA. He had to commission the plant within a particular time period. He commissioned late. He went to the commission and said, you give me the PPA tariff. The contract had a varied tariff clause, which said in the event of delay, the tariff on the date of commissioning is what would be applicable.
KRC,
Sorry, my lord.
why can't you go to KRC?
There is, my lord, a judgment by this honorable court where there is no dispute. Only, my lord, under 86(1)(f).
If she
there is a
agrees
dispute-
there's no dispute, that is
No,
one thing.
my lord. I cannot invent a dispute. My lord, the honorable court says that if it is an agreed amount, now, my lord, if there is an agreed amount, one can always say that now I dispute it.
The same thing we can say before KRC.
No,
also.
that's true, my lord. But this honorable court, my lord, in this matter, renew matter.
ಅಲ್ಲೇ ಹೋಗಿ, why do you want to waste time here?
ಅಲ್ಲ ಆದ್ರೆ ಏನಿಲ್ಲ ಇವರು ಈಗ ಅಗ್ರೀಡ್ ಅಮೌಂಟ್ ಗೆ ಈಗ ಇಲ್ಲಿ ಜಸ್ಟ್ ಟು ಮೇಕ್ ಇಟ್ ನಾನ್ ಮೇಂಟೈನಬಲ್ ಅಂಡ್ ಸೇ ದಟ್ ಮೈ ಲಾರ್ಡ್ ಫ್ಯಾಕ್ಚುಯಲ್ ಡೆನ್ಸ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಆರ್ ಇನ್ವಾಲ್ವ್ಡ್.
You're early 2024. I'll direct them to consider and dispose it of early.
Sorry,
I'll consider direct KRC to consider and dispose it of early.
ಅಲ್ಲ if your lordships direct, my lord, that could be done. But I am saying, my lord, just to invent a dispute when there is none.
There is a dispute, there's no
ಈಗ
intention.
ಕೇಸ್ ಹಾಕಿದ್ರೆ ಡಿಸ್ಪ್ಯೂಟ್ ಅಲ್ಲೇನೋ ಡಿಸ್ಪ್ಯೂಟ್ ಇರಲ್ಲ, ಅಲ್ಲಿ ಕೊಡ್ತೀವಿ ಅಂತಾರೆ. This is all, my lord, just to avoid the forum.
No,
If
there's
we
no
say-
such. I don't know why my learned friend is saying this. The letter, my lord, please see Annexure A. my
And
lord, page
lordships may
35.
see, this is statutory, my lord. Moreover, under the central government rules, there is LPS rules. And the LPS rules mandate it. And these payments are agreed amounts under an agreement. If I have to say, my lord, this is a dispute, then, my lord, I am not saying, my lord, lordships can always direct both of us to relegate to any forum. But to say that there is a rule and the rule says that you have to make the payment within a time-bound manner, you don't dispute the demands raised, don't answer them, nor
Give them
dispute
also
them.
some work. Why should we take all the work?
ಅಲ್ಲ ಇಲ್ಲಿ it is a simpliciter, my lord. And in renew power, lordships may see, general guidelines have been laid down. Lordship, may I persuade your lordships to see page
Petitioner is-
29.
Petitioner is agreed by Annexure A, by which his claim for payment of late payment surcharge has been rejected by the respondent. So not consider the petitioner submits that the late payment surcharge is an amount which cannot be disputed. And therefore,
And guidelines have been laid down.
respondent is bound to consider the claim. On the other hand, counsel for the respondent BESCOM contends that the petitioner is not entitled for the late payment surcharge and BESCOM is disputing the claim. She makes a reference to clause 10.3, which pertains to dispute resolution in respect of the power purchase agreement that has been entered into between the petitioner and the respondent, and contends that the making of a claim and the rejection of a claim by itself amounts to a dispute, and therefore under clause 10.3 of the PPA, the matter request be referred to the KERC, and as a consequence, the petition should not be entertained. It is not in dispute that this dispute arises out of a claim arising under the PPA between the petitioner and the respondent. It is also not in dispute that clause 10.3.1 does provide for a reference to the KERC for resolution of the dispute in accordance with the provisions of the Electricity Act. In my view, since BESCOM is contending that there is a dispute regarding the claim of the petition for payment of late for the towards late payment surcharge, it would be appropriate to direct that this dispute shall stand referred to the KERC as per under clause 10.3.1. The KERC shall enter into reference and resolve the dispute as provided under the provisions of Electricity Act 2003. It is expected that the KERC would take up the matter as dispose of the matter as expeditiously as possible, at any rate within a period of
3 months.
ಸಾಕಾಗತ್ತಾ?
ಅಲ್ಲ, KRC ಅಲ್ಲಿ there are guidelines framed, my lord, that's what I want.
Lord, I'll point out those guidelines don't apply to
ಅಲ್ಲಿ ಅಲ್ಲೇ reserve your arguments.
ಅಲ್ಲ, ಇಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಗೈಡ್ಲೈನ್ಸ್ ನನಗೆ ಅಪ್ಲೈ ಆಗಲ್ಲ ಅಂದ. ಹೈಕೋರ್ಟ್ ಗೈಡ್ಲೈನ್ಸ್ ಅಪ್ಲೈ ಟು ಎವ್ರಿಬಡಿ.
51, CMC Basuraj. I will argue this matter.
Enough.
Is in VC, madam. Number 51.
ನೀವಿದ್ದೀರಾ?
Kindly pass over. Kindly, is in VC.
Realist.
There is, 11th, Marat, there is an urgency in this case. 11th.
I am not available. If you want an adjournment, it will come before other bench. For Alva.
19. Please.
My friend is here, the 45th matter. They are precipitating the matter. That's why there was urgency. I moved. Short date may be given. But 45th matter, where my learned friend said he will seek instructions. They are
19th.
The number 52, Shri Pawan Chandra Shetty.
Petitioner, my lord.
Yes, ma'am.
My lord, this is the third round of litigation, my lord. The petitioner, due to electrocution, my lord, amputate his left hand, my lord.
Yes.
That needs to file objections where that earlier remitted back to reconsideration, considered and granted some compensation. Let that I seek for announcement of the compensation.
1,20,000 ಕೊಟ್ಟಿದ್ರಾ?
1,20,000 was given.
ಎಷ್ಟು ಕೊಡ್ಬೋದು? ಅಷ್ಟೇನಾ?
As per our circular, not that it is there that.
How old was he?
That he is aged about.
My lord, at the time of incident, my lord, he was aged about 36 years. Now he is, my lord,
42 years.
43 years, my lord.
ಎಷ್ಟು ದಿನ ಪ್ರಕಾರ ಎಷ್ಟು ಕೊಡ್ಬೇಕು?
My lord, we produce the photograph also, my lord.
Under their guidelines, is there any, under their guidelines,
My
is there
lord.
any amount fixed?
My lord, they awarded 1,20,000, my lord. However, my lord, the motor vehicle accident, the parameters may be taken, my lord, and
Go to civil court.
my lordship,
ಎಷ್ಟು ಕೊಡ್ಬೋದು?
ಅಲ್ಲ, ಅದ್ರ ಕೆಳಗಡೆ ಹೋದ್ರೆ ಅವರು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋಗಿ they have to examine doctor and all that it has to be.
Admitting the
my
amputation.
lord,
The amputation we are admitted. As per the circular we have granted.
What is circular ಕೊಟ್ಟಿದ್ದು?
my lord, wound certificate also we produced, my lord, and the copy of the photograph also produced, my lord. And the disability certificate also produced, my lord. Annexure G, my lord, disability certificate.
ಇನ್ಸಿಡೆಂಟ್ ಆಗಿದೆ ಯಾವಾಗ?
My lord, incident
2015.
9/6/2015, my lord.
15.
Yes, my lord.
rupees 2 lakhs for 16 years and above.
Yes.
Plus rupees 3,000 for reduction of every year in age multiplied by percentage of loss of earning capacity. $80 disability ಅಂತ ಇದೆಯಲ್ಲ?
That is not that,
Annex G. We also produced the photograph, my lord. His left hand amputated, my lord.
Like ಇದ್ರ ಪ್ರಕಾರ ನಾನ್ ಫೇಟಲ್ ಹ್ಯೂಮನ್ rupees 2 lakhs for 16 years and above plus rupees 3,000 for reduction of every year in the age multiplied by percentage of loss of earning capacity.
yes,
ಅಂದ್ರೆ ಅದಕ್ಕಿಂತ ವಯಸ್ಸು ಕಮ್ಮಿ ಇರೋರ್ಗೆ ಎಷ್ಟು ಕೊಡೋದು?
ಅದನ್ನೇ ಕಮ್ಮಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು. 2 lakhs, 69 years. Reducing that every year the 3,000 reduce ಮಾಡಿ 1,20,000 ಕೊಟ್ಟು.
ಪ್ಲಸ್ ಲಾಸ್ ಆಫ್ ಅರ್ನಿಂಗ್ ಕೆಪಾಸಿಟಿ
ಅದೆಲ್ಲ ಇದ್ರಲ್ಲಿ ಇಲ್ಲ.
ಇದೆಯಲ್ಲ, ಪ್ಲಸ್ ಅಂತಾನೆ ಇದೆ. ಪ್ಲಸ್ rupees 3,000 multiplied by percentage of loss of earning capacity. So whatever he was earning, 80%.
That all these documents material has to be placed in what he has earned.
There is an annexure 80% anta.
The
Annexure to
annexure,
that government, to that order.
Yes, my lord.
Amputation through shoulder joint, 90%.
yes,
Amputation below shoulder with stump less than 8 from tip of acrimonium,
Yes, yes.
80%.
yes, yes.
80% ಕೊಡಬೇಕಾಗುತ್ತೆ.
Like earning capacity that he has to, what is his earning capacity?
Huh.
That he has to prove it.
Nominal we will take that time, whatever is the age that day we will take.
That even to take into all this, disability has to be examined. The doctor has to be examined, doctor certificate,
It's a case of amputation.
amputation, but that it
My lord.
There is a disability certificate. Your own annexure says 80%. 3 Indian doctor examine
My
ಮಾಡ್ತಾರೆ.
lord,
That is
the
the only that I
disability-
seek time to file objections to get his certificate whether the genuineness or not.
Lord,
And
the
that is the why
disability
that
certificate
I needs
also.
to file objection.
ನೀವೇ ಒಪ್ಕೊಂಡು
ಅಲ್ಲ ಒಪ್ಕೊಂಡ್ ಅಂತಂದ್ರೆ that based on the circular that amount has been
My lord,
paid.
the disability.
Amount has been
certificate also.
awarded.
The
will give
disability
you one
certificate
chance.
also, my lord.
2024 ತಾನೆ. Realist.
19.
Much obliged, my lord.
53 adjourned, serial number 54. The Aditya Narayan.
In 54, I appear for the petitioner minutes. Would my lords kindly grant me a short accommodation to file rejoined minutes?
My lords, in this matter, my lords, your lordship may kindly see your lordship's interim order, my lords. The only question is whether of jurisdiction, my lords. At the time of passing the interim order, the lordships were pleased to observe
25%.
25% on the ground that, my lord, that the commission has no jurisdiction, my lords. There's no power to deduct these charges, my lords. We have pointed out that such power is there in our statement.
But
of
I just
objections-
want to file a rejoinder to the statement of objections, my lords. I'll appear physically next week. Your lordships may have it. Before the month is out, my lords, we can argue the matter and conclude, my lords.
18th.
Please, can I? Please.
I'm obliged. Lords, in 55, the other side has to file counter.
55 Shabas. 55.
Fortune 5.
55.
Your lordship, in this matter, as per the CERC interim arrangement is being continued. And for the merits of the matter, your lordship, they can go before CERC and they can plead the matter.
Lords, legal member is not yet appointed, is my understanding. The counter is not filed.
File your objections.
I can file objections on merit of that.
18.
Obliged.
56 to 58 adjourned. Number 59.
Yes. Good.
The number 73.
Sorry, my lord, my apologies. I got stuck in another court. I'm so sorry. There is a special bench. Friday. Sorry. Lord, of course, we have argued extensively, only by way of reply, my lord. First submission of theirs was, my lord, if your lordship recollects, my lord, your lordship also asked me, is there any promise held out? There is an agreement I've given to them, my lord, last week itself. Madi agida. Oh, last time I hakida. Please look at, my lord, that additional statement of facts and hakidi. Well, we don't have right now. Yes. Can I persuade your lordship come to, my lord, page 11, annexure M. Yes. This is, my lord, an agreement which had been entered into, my lord. My lords, get that, my lord. Sorry. My apologies, my lord. Namma hesru Maitri anta aitu, adanna hakidivi. Earlier, my lord, we were known as Maitri Energy, my lord, bottom alli sigutte nodi. So hum agide. Ashte, that, my lord, our Companies Act alli name we changed. Then, my lord, please come to page 14. 1-4. In 2009, before, my lord, I set up, Government, my lord, and Maitri, that's, my lord, the petitioner, entered into an agreement for, my lord, me to set up. Please come to, my lord, 3, Roman 3. Yes. Can I persuade you, look at, my lord, Roman 2 at page 14 bottom. Whereas Maitri Energy Limited requested the government to permit them to set up Mahadevapura mini hydel project across Kaveri River near Mahadevapura village, Srirangapatna Taluk, Mandya district of 6 megawatt capacity, and government were pleased to accord approval to them in the matter. White GO dated so and so, dated 10/12/2007. Then, my lord, this is the more important thing. Now this agreement witnesses as follows. Ownership of the unit will vest with the company for a period of 30 years from the date of commissioning of the powerhouse. Company undertakes that it shall not hypothecate the site, the structure, installation, machinery, building thereon for any period longer than the period for which the sites are leased to it by the government. Karnataka Renewable Energy Limited, Bangalore, or 30 years plus the period of construction, whichever is lower. This lease is subsequently renewable for a further period of 20 years at the option of the company. Then, my lord, please come to, my lord, running page 17. Yes. Para 5. Transmission line from the powerhouse to the Karnataka Power Transmission Corporation Limited, grid point, shall be got constructed by KPTCL at company's cost. The transmission line would be maintained by KPTCL. Company shall pay wheeling and banking charges to Karnataka Power Transmission Corporation, that's KPTCL, at the rate prescribed under the order of KPTCL dated 13th of June 1996, and further as revised by KERC from time to time. A separate agreement should be made by the company with KPTCL in this regard. Banking arrangement shall be on a water year basis with the grace period of 1 month. The company shall enter into wheeling and banking agreement with the KPTCL in case of selling power to third party, and power purchase agreement in case of selling power to KPTCL. Therefore, my lord, 1 year banking, my lord, is what was represented. Promissory estoppel will squarely apply, my lord, in this.
After this agreement of lease,
Yes, my lord.
you entered into this.
No, this is not agreement of lease, my lord. This is an agreement with the government. Government, my lord, KPTCL is a part of the government.
Where it leased the property to you for 30 years.
And, my lord, thereafter, my lord, after that, my lord, it will vest in the government free of cost. Please come to, I'll point out that also.
But does the government have the power to determine the banking charges?
Not banking charges, my lord. Charges, I am not on charges.
Even the banking period.
My lord,
What right does the government have in the light of the statutory regulations?
no, my lord, I'll tell you, lordships, how. Today, the government, my lord, I want to set up a power plant. Why? Because, my lord, it's a renewable energy. Renewable energy, my lord, cost me, my lord, a lot of money. I am production, my lord, my production is only during the rainy season, 4 months. If, my lord, at that time, there are bigger dams, my lord, which generate electricity. Therefore, my lord, there is no person, my lord, to take it. Therefore, my lord, the government said, you are investing, my lord, so much of money. My lord, I invested about 68 crores. My return, even by now, my lord, is not more than 20 crores. I'll have to, my lord, recoup. That's why, my lord, the government said the Unit, my lord, will with me for a period of 30 years. And they also said you will have banking on yearly basis, not monthly basis.
But if I accept this argument, that means the government has the power to determine the entire terms of the power to be generated by you and supplied by you, notwithstanding the regulations of the KERC.
My lord, I'll come to your lordships. Your lordships wanted to know, my lord, whether there is a agreement, my lord, or any promise. If there is a promise, then, my lord, what would happen? Only one judgment I'll give your lordships, and then, my lord, I'll dilate on, my lord, what fell from your lordships, whether regulation will supersede this or, my lord, not. And to what extent, my lord, that regulation is valid. Please permit me to, my lord, Sujata or judgment. Copy ಮಾಡಲಿಲ್ಲ ಆಯ್ತು ಸಾರಿ ಐ ಓನ್ ಅಪಾಲಜಿ ಒಂದೇ ಕಾಪಿ ಇದೆ ಯಾಕೋ ಗಡಿಬಿಡಿನಲ್ಲಿ ನಿಮಗೆ ಮೈ ಅಪಾಲಜೀಸ್ ನಿಮಗೆ ಗೊತ್ತಿರುತ್ತೆ ಇಲ್ಲ ಒಂದೇ ಕಾಪಿ ನನ್ನ ಹತ್ರ ಇಲ್ಲ ಪಾರಾ 25 ಮಲಾಟ್ ಪ್ರಾಮಿಸರಿ ಎಸ್ಟೋಪಲ್ ಬಗ್ಗೆ ಮಾಡಿದ್ದಾರೆ ಅಲ್ಲಿ
25.
Para 25.
Disagreement.
Paragraph ಏನೇನೋ ಬರುತ್ತೆ.
30 years lease was given in annual banking promissory estoppel.
25 ಮೇಲೆ ಬಂದಿರುತ್ತೆ.
It has said act and regulations will supersede all the judgment of the Supreme Court.
ಹೇಳಿ ಅಲ್ಲಿ ಬರ್ಬೇಕಾದ್ರೆ ಇನ್ನೇನಾಗಿದೆ.
Existing contracts. Supreme Court. You sure? No. We've already given this one.
Renew power. Renew power versus Bangalore electricity supply. Sorry, my apologies. ಇಲ್ಲ ಅನ್ನತನೇ ಕಾಪಿ ಇಲ್ಲ ಈಗ ಇಲ್ಲಿ ಇರ್ತೀವಿ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವ್ರ ಹತ್ರ ರೆಡಿ ಇರ್ಬೇಕಲ್ಲ.
You have it, no?
What was the issue framed?
My lord, can I pursue your last look at my lord para 2 facts ಬರುತ್ತೆ ನೋಡಿ. I'm sorry, my lord, ಅದರದ್ದು ಕಾಪಿ ಇಲ್ಲ, but para 2 ತಾವು ಬಂದ್ರೆ facts ಅಂತ ಬರುತ್ತೆ ನೋಡಿ.
Yes.
Petitioners challenge the order dated so and so passed by the KERC, Bangalore, under the provisions of the Electricity Act 2003 and the KERC Terms and Conditions of Open Access Regulation 2004, which deals with open access charges, including wheeling and banking charges, transmission losses, cross-subsidy charges, surcharge of renewable energy projects commissioned between so-and-so 2013 to 2018. Open access charges for RE projects commissioned between so-and-so 2013 to 2018 were governed by two separate orders of the KERC. Order dated the 4/7 dealt with the wind-based as well as mini-hydel power plants. And the order dated 18/8 dealt with solar power plants. Wind mini-hydel power plants under order dated 4/7 were required to pay 5% wheeling charges of the injected energy. Banking charges were specified at 2% of the injected energy. Solar power generators as per order dated so-and-so were exempt from paying wheeling and banking charges and cross-subsidy charges, surcharge for a period of 10 years from the date of commissioning, provided that their plants were commissioned between 1/4/2013 to 31/3/2018. It appears that the petitioners have complied with the conditions of order dated so-and-so and so-and-so and commissioned their respective projects prior to 31/3/2018. However, KERC by the order impugned herein continued the exemption on wheeling and banking charges to solar projects commissioned on or earlier to 31/3/2017 and all RE projects other than the captive generators availing the benefit of renewable energy certificates which have not yet been completed 10 years from the date of commercial operation as on 31/3/2018 are made liable to pay 25% of normal transmission charges or wheeling charges and banking charges of 2% in kind. In case of wind mini-hydel projects commissioned during the period 10/10/2013 to 3/9/2017, 25% of the normal commission transmission charges and or billing charges have been levied. The line losses were to be exempted in kind. Banking charges were retained at 2%. So on. Therefore, my lord, that was challenged. That, my lord, the honorable, my lord, this all
% normal transmission charges were challenged.
25 mandadu. Other now they said, my lord, promissory estoppel will apply. My lord, now coming back to my lord, what fell from your lordships. My submission to your lordships is, my lord, and that is what, my lord, I did submit, my lord, on the last occasion. The rules framed by the central government, my lord, one is the act itself. Act, my lord, is, my lord, to promote renewable energy. They must, my lord, ensure that renewable energy, my lord, is promoted. For that, whatever is required to be done must be, my lord, so done, my lord, as per the regulations by the KERC. If it is contrary to the statute, then, my lord, to that extent, my lord, it has to go, my lord, give a go by to the regulation, and, my lord, the statute will override. Ultimately, my lord, there is what is known as, my lord, the letter of the law and the spirit of the law. Spirit of the law, my lord, is enshrined in 86(1), my lord, C of the Act itself, as I pointed on the last occasion. 86(1) C, my lord, specifically says, you must ensure how, my lord, I am able to sell. If, my lord, monthly idre, it will become a waste. Please come to, my lord, E, 86(1)E. Yes. Promote cogeneration and generation of electricity from renewable sources of energy by providing suitable measures of connectivity with the grid and sale of electricity to any person, and also specify for purchase of electricity from such sources percentage of total consumption of electricity in the area of distribution licensing. Therefore, my lord, in fact, this is, my lord, a commission. State commissioner shall discharge. My lord, please look at the one itself. The state, it's a function of the state commission. State commission shall discharge the following functions, namely, promote cogeneration, generation of electricity from renewable sources of energy by providing suitable measures of connectivity with the grid and sale of electricity to any person. My lord, they must promote this. If, my lord, I am not able to sell 1 month only the banking hoitu antandre, then, my lord, I'll have nothing. Therefore, my lord, look at, my lord, the agreement that I had. I set it up, my lord, by the government, my lord, based on this. KPTCL, my lord, is a part of the government itself. Secondly, my lord, the section itself. And the thirdly, my lord, I pointed out the rule itself. They are relying upon, my lord, today, the rule framed by the central government. That has, my lord, overriding effect over the regulations. Rule is, my lord, at page 87 of my writ petition, where all this, my lord, relates to, my lord, the consumer. Rule, my lord, page 87 of the writ petition. Yes. I pointed out, my lord, B, entity means any consumer who has contracted demand or sanctioned load of 100 kilowatt or mere or more, except for captive consumers. So, my lord, entity is, my lord, a consumer. Then, my lord, obligated entity. E, obligated entity means entity mandated under clause E of subsection 1 of section 86 of the Act to fulfill renewable energy purchase obligation. Renewable purchase obligation is again a consumer, which includes distribution licensee, captive user, and open access consumer. Captive user, my lord, is one who, my lord, generates electricity and consumes himself. Therefore, my lord, no generator, my lord, of the general nature. Then, my lord, 3. This rule shall be applicable for generation, purchase and consumption of green energy as defined in the clause C of rule 2, including energy from waste to energy plant. 2C, my lord, is 2C mistake, 2B, doesn't matter. Then, my lord, 4. Renewable energy purchase obligations. On and from the date of commencement of these rules, there shall be a uniform renewable purchase obligation on all obligated entities in an area of distribution licensee. 2. Subrule 2. Any entity, whether obligated or not, may elect to generate, purchase, and consume renewable energy as per their requirement by one or more of the following methods. This again, my lord, is entity. He, my lord, generates and consumes himself. Then, paragraph B, my lord, 2B. by procuring renewable energy through open access from any developer, either directly or through a trading licensee or through power markets. Developer means generating company who generate electricity from the renewable sources of energy. Therefore, my lord, they have to purchase it from me. Again, my lord, all these are relatable to consumer. Then, my lord, C, any entity may elect to purchase green energy either to a certain percentage of the consumption or its entire consumption, or they may place a requisition for this with their distribution licensee, which shall procure such quantity of green energy and supply it, and the consumer shall have the flexibility to give separate requisition for solar and non-solar. My lord, please mark this, my lord. I'll tell your lordships why. See, my lord, if your lordship sees, he can requisition, my lord, the distribution company KPTCL to, my lord, consumer to give me, my lord, power. That's why, my lord, in 8, my learned friend, my lord, pointed out, in 8 banking, he said, my lord, there is that injection. Injection is this. It is not by me. I, my lord, inject it. Yes, generator injects it. But all these, my lord, relate to, my lord, the consumer. Now, my lord, please come to, my lord, paragraph, clause 5. Next page, rule 5. To provide green energy open access to consumers of green energy, the appropriate commission may, if necessary, amend the relevant regulations made by it, and such regulations shall be consistent with these rules. Again, my lord, consumer. Now, my lord, please come to paragraph 8, rule number 8. Next page, 89. Banking shall be permitted, at least on a monthly basis, on payment of charges to compensate additional costs, if any, to the distribution licensee. Distribution licensee are there. By the banking and appropriate commission shall fix the applicable charges. The permitted quantum of banked energy by the green energy open access consumers shall be at least 30% of the total consumption of electricity from the distribution licensee by the consumers. Explanation. For the purpose of this rule, the expression banking means surplus banking energy injected into the grid and credited with the distribution licensee by the green energy open access consumer, and shall be drawn along with the charges to compensate additional costs, if any. This injected, my lord, is, yes, I inject, but then all this, my lord, relates only to the consumer. Therefore, my lord, their argument is that paragraph, my lord, banking can be only, my lord, for 1 month. 1 month was, my lord, only for the consumers. Yes. Therefore, my lord, my submission, and my lord, now please come to 91. That's, my lord, the regulation framed by the, my lord, the KERC. Yes. Please come to, my lord, the definition of consumer at page 92. Consumer means any person who has contract demand or sanctioned load of 100 kilowatts or more. Captive consumer shall not have any load limit, who is supplied with electricity from RE sources for his own use by the licensee or CPP, or the government, or by any other person engaged in the business of supplying electricity to the public captive, public including captive, under this act, or any other law for the time being enforced, and includes any person whose premises are for the time being connected for the purpose of receiving renewable energy with the works of a licensee and the government of such or such other person, as the case may be. Then, my lord, paragraph 12 or regulation 12, suddenly they say, my lord, it is banking is 1 year. 1 month. Paragraph, my lord, page 102, your lords will get that. This is what we said. In fact, my lords may recollect, Aptel, my lord, in 2 judgments have held, before you reduce the amount of banking to 1 month, you must have data, you must analyze. Nothing has been done in this case. Paragraph 12, my lord, regulation 12, my lord, at page 102. Banking shall be permitted on a monthly basis on payment of applicable charges as determined by the commission in separate orders issued from time to time, provided that unutilized banked energy remaining at the end of the month shall not be permitted to be carried forward to subsequent months. This, my lord, my submission is, this also, my lord, would relate to, my lord, the consumer, because of the definition of consumer, my lord, as your lordship saw, my lord, in the beginning of this very regulation at page 92. Consumer is one, my lord, who consumes. And the regulation 8, all, my lord, all this also, my lord, means, my lord, all are relatable to, my lord, the consumer. And 12, they are trying to misinterpret it. My submission is, my lord, even if, my lord, it says that even for, my lord, the renewable energy generate, it will be contrary to, my lord, the regulation, rules. Rules said, my lord, only in relation to consumer, my lord, it is 1 month, not, my lord, for me. And contrary to, my lord, the statute. Therefore, my lord, my submission is, and APTEL regulation, my lord, APTEL, my lord, 2 orders I have given to your lordships, my lord. I don't want to, my lord, repeat. Then, my lord, the third submission that my learned friend made was report, my lord. They called for a report and they produced a report. My lord, on the last occasion, that report, my lord, I pointed out. It is only, my lord, in relation to, my lord, KPTCL, nothing else. What is required, my lord, is they must also take into account, my lord, 86(1)(e) says, my interest, my lord, if ultimately, my lord, today, we have reached a stage where morning, my lord, it is so cloudy. We thought, my lord, there will be a torrential rain. Madhyana Agostottige, there will be hardly few honeys. This is, my lord, global warming. That is why, my lord, renewable energy sources, my lord, of energy, my lord, are absolutely essential to be, my lord, generated and to be encouraged. It is in this background that, my lord, section, my lord, the Electricity Act, my lord, specifically provides in the very preamble that, my lord, renewable energy sources, my lord, of energy must be, my lord, advanced, and, my lord, it must be, my lord, encouraged, and 86(1)(e). Therefore, my submission to your lordship says that the report, my lord, is, my lord, I think I already said that. Let me just, my lord, read it aloud. Estimated impact of renewable energy of banking and revealing and banking charges on the Karnataka ESCOM, nothing else. Therefore, my lord, what impact it will have on the renewable energy, my lord, generators, not taken into account. That is what, my lord, the APTEL in 2 judgments. After all, my lord, I give you, lords, 1 judgment. Authority is bound by the appellate orders, my lord, passed by the appellate authority. In this case, APTEL has specifically held that you must take this into account. Nothing has been done in the case. Then, my lord, the next, my lord, submission of my learned friend is generator, my lord, need not be consulted. No generator is consulted. I said, well, study is, my lord, by the BESCOM. Then, my lord, supervening object is to protect the consumer. That's, my lord, the statement that my learned friend made. My submission to your lordship is, my lord, consumer, the regulation takes care of it. I ask myself this question. If, my lord, renewable energy, my lord, the sources of generation, my lord, it closes down. Today, my lord, if they have banking of 1 month, I will, my lord, have nothing else, my lord. I will not be able to, my lord, be, I'll be at a loss. If I am at a loss, I'll have to shut down. If everybody shuts down, please look at, my lord, what happens, my lord, the state. Renewable energy, my lord, will not be there. If renewable energy is not there, they'll have to, my lord, I'm told, my lord, today morning, newspaper said, the consumption, my lord, in, I think, the next, it will triple in a matter of, my lord, 3 years or 4 years. Consumption of electricity in the state. If that is so, if you don't have, my lord, renewable energy sources and generation, if you don't encourage, my lord, then you at least on moda beligotirutte, adu irodilla. This is what will happen. Then, my lord, lastly, my learned friend, my lord, referred to 2 judgments. One is, my lord, 2023 SEC Online Delhi, 7,100. Please look at paragraph 11 of that. ಯಾವುದು ಅವರೊಂದು 2 ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟರು ಇದಲ್ಲ ಮೊನ್ನೆ ಅದು ಮೆಮೋ ಆಫ್ ಸೈಟ್ ಹೆಚ್ಚು ಕೊಟ್ರಾ ಸರಿ ನೋಡಿ 1 ನಿಮಿಷ ನಾನು ರಿಟರ್ನ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ತಮಗೆ ಯು ಡೋಂಟ್ ಮೈಂಡ್ ಆಗ್ಬೋದು my learned friend says, my lord, he is already marked para 11, my lord. I'm grateful to him. Please come to, my lord, running page 30, our compilation. Thank you. That is, my lord, Juniper Hotels Private Limited. My lord, 13. It starts at, my lord, that judgment starts at para 8, page 8. 13 nalli. Para 11. The exemption from wheeling, transmission and additional surcharge for the open access consumer cannot be claimed as a matter of right. My lord, please mark this again. Open access consumer cannot be claimed as a matter of right. In the state of Rajasthan versus JK Udaipur, Udyog Limited, 2004, 7 SCC 673, Apex Court observed that exemptions and concessions granted by the government are privileges. They do not confer upon the beneficiary any legally enforceable right against the government for grant of concession, except to enjoy the benefits of concession during the period of its grant. Relevant observation Supreme Court is, my lord, called out here. That's why government, my lord, specifically said for, my lord, you will have during the period of your entire tenure, yearly banking. That's why I gave you, lordship, my lord, that order, that agreement that the government had. Government passes a GO and then, my lord, executes that agreement. And, my lord, KPTCL is, my lord, a part of the government. Government, my lord, owns the entire KPTCL. It's not a private entity. Therefore, this, my lord, statement legally enforceable against the government for grant of, except to enjoy the benefits of concession during the period of its grant. Grant is, my lord, for 30 years. After 30 years, my lord, my plant, everything goes, my lord, free of cost to the government. Therefore, my submission to your lordship is this 2013, my lord, has no application. Then, my lord, 2014, Aptel judgment is referred to. That is, my lord, fortune. Please come to, my lord, para 17 of this. That is 185, my lord. Thank you. Like you, my life becomes very easy. My lords got that, my lord?
Yes.
Page 185 bottom. While taking critical evaluation of the contention and objections of the respondent commission as well as respondent ESCOMs, we hold that they do not establish any supervening public interest that prevail to modify the banking arrangement, even prior to 10 years period available so and so. Neither in the impugned order nor in the statement of objections filed by KARC or the respondent. No satisfactory reasons of public interest warranting such one-sided amendment in the wheeling and banking agreement is cited. As such, in the absence of supervening public interest established by KARC, reducing the banking period, forcing other restrictions in the banking period or drawal of energy in a premature manner, giving the promise and assurance to go by before the expiry of the validity of the period of 10 years guaranteed by the previous order of the commission. Appellant who have invested, executed commercial agreements cannot be left in the rush. Idರಲ್ಲಿ government normal or 30 years ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. Now, my lord, please look at the last paragraph. They say, ಅದರಲ್ಲೇನೆ, my lord, please come to my lord, page 186 ಅಲ್ಲಿ bottom, absolute bottom. 3 lines, my lord. RE power plants have longer useful life spanning across 25 years, whereas wind generators,
Wheeling and banking.
WBA, wheeling and banking agreements are executed only for 10 years. Keeping these aspects in mind, in view, physical support in the form of annual banking would need to be reduced gradually if necessary, only after the expiry of the WAs, in order to avoid financial shock to the developers herein. Then, my lords, the 2 judgments I have given to your lordships, Aptel says, without, nodi, court master, naman kottidenu, 2024 SCC online, SC inda ide. My lord, to page 17 ಅಲ್ಲಿ, Aptel judgment.
Yes.
If your lordship sees, my lord, this is Tamil Nadu Electricity Board, regulatory authority. My learned friend said, except, my lord, in Karnataka, no others have, my lord, annual banking. That's not correct, because this will show that, my lord, when they try to reduce, my lord, annual banking, they, my lord, set it back. Please come to, my lord, page, paragraph 14, my lord, for a minute. Running page, my lord, 20. Concept of power banking has been the subject of dispute in the past. It was explained by the bench or the tribunal in judgment in the matter of Tamil Nadu State Electricity Board versus Tamil Nadu Electricity Regulatory Commission, so and so. Banking energy is analogous to small saving bank account in a financial bank. Person deposits a surplus amount in a savings bank. He can withdraw his money from the bank anytime according to his requirement. For this deposited money, he earns some interest. Bank in turn gives loan to some other needy customers. In this process, saving account bank holder as well as bank are benefited. Now come to the electricity banking. Electricity is a commodity that cannot be stored. It is to be consumed at a very instant it is produced. Generation by wind energy generator solely depends upon the availability of wind at a particular velocity. Similar, my lord, is our case only during, my lord, when water is available. In other words, it is periodical in nature. Its generation is not constant, even during the period of 24 hours of a day. It could be possible that it generates electricity when captive user does not require it. In such a case, energy generator banks it with the distribution licensee who supplies this energy to its consumer at applicable tariff. However, for returning the bank energy, licensee may have to procure additional electricity from other sources. Unlike the banks which have to pay interest to the saving bank holder, here the licensee, the banker of the electrical energy, that's the ESCOMs, earn interest on this banked energy. Thus, banking rate of electrical energy should be nominal. Then, my lord, please come to, my lord, the last of the paragraph. My lord, para 310. At, my lord, running page. Sorry. One minute. Page, my lord, 48.
Yes.
Para 96, my lord. We would not allow further ad hoc approach on the subject. We thus also direct State Commission shall not bring about changes in the rules for power banking or the kind attempted through non-speaking impugned decision by any further order without undertaking a study based on the requisite data properly gathered and analyzed so as to draw informed conclusions about the financial impact on various stakeholders.
Yes.
Again, my lord, this is reiterated in the next judgment, which my lords get, my lord, at page, my lord, 501.
Yes.
That's starting. Please come to, my lord, the last page, para 310, at, my lord, running page 117.
Yes.
My lord, idರಲ್ಲಿ 309 ಅಲ್ಲಿ, if your lords come down, my lord, 2, 4, 6, 8, 10, 12, 14 lines from the top, my lord. While taking, my lord, 12 lines on the top. While taking note of the findings and discussions in the impugned order and the respective submissions of the learned counsel of both parties, we find that while exercise at level of State Commission lacks in data, record and analysis, etc., additionally, there is no evaluation of financial injury for the appellants vis-a-vis ESCOMs on account of such banking or reduction in the banking period whatsoever. ಇಲ್ಲಿ one side and ಮಾತ್ರ ನೋಡಿದ್ದಾರೆ, ಎರಡು side ನೋಡ್ಬೇಕು ನೀವು ಅಂತ ಹೇಳಿದ್ದಾರೆ. Therefore, my lord, looking at all this, my lord, my submission to your lordship is that, my lord, the order that has been regulation, my lord, is first of all, my lord, does not apply to us. Secondly, my lord, even if it applies to us, my lord, it is, my lord, in the teeth of the act, the rules of the central government, and therefore, my lord, it should be bad in law. Grateful to your lordship.
The banking issue is not for permitting not.
Banni, ee kade banni.
You also rely upon a similar clause in a similar agreement.
Yes, exactly same agreement and date also. May I persuade your lordships to see, my lord, the same agreement which my learned senior just now read. In my petition, my lord, in 11235. Page estudu? Vrindavan agreement.
That agreement was traceable to which statutory provision?
Yes, I am, my lord, on that. That is under the Supply Act, Electricity Supply Act. And that is what, my lord, is my entitlement. One, my lord, learned senior read out the judgments and, my lord, made out a case of benign treatment to renewables. That is, my lord, one logic. The other logic is, my lord, lordships may see the year of that agreement at page 163 is 1995. Lordships get it, my lord, Annexure H 163.
Before the act.
Yes, yes. Before the Reforms Act also came, Lord. 3 acts have come after that. 1999, the Reforms Act came. Electricity Act has come in 2003. So, my lord, 2 acts have passed by. Now, may I persuade your lordships to see exact similar clause. Clause 6, my lord, at page 167. The transmission line from the exact similar. Lordships may just juxtapose it with the earlier petition, my lord. A separate agreement should be made by the company with the KEB in this regard as so and so, so and so. Now, may I, my lord, persuade your lordships to see the first page of that agreement at 163.
Yes.
This is, my lord, the government. In the Supply Act regime, under the 1948 Electricity Supply Act, KEB was in existence, and KEB, my lord, was nothing but the government itself. Whether the KEB entered into an agreement or government entered into an agreement, same thing. Because Under Secretary was, my lord, placed in KEB, so it was one and the same. Now may I persuade your lordships to see.
What happened to the agreements that were entered into under the
Yes.
Supply Act on the 1999 Act coming into force?
They continued. They continue.
Under which provision?
Yes, under that is what, my lord, I'm saying. Under 18(6) of the Reforms Act, may I persuade your lordships to see 18(6) of the 18 subclause 6 of the Reforms Act. Electricity Reforms Act. I have culled out that, my lord, for just for time being, my lord. Yes. Electricity, the KER Act said all, may I read, my lord, 18(6) of the Reforms Act. All licenses issued, lordships have it, my lord.
Is this the license issued under the electricity?
Alla, munde agreement to this. All licenses issued under the so and so, so and so, and so and so. All power purchase agreements, transmission service agreements, other contracts, lordships may see, entered into shall continue in full force and effect and will be transferred to the successor entities. Now, my lord, the KPTCL is an entity created under the Reforms Act. This act that your lordships are now seeing. And lordships may also see, while your lordships are on that point, section 58.
This power purchase agreements.
Yes. And other contracts.
Other contracts between whom?
Entered into, my lord, that's what it
As
says.
portion of section 6
Yes.
relates to the license granted by the state government.
Yes.
That will continue.
Yes.
And the second portion relates to the
All power purchase agreements
between whom? Between the
KEB
and
KEB and myself.
not the agreement of the government.
Allah, KEB, that's what I submitted, my lord, in the first. KEB and government were not different. It was a board of the government, and state was the undersecretary of the government, was the undersecretary of the KEB. There was no distinction between KEB and the state government. And power purchase agreements, transmission service agreements, and other contracts, lordships may see as a generic term, shall continue to be full force and effect and will be transferred to the successor entities. And then, my lord, this also, my lord, is important, where your lordships will see section 58. Section 58, my lord, the effect of the act on electricity supply, Indian Electricity Act and Supply Act, in which your lordships may see 58F, my lord, 58(3)(f) of the Electricity Reforms Act, which said, in respect of the matters covered in so and so, so and so, that, my lord, your lordships will see that 18 also is included. 18 so and so, so and so, to the extent that so and so provisions, the provisions of the Electricity Supply Act shall not apply in the state. So, one is, my lord, the consistency provision, that all contracts shall continue, and then, my lord, it was repealed. That's what I was, my lord, submitting. This act repealed the Supply Act, divorced this saving clause under section 18(6). So my agreement, my lord, is saved. And also now, lordships, my lord, asked a pertinent question on the banking charges, etc. Now, my lord, lordships asked me, I am, my lord, reminding myself that what lordship said was, all right, now this agreement was entered. Now, why you did not enter into an agreement for 30 years? Also, what happened to the banking period and charges subsequently? Did you waive off this, my lord, clause? Now, I am answering that by saying that, my lord, definitely the agreement said, my lord, at page 167, a separate contract shall be entered. And that contract continued even after the Reforms Act, even after the Electricity Act, lordships may note. Because under the Electricity Act 185, the Reforms Act also was saved. To the extent that it is not inconsistent. May I persuade your lordships to see 185 of the, my lord, Electricity Act, 185(3), my lord, of the Electricity Act. The provisions.
I'm not very clear as to whether under 18(6), the agreement that you entered in the government.
Yes, it is. Because lordships may see, alla, bekadre, adra hale agreement, adadmele, ee agreement admele,
No, 18.6, because under the
Yes, my lord.
Electricity Supply Act,
Yes, my lord.
there was no question of the state government entering into an agreement with the producer of power. It was only the board which was
Yes.
entering into contract.
Yes,
That has been saved,
yes, my lord.
but
That also, yes, that is saved. And the subsequent, now that is why, my lord, I am reading 86 for myself. 18.6, my lord, also says, 18.6, Reforms Act. Yes, 18.6, my lord, reads two things. One, when it says in the second part, all power purchase agreements, transmission service agreements, and so shall continue to be in force. That means the agreement that I entered in terms of that clause is also saved.
other contracts entered into shall continue to be in full force and effect and will be transferred to the successor entities.
Hೌದು.
So this
ಅಂದ್ರೆ
is on the basis
KPTCL.
of those contracts which KB had entered into.
ಹೌದು.
That will continue to be in effect
Yes.
to the successor
Yes,
entities.
yes, my lord.
Not the contract entered by the government.
Yes. Now, my lord, in that interregnum period, my instructions are, no agreement was entered into with KB, and in 2006, lordships may see for the first time.
There is, if your lordship sees the difference between KB and government.
180, my lord. Sorry.
Don't mind, I'm so sorry.
Sorry.
Page 171 of my learned friend's
Yes, yes.
agreement makes a decision in respect of a dispute between KEB and the entity concerned.
Yes.
Is to be decided by the government.
Correct. So there is a distinction between government and the KEB, is what he's saying. Correct, my lord. No agreement was entered into with KEB. That is my submission. If, my lord, there was an agreement entered into with KEB.
Your reliance on 18.6
Yes.
would not be of any consequence because the agreement that the government entered into
Yes.
with you
Yes, my lord.
is not what is covered under 18.6.
No, my lord. No, my lord.
18.6 only deals with those contracts which was entered into by the erstwhile KAP,
Yes.
which will continue to be in effect
There was no agreement entered.
with the successor entities. Therefore, these are the agreements
Yes.
with KAB, not agreement by you with the government.
Please.
This is not safe.
Please, may I submit that, my lord? Lordships may see the first part of 18.6, all licenses issued under Supply Act by the state government or competent authority shall be deemed to be provisional licenses. It only relates to
So
licenses.
even that is not safe. Even if you had been
All-
granted a license, even if somebody had been granted a license, that permanent license becomes provisional.
ಅದು ನನಗೆ ಸಂಬಂಧಪಟ್ಟ ಹೌದು.
ನಾನು ಹೇಳ್ತಿರೋದು.
Sorry.
It is made provisional and subject to the other provisions of the act. Therefore, that license comes to an end,
Yes.
basically. Then the second part of 18.6
Yes.
talks about those contracts which are entered into with the KAP,
Yes.
which will continue to bind the successor entities. That
Please.
is when they unbundle the entire sector. Whoever
Please.
succeeded as an entity
Please.
to KAP, they will bind them, that is all.
Please, may I answer that, my lord? My lord, I completely understand what your lordships are saying. 18 as a whole deals with the KEB, in fact, the government itself. My lords may see, there is no reference to KEB at all. One aspect, my lord. Secondly, lordships may see 18 itself, forgetting for a moment, my lord, what 18.6 says. No person other than authorized by the license exemption under so and so shall transmit electricity and supply electricity. And, my lord, the state government, the state commission shall have powers to regulate. And state government's role is under 18.5, lordships may see. And then comes, my lord, 18.6, which relates to the agreement omnibus provision, which does not confine its, in fact, relate itself to the KEB at all. There is no reference to KEB at all. I did not enter into any agreement with KEB at all. Why, my lord? I did not commission the project during that phase. I commissioned it in 2006, which will, sorry, 2006 nalli, in page 180, lordships will find an order that all agreements ipso facto bind me. Now, my lord, 18.6 agreement, whether it binds KEB or, my lord, government, the question may be, my lord, kept one side. There was no agreement with KEB, could not save it because there is no KEB agreement. Now the government agreement is saved under page 180. May I persuade your lordships to see, my lord, the government order of 6/2/2006. 180 of my petition. Yes. The government is pleased to accord. Now this is again by the government, Lord. This is not by KB or KPTCL. No agreement, no reference to agreement because there was no question of government is pleased to so and so. All clearances, approvals and agreements made in favor of so and so shall be applicable to so and so. Now even presuming for a moment, Lord, that what your lordships just now said, that 18.6 approvals extinguish, because if you have a KEB agreement that is saved at best, where is the government saving clause? This is the saving clause. Entered into by me with the government order at page 180. This is issued after the Supply Act regime, after the Reforms Act regime, after the Electricity Act regime. So my respectful submission is that if the government says that my agreement terms with you continue ipso facto, then, my lord, the government is transferring that entire banking issue, etc., etc. Now, your lordships also asked me, why did you enter into an agreement, another agreement with KPTCL, where, my lord, there is change in charges. This charge, that charge is substituted. To that, the charges, my lord, I am bound. There is no question of me saying, avatte ನೀವು willing banking ಏನ್ charge ತಗೋತಾ ಇದ್ರಿ ಇದರಲ್ಲಿ ಬರ್ದಿದೆ agreement ನಲ್ಲಿ ಅದೇ continue ಆಗಬೇಕು, because there is no agreement, there is an order. And in 2000, as latest as 2006, when, my lord, the commission was constituted, commission was in existence, the government said, because this agreement relates to that era, of the earlier era, they did not insist on a new agreement. After the Electricity Act has come, there is inconsistency, agreements are abandoned or whatever, there is ambiguity, and the KEB agreements are only continued, state government agreements do not continue. That maybe, my lord, was in the back of the mind of the government, and government said, all the approvals shall continue for better clarity. So therefore, my lord, I am operating under this government order of 6.2. Now, second aspect is, my lord, that after this order is passed, in 2014, I commissioned the project. Then, my lord, I enter into an agreement in terms of the agreement that I read to your lordships, where banking billing charges are determined. As far as charges are concerned, my lord, it is the prerogative of the commission to, my lord, change the charges, vary the charges. In fact, the charges were below the charges fixed in the government order, rightly or wrongly. That is, my lord, government's role as a regulator, KEB's role, sorry, not government's role, KEB's role was a regulator, transmitter, supplier, etc., etc. One portion of that, my lord, under the Reforms Act came to KERC, which is actually KEB. In a sense, the adjudicatory functions of KEB came to KERC, and the power purchase agreement approval functions came to, my lord, KERC. They said it is akin to KEB's successor in that regulatory function and adjudicatory function. So, they quasi-judicial function. They said that the agreement shall continue. They gave me banking. I am not, my lord, an entity who got banking under the normal course, but under a banking, annual banking in my government agreement. Now, my lord, all clearances, approvals, agreements continued. Charges may vary. Even today, I am saying, my lord, if for argument's sake, if GOA charges are to be applied to me, suppose the rules are sustained, regulations are sustained, apply charges. I have no difficulty, because I have already amenable to that change in charge in my agreement itself. I cannot come back and say to my lords that, my lord, I will not pay those charges. That charge, if they are illegal, I will challenge that, which I have done in this petition itself. I am not saying, Lord, they have a right and I don't have a right to question. Their right to levy and my right to question both remain. So if it is illegal or you are levying it from some, I will challenge. But as far as banking is concerned, my lords may see that the very existence of the project was on the annual banking issue. Otherwise, my lord, I would not have continued. In 95 itself, I would not have invested. Secondly, in 2006, when Electricity Act, now they know, under the Electricity Act, no banking provision, no billing provision, nothing. They say it is all a changed regime. The KERC will decide the way they want. Now they continued that agreement and allowed me to commission the project. There were hydrological risks, there were investment risks, fiscal risks. I took all the risks, my lord. And based on the government order of 2006, I commissioned the project. Otherwise, my lord, if they had said, they reneged on their promise, or they would have simply said that 18.6 doesn't save it, or other provisions do, I would not have commissioned. So therefore, my lord, my existence, my birth itself is under that government order. And even otherwise, if your lordships were to take that way, that the government, you cannot cling on to the government order and not show me the statutory provisions under which you rely upon. I am showing 18.6 to my lords, where it continued. And even the 18.6 also, my lord, the power purchase agreements anta nodidru, no, it deals with the banking. Now, even if your lordships were to, suppose I had entered into an agreement with KEB, I would have entered into an agreement with KEB with these charges only. Therefore, if I had entered, that's only hypothetical, I have not entered, but still I am saying, Lord, that agreement would have been, even that agreement was saved, it would have saved. Now, my lord, during that era, many have entered, like my lord, my learned senior's client has entered into an agreement during that era. Perhaps that agreement will continue. So in my case also, that question is hypothetical because there was no. So therefore, my lord, the legal entitlement to banking is one, statutory. Second, the government order that made me exist and set up the project, make investments and continue all the contracts under the earlier regime is not just, my lord, it's an executive order. They say, my lord, that in the central government's objection that is filed in GOA, they say under Article 73, we have executive powers to issue that. And the government is omnipotent. They are the shareholders in the KPTCL. They are the complete, my lord, regulate under 108, Section 108 of the Electricity Act. They have right to 107 of the Electricity Act. They have right to issue directions. So all that power was there with them. And they could change the law also, bring state amendments also. Or in my case, simply, my lord, the agreement could have been very different that they have entered into. But the agreement was consistent with the earlier clearances granted. And the charges varied because the government function, the very government, which was acting as the quasi-regulator then, had invested its function of quasi-regulation to KERC, and KERC, my lord, molded. Now, my lord, the question is that now I was given annual banking till, my lord, this month, about 8th or 9th of this month, because I have not, even now, my lord, I am entitled to annual banking. Now, question is, they say that once you cross this barrier of you come under the GOA regulations, and GOA regulations mandate that application should be made under GOA because the rules mandate it. And our GOA regulations say that banking period. Now, that also, my lord, the regulations, even if you're in the most unlikely event of, my lord, sustaining the rules, it only gives the minimum prescription of 1 month. It doesn't say. Now, lordships asked, Lord, a pointed question to both, where is that banking? It is alien to the scheme of the act, etc. If that was so, Lord, it wouldn't have found place in the rules or regulations also. In the regulations, minimum period of 1 month should be given is what is mandated. Now, they read this minimum to be maximum and change that. And, my lord, I am supplementing this submission by saying, for all those, after the regulation, after the green energy open access rules were promulgated by the central government in June 2022, also they have given annual banking. Because the KERC notionally fixed one date as January 2023 and said, all applications to be filed beyond this date. That where does the date come, Lord? We don't know. Now, if there has to be an uniformity, Lordship said, my lord, that ಕೆಲವರಿಗೆ free, ಕೆಲವರಿಗೆ ಹಾಗೆ. Yes, it is true. Not in the batch that, my lord, we are there. No. The problem now is, my lord, from January, now June 2022, the rules have come. Like the petrol rate, my lord, I said, from this date, the petrol rate is revised. Banking rate is revised under the GOA regulations. So all of you are in the same banking regime. The GOA, adu madalla. GOA regulations apply ಆದ್ಮೇಲೆ ಎಲ್ರಿಗೂ ಒಂದೇ ಮಾಡಲ್ಲ. ಒಂದು ನೀವು ಹಳೆ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಎಲ್ಲ ಇತ್ತಾ, you are not asking open access from me, I will grant annual banking and 2% banking charges you till your agreement continues. After that also, if I don't make an application, the charges don't come. If I go to some interstate, somewhere else, the question of annual banking, that issue is erased. Only when I am making an application after January 2023, this date also lordships may see, that date has no mention or no effect at all. In fact, my lord, as latest as April, they have granted annual banking to the applications made. ಆಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರು, June 2023, they passed an order saying that we are implementing that regulation in Karnataka. Lordships may see this. Their own regulations were passed. ಆಯ್ತಪ್ಪ, ನಿಮ್ಮ regulation pass ಆದ್ಮೇಲೆ ಆದ್ರೂ ನೀವು annual banking ಇಲ್ಲ. There is a date after that also. ಆ date ನಿಂದ ಬಂದರು. Now, Lord, I ask myself, I am in the market, competing market. One set of people, they are in annual banking. They may not have commissioned the project when there was hydrology risk. I was the first one to venture. The cost of establishing a hydro project was very high. The time required for establishing the hydro project was very high. I took risk. And, my lord, on the promise in 2006 and prior to that also, ಈಗ ಬಂದು ಈಗ hydrological risks have reduced. Then, my lord, amount is also very less because many people are in the market, equipment cost is less, and rate, my lord, I can dictate rates. Now it's a buyer's market. Now, ಅವ್ರಿಗೂ annual banking, annual charges 2%, 5% billing. Regulations ಬಂತು, ಅದಾದ್ಮೇಲೂ, rules ಬಂತು, ಅದಾದ್ಮೇಲೂ, January 2023, some rate, some, my lord, date is fixed, as some happy date is fixed, and from that date, this, my lord, is applied. And cutoff date is 2nd January 2023. Lordships may note that. But I made a vague reference. I have referred that as the long-term rate. Now, my lord, nowhere the objections filed here address the legal issue, my lord, that either save agalla, save agatte, that objection is filed. But in this agreement, in this, they don't show that in 2006, the government had to answer this question, right? That why was I allowed to even set up the project? Because up to 2006, I merely had a paper in my hand. I had not established the project. In 2006, you induced me by saying all approvals, etc. are applicable to you. You set up the project. And now you are saying that new regime comes and you change the course. And finally, my lord, on GOA charges, lordships permit, I'll continue the argument in this petition itself. Now, my lord, the objections are filed by central government. I'll conclude, my lord, by this submission. Now, kindly see, my lord, the objections filed by the central government, which lords are made available to lords. The logic advanced is, kindly see, my lord, paragraph 8. Sorry, the specific, my lord, the heart of the case they have made out is, my lord, the source of power, which your lordships will find, entry ತೋರಿಸ್ತಾರ ಇದಲ್ಲ ಇದೆ sorry, my lord, the objection statement yes, I'm sorry, my lord, page 21, ink page 21, this is the heart of the argument, my lord. They say, am I reading with you? In this context, in the middle of that page, ink page 21 of their objections, my lord, para 18.7, the sum and substance is this logic, my lord. In this context, lordships get it. In this context, while petitioners curiously concede that electricity as a subject of litigation under so-and-so of the so-and-so in list 3 of the concurrent list, it has escaped the attention of the petitioner that Schedule 7 of the Constitution places participation in international conferences, associations, and bodies implementing decisions thereat. Idu our source. Now kindly see, my lord, the Constitution. Idralli conference ige hogbodu. International conference, not conference, international conference, international associations, etc. And the decisions taken thereat can be implemented is the source. So I don't derive my legislative competence or constitutional competence under the entry that the petitioner is alleging. I derive under entry 13 of list 1. Entry 13, list 1. That, my lord, there is no quarrel with that. Now, my lord, I am not admitting, not presuming that even the Electricity Act also is a result of that conference. Like, now, my lord, international covenants mandate reduction of carbon, etc., etc. So the objective, if your lordships were to see the objective of the Electricity Act, it says benign policies for renewable energy. And my lord, this is not traceable to, this is the complete prerogative of the central government. I will, my lord, presume, not admit. Not just the rules, the act itself, not under it, not traceable to list 3, this is not in concurrent list, it is your prerogative. Now, my lord, my question is, my lord, to myself, that the parliament in its wisdom, not, my lord, the central government, the parliament in its wisdom has enacted a law under the international convention or whatever to say that under 86(1)(e), it shall be the function of the Electricity Regulatory Commission to promote renewables, 1. Secondly, under section 42(2) of the Electricity Act, it shall be the duty of the State Commission, which your lordships have read. I will not, my lord, bother your lordships again. Under 42, the onus of implementing open access is given consciously by the parliament to the, my lord, the state commissions. And all these entities are licensees of that state commission. That was the understanding, my lord, because you are licensee of a state commission, you know their financials, how much they have to be compensated, not compensated, etc. Therefore, the regulatory function in the state where there is intra-state supply is to the state commission. Now, this is a parliament-made law under international convention, etc. Now, the government makes a rule. Lordships may draw distinction. Parliament makes act. Government of India makes a rule and says parliament is wrong. That I will make rules. The legislature union of India may have delegated the power to that. Under my executive power, under 73, they also refer to, my lord, Article 73, that they have powers to frame. I am, my lord, not joining them in that quarrel at all, that they have complete legislative competence. The Union of India has complete legislative competence. In fact, my lord, if they have made act, how can they not make rules? But if the parliament says, and then, my lord, the rules have to be placed before the parliament. Even these rules have to be placed before the parliament. Lordship saw, my lord, there is a specific provision under the Electricity Act for the rules made by the central government. Lordships may, my lord, see the specific section. Power of the lordships may see 176, 176. My lord, yes, lordships. One is, my lord, the previous publication, of course. 176. Also, my lord, there is a provision. I'm sorry, my lord, not able to lay hands immediately. All regulations shall be subject to previous publication antide. Adu agirbodu. And this shall be placed in the part. Now, even, my lord, for argument's sake, I'll show that exact provision, my lord, my apologies. But pending that, lordships may see, I am ready to 182. I'm grateful to. Yes, Ade Tara Central Legislature. And even I am, my lord, ready to presume that it is placed before the parliament. And parliament also, my lord, has assented. 179. I'm sorry. I'm grateful to my learned friend. 179 says that rules and regulations to be laid before the parliament. Whether it is done, not done. Now, whether I will presume it. That is placed before the parliament. Now, the parliament cannot quash this or not reject this. They will only have to amend it or modify it. Lordships may see the provision also. 179, my lord. Every rule made by the central government, every regulation made by the authority, every regulation made by Central Commission shall be laid as soon as after so and so, so and so, before each House of Parliament while in session for a total period of so and so, so and so. Then, my lord, however, that such, now there is a House shall agree in making any modification in the rule or regulation, that the rule or regulation should not be made. The rule or regulation shall thereafter have the effect only in such modified form and as the case may be. However, that the modification or the annulment shall be without prejudice to the validity of anything previously done. Now, there is no material to show even in the objection statement filed because I'm just relying on the pleadings, my lord. Where I have made an allegation in the petition itself. 179 is complied or not known. Suppose this was placed in the parliament, they would have seen parliament kanun madide, your rules itara madidare, it would have been amended or rejected. Second argument is, even presuming against me, my lord, it is laid down. Does it, my lord, empower the government? Does it empower the government to overrule a parliament-made legislation, enactment, by way of an executive order, to say that, my lord, what power the parliament has given to the state commission will be usurped by the central government, or tomorrow, my lord, state government also will make a rule now, just following the suit from there. So therefore, my lord, I am saying, first, my lord, the last argument first, the central government has no competence, central government has no competence to make these rules. Parliament has made Electricity Act, which is inconsistent with that. Secondly, my learned friend rightly and fairly conceded, my regulations are not in consistence with that rule because I made some other regulation, now independently verify them. So by that logic, my lord, the regulation should go, because even in the union government's objection, they say, ಇವ್ರೇನೋ ಬೇರೆನೇ ಮಾಡಿದ್ದಾರೆ, ನಮ್ಮ ರೂಲ್ಸ್ಗೆ ಅದು ತುಂಬಾ ಅದೇನು ಒಂದೇ ತರ ಕಾಣಿಸೋದಿಲ್ಲ, ಸ್ವಲ್ಪ ಬೇರೆ ಬೇರೆ ಇದೆ, ಹಾಗಾಗಿ ಅವ್ರದ್ದು ಮಾತಾಡ್ಲಿ ಇವರು ಅಂತ ಹೇಳ್ತಾರೆ. Then, my lord, by that logic, if you test it on the annual, if not the rules sustain, then regulations go. If they say independent argument was advanced, that dehors the validity of the rules, regulations sustain. Regulations will have to go because if the rules are sustained, if rules go, then regulations will not go. Third argument is, my lord, independent argument is this: the regulations are a cut and paste, and by virtue of regulation 5, rule 5, they have to fall in line with the, even if they have made an inconsistent provision also, rules prevail. So indirectly, my lord, what the central government did was enacted a regulation which was the exclusive province of the state commission under 86, read with 42, 2 and 5, and then said, follow this, your regulation, etc. If is, my rules remain. So the regulation is made by the central government already, and this is only a farce that, my lord, the regulations are just semblance of some regulations are made, and to show that we have also made a regulation. So regulations go. Now, my lord, the last argument, my lord, and I conclude. The banking period, my lord, in Brindavan's case was, as per the government agreement, annual, monthly, whatever, my lord, is the prerogative of the State Commission. Let them look at the agreement that I have entered. I am at liberty to show to them that this is my entitlement and let them continue because they have continued to all others. One. Secondly, my lord, as far as charges are concerned, Lordship said, my lord, that pending final adjudication, 50% has to be paid. Now, my lord, I am only confining my argument to that by saying this. If the rules go, presumably, not presumably, if your lordships are prima facie inclined to, my lord, set aside the rules and regulations, then the order of June 2023, where the Regulatory Commission said, implement the GOA regulations and these charges where regime was introduced. That order remains. If the rules and regulations go, that order goes. In the void, there should be some charges payable and it cannot be, my lord, a vacuum and a laissez-faire that you don't pay any charge. Now, my lord, for that, I have submitted on the last date, as per the definition of wheeling defined in the Electricity Act, it's a composite charge. That charge, my lord, is paid in kind, not in cash. Now, the biggest shift is, my lord, not the quantum, the kind versus cash. The regulatory regime that prevailed earlier, Lordship may for a moment, my lord, ignore whether that charge was more or this charge was more, whether it covered all the charges or not is another argument. But no cash component was ordered to be paid by any generator, renewable energy based generator, even to this date. And my competing entities who are in the market today, who are, my lord, enjoying the laissez-faire, whatever, my lord, is to be called, they are only paying billing charges. That billing charge, my lord, is paid across the board by all generators. And I am here, my lord, challenging those rules and made your lordships, my lord, persuaded your lordships to the extent possible that rules are bad. Now I will pay 50% of the cash component. Now, those who did not come and join issues with me, and even there are other interim orders granted in the similarly situated cases, not before this honorable other courts, and those who did not come to court also, they are all enjoying that, my lord, billing charges. They never filed a petition to the KERC or before this honorable court. These rules are in effect. Aurdu itara charges inge, aurdu bere ide, aurdu bere ide. Suppose, my lord, I'm posing this hypothetical question to myself. If BESCOM is, my lord, given a charge of 100 rupees payment, transmission charge to be paid to KPTCL, Chamundeshwari is given 20%, 20 rupees, MESCOM is given 30 rupees. And your lordships will say that new court even 50%. Now 100 becomes 50 or 20, 30 will remain. This is, my lord, the regime, imbalance in the regime that will create. For that, my lord, the KERC, the KPTCL's application, I also showed to my lords. I'm just winding up the argument, my lord. The application asked the KERC to fix the charges in respect of ESCOMs and short-term open access consumers in 2023. So therefore, their ask itself was that. But KERC, my lord, looked into this matter and said, all right, you have asked this, you take these charges, it is entirely paid. But I will fix a separate charge in June 2023 for which you will become entitled. And that was prospectively made applicable. My respectful submission is, my lord, in the same year you cannot pass two orders is what I have challenged, my lord. That is that on that ground, that order also has to go only in the event all these rules, regulations, etc. sustain. Because the Electricity Act itself says no two tariff orders can be passed in the same year except for the fuel surcharge adjustment. You cannot repeatedly pass orders. One. Secondly, my lord, more importantly, if multiple regimes are created in this manner, and the competition element within the renewables and within the ESCOMs also. Some ESCOMs have higher obligation to buy renewables. And then, my lord, this low, high, whatever regime is paid. In Gulbarga, Hubli, etc., that is not there. Most renewable projects are concentrated or PPAs are assigned to BESCOM. That will be one other skew that will happen. So my prayer is, my lord, pending this, now the application, review petition is also filed to that tariff order. I don't know, my lord, whether on this ground or some other ground, review petition is also filed. Yesterday, that matter had come up before KERC. Now, all that I am praying is, my lord, in final phase, that let these charges be, let the rules and regulations be set aside. And let KERC be asked to decide, my lord, whatever charges are applicable as per their own regulations. MYT regulations are announced yesterday. My lord, KERC's council is here. The multi-year tariff regulations are announced yesterday. They were notified just in anticipation of this hearing. And the MYT regulations provide how to fix wheeling charges. That is also there. How to fix wheeling charges, how to fix banking charges, how to fix transmission charges. Everything is there. Under that regulation, let them, Lord, be given 15 days, 1 month, 1 week time to determine ad hoc charges, not final charges, ad hoc charges. And we will, Lord, present all this material before them and show that transmission charges ಇಷ್ಟ ಆಗ್ಬೇಕು ಅಷ್ಟ. Then what will happen, my lord? Then what will happen is all generators will get covered. Here, my lord, selectively some of us are here. Some of us are in there, some ಅವ್ರನ್ನೆಲ್ಲರನ್ನೂ ನೀವು ಕ್ಲಬ್ ಮಾಡಿ ಆ KERC ಬುಟ್ಟಿಗೆ ಹಾಕಿ ಅವರು MYT ಅವರು ಚೆನ್ನಾಗಿ ಅವರು ಒಳ್ಳೆ ಚಾರ್ಜಸ್ ಹಾಕ್ತಾರೆ. Therefore, my lord, that will take care of all the charges of all consumer. Then consumer tariff also they will have to consider. By charging me this, how much should be the transmission tariff paid by my learned friend client ESCOMs? How much should be the transmission charge to be paid to SLDC? Then other entities. There are multiple ramifications. If my charges are altered, my lord, there will be a cascading effect, and good or bad, ripple effect, I would say, domino effect. So therefore, my lord, my respectful submission is regulator is the best expert. They know everything. And let them be, my lord, given 15 days time, 20 days time, only to fix provisional tariff. They may not be able to, my lord, fix the final tariff. Let them fix that tariff. We undertake, my lord, to go before them and show that this is the regime. They know how that skewed regime has taken place. So therefore, my lord, only constitutional court may look into the constitutional validity. Tariff function, my lord, very expert bodies are there, regulatory commission, and they have been ably aided by the ESCOMs also. They will defend their interest before the KERC, and tariff functions be real. This is all. Grateful.
Yes. Good. Shall we do it on Monday, 4:30?
I'm not available the next week, therefore could finish it today.
Oh. Taking some time to absorb what Sridhar Prabhu said, so it's becoming a little
It will also take some time to observe what he said.
No. I was as not simple as I could get.
Time is unnecessary.
Because he said 5 minutes.
Doesn't apply to him. With great respect.
That's why I didn't interrupt. If I had interrupted, you would go on for one more hour. Whatever he wants to finish.
But then your lords may come back and we'll argue it after.
No, but there's a problem for that interim arrangement that
So far as my lord, Rolla's clans.
no, Mr. DL and Rob and
That of course, transmission charges, I was not arguing. I'm only arguing this banking issue.
you're not involved in that
In
transmission.
the transmission, Lord, I've not been, they told me first and
Then I'll listen to Kamath and then get back. Then I'll grant an interim order asking them to pay transfer charges at 50% till 19th.
yes, sir, 50%.
You know, again, I am praying, Lord, that let KERC be given some job. All, my lord, everything we are relying on lordship's orders, my
I
lord.
will give them
The
that job.
KERC is before your lordships.
Give them the job, but you make a deposit until then let nothing.
ಅಲ್ಲ ಈಗ ಏನಾಗಿದೆ ನಾನು ಹೇಳ್ತೀನಿ ಈಗ ಆಲ್ರೆಡಿ ಕೊಟ್ಟಾಗಿದೆ ಈಗ ಅವರಿಂದ ಆ ಕನ್ಸ್ಯೂಮರ್ಸ್ ನಮಗೆ ವಾಪಸ್ ಕೊಡಲ್ಲ. This is not the difficulty. Consumers have already sold, their goods are sold based on the electricity. Prospective, whatever your lordships may fix, my lord, fixed prospect.
If I accept your contention.
Yes.
I'll direct the refund of that amount, isn't it?
ಅಲ್ಲ ಈಗ ರಿಫಂಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಪಾಪ ಅವ್ರಿಗೂ ಆಮೇಲೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
ಏನು
ಅದು ಆಮೇಲೆ
ಕಷ್ಟ
ಅವ್ರು
ಆಗಲ್ಲ.
ಕೊಟ್ಬಿಟ್ಟಿರ್ತಾರೆ ಬೇರೆಯವ್ರಿಗೆ.
One-
ಅವ್ರ
one day will
ರಿಫಂಡ್
return.
ಇಸ್ಕೊಳ್ಳೋದು ಮಿಲಾಡ್ ಅವ್ರಿಗೂ ಕಷ್ಟ ನಮಗೂ.
ಇಲ್ಲ ನಮಗ್ ಕಷ್ಟ ಇಲ್ಲ.
No, no.
Monday will
ಕಷ್ಟ
return.
ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲಿ ಆ ಕೇಸೇ ನಡೀತಿದೆ.
ಒಂದ್ ಕೆಲಸ ಮಾಡಿ
Yes.
ಡಿಪಾಸಿಟ್ ಮಾಡ್ಬಿಡಿ ನಾನೇ ವಾಪಸ್ ಕೊಡ್ತೀನಿ.
ಸಾರಿ ಮಿಲಾಡ್, ಸಾರಿ.
ನಮ್ ಕೋಟಲ್ಲಿ ಡಿಪಾಸಿಟ್.
ಅಲ್ಲ ತಮ್ಮ
ನೀವ್ ಗೆದ್ರೆ ವಾಪಸ್ ನಾನೇ ಕೊಡಿಸ್ತೀನಿ.
ಅಲ್ಲ
You don't have to go there and.
ಅಲ್ಲ ಈಗ ನಾನು ರೆಡಿ ಆಗಿ ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದೆ. I bow down. Whatever your lordship said, my lord, we bow down. If they are not arguing, my lord, should they be rewarded for that? That's all I'm saying. Till 19, lordship may fix 100% charges after my lord lordships hears and we don't satisfy your lordship. But we have satisfied your lordships, my lord, to the extent possible. And if they seek time, lord, is it a suppose they had argued today, your lordships have, my lord, perhaps given the judgment today. Even union government doesn't argue. And the pleadings are not complete in my learned senior's case. In my case also, my lord, 7-8 pleadings are not complete. Anyway, I'm not blaming, my lord, same pleadings they will file. But all of the skewed regime will happen. That's all I'm saying. Others will continue to enjoy, those who are not before your lordships. And those who are getting interim orders in Dharwad and Gulbarga, our own clients. I'm not saying that anybody else. They will also pay. We will also, my lord, 50% now cut.
Comes from this court, all of the courts will modify.
ಅಲ್ಲ ಹಾಗೆಲ್ಲ ನೀವು ಅದರ್ ಕೋರ್ಟ್ಸ್ ದೇ ಕೆನಾಟ್ ನಮ್ ಕೋರ್ಟ್ ಇದೆಲ್ಲ ನಮ್ ಕೋರ್ಟ್
ಅಲ್ಲ may I clarify your lordship.
She will not give.
ಅಲ್ಲ ಈ 50% ಮಾಡ್ಬೇಡಿ. ಅದೇನಾಗುತ್ತೆ ಇವ್ರು 50% ಇಷ್ಟೆಲ್ಲ ಮಾಡಿದ್ರು ಅವ್ರು ಏನ್ ಅನ್ಕೋತಾರೆ ಇವ್ರಿಗೆ ಇವರು ಈಗಲೇ ಕೊಡ್ತಾ ಇಲ್ಲ. ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಮೇಸಿ ಈಗಲೇ ಓಪನ್ ಆಕ್ಸೆಸ್ ಕೊಡ್ತಾ ಇಲ್ಲ. ಅದೇನೇನೋ ಕಾರಣ ಹೇಳಿ ಕೊಡ್ತಾ ಇಲ್ಲ. ಈಗ ಅಂದ್ರೆ ಲರ್ನೆಡ್ ಸೀನಿಯರ್ಸ್ ಕೇಸ್ ದೇರ್ ಇಸ್ ಒನ್ ಕೈಂಡ್ ಆಫ್ ಇಂಟ್ರಿ ಆರ್ಡರ್. ಇನ್ ಮೈ ಕೇಸ್ ಒನ್ ಕೈಂಡ್ ಆಫ್ ಇಂಟ್ರಿ.
I'll make one kind.
ಅಲ್ಲ ಬೇಡ ಸರ್ ಆ ತರ ಎಲ್ಲರಿಗೂ ತೊಂದರೆ ಕೊಡುವಂಥದ್ದು. ಐ ಆಮ್ ಓನ್ಲಿ ಸೇಯಿಂಗ್ ಲಾಟ್ ಬೆನಿಫಿಟ್. ಅವ್ರ ಬೆನಿಫಿಟ್ ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟೇ. ಪ್ಯಾರಿಟಿ, ಉಲ್ಟಾ ಪ್ಯಾರಿಟಿ ಅಲ್ಲ ಸರ್, ಸೀದಾ ಪ್ಯಾರಿಟಿ. ಐ ಆಮ್ ಓನ್ಲಿ ಸೇಯಿಂಗ್ ಲಾಟ್ ವೈ ಶುಡ್ ಐ ಬಿ ಪೆನಲೈಸ್ ಫಾರ್ ವಾಟ್ ಲಾಟ್ ವಿಲ್ ಹ್ಯಾಪನ್ is it will be an imbalanced regime. That's all. I leave it at that, my lord. I am nobody to, my lord, say This is only, my lord, ESCOMs have to then, at least I pray to their conscience that multiple generators, they are giving annual banking, even after the rules. Because they didn't challenge. We challenge, we are being rewarded for our.
Allah, I stated on record, your lordship, we are not giving annual banking to anyone.
Anyone allapa.
Anyone except for those who have.
Based on that affidavit, they are charging annual GOA charges to all renewable energy projects in Karnataka and our affidavit hakli.
For those who have expired.
There's an agreement.
Agreement idavri alla. After the GOA rules.
After the GOA rules, yaar expire ಆಗಿದ್ಯೋ ಅವ್ರಿಗೆ ಆಗ್ತಾ ಇದೆ.
Expire ಆದವ್ರಿಗೂನು.
ಇಲ್ಲ ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ retrospectively apply ಮಾಡಿ.
Even after the rules have come, expire ಆಗಿದ್ರೆ ನಾವು ಅವ್ರಿಗೆ GOA charges ಹಾಕ್ತಾ ಇದೀವಿ ಅಂತ ಅವ್ರ affidavit ಹಾಕ್ಲಿ ಸ್ವಾಮಿ. And lordship levy 100% charges should be imposed on us. I give that undertaking right away. I'll file the personal affidavit that after January 2020.
Why are you getting personally involved in this personal affidavit?
No, Lord, Allah, your council knows that not those charges are not being charged. We all, my lord, we work together and we appear in public hearings. We are aware, my lord, how the charges are levied. We are all a regime, my lord. We are not.
You're getting too emotional in this.
No, not emotional. This is only.
He's transmitting a lot of things.
I'm saying, Lord, after 2022, multiple generators are being charged, multiple levels.
Let me listen to Mr. Rao.
I am getting the shock from him.
You're not the only one.
So, my first request is, let me say something for 5 minutes. Number one, my lord, as I have already said, pleadings are not complete in my case. There is an interim order of F, G and H, the demand notices granted in the month of December. Till today, my lord, they have not come up with any application, let alone statement of objections. That interim order continues even today. My lord, just page 131 of my paper book, if your lordship would see, which is very far, is it? Annexure D. Annexure D page. It starts at 72, my lord.
Yes.
This is the tariff order of 2023, which is under challenge in my writ petition. Kindly go to page 131. Third paragraph. There is no mention of paragraph. May I read?
Page
131 of this tariff order of 2023.
Yes.
As determined above, the transmission charge of rupees so and so per megawatt per month is applicable for all long-term open access consumers for the financial year 24, excluding regarding projects for which separate orders issued by the commission would be applicable. ಇದು ನಮಗೆ ಅಪ್ಲೈನೇ ಆಗೋದಿಲ್ಲ ಅಂತ ಅವರೇ ಹೇಳ್ತಾರೆ. ಸಪರೇಟ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ರಿನ್ಯೂವಬಲ್ ಎನರ್ಜಿ ಟೈಪ್ ಆಫ್ ಪ್ರಾಜೆಕ್ಟ್ಸ್ಗೆ separate tariff order also does not say it applies to us. My lord, prima facie they have no, my lord, the tariff order itself says that they cannot charge. That is the main attack, my lord. Number two, my lord, insofar as the interim order of annexure F, G and H, it comes to about nearly 60 lakhs. Demand notices. Payment mode. Annexure L on 19/12/23. Annexure L at 209.
Yes.
My lord, I have paid the amount under protest, part of it, out of about 60 lakhs, nearly 27 lakhs and odd I have already paid under protest. Therefore, my
Already paid 50%, virtually 50%.
virtually 50. So therefore, my prior to filing also, my humble submission is continue the interim order as granted, my lord, till 19th and
The effect of my order is this will continue. This 50% that you paid will continue even now for future transmission. Because you already paid 50%.
interim order is stay of F, G and H, the demand notice.
This for the earlier period,
ಅದರಲ್ಲಿ
for the
nearly 50% ಕಟ್ಟಿದ್ದೀವಿ.
You've already paid 50% for the prior period.
Not exactly 50,
Almost.
nearly 50.
So
So
thereafterwards-
19th, if your lordship would kindly have it, Lord, on that day we'll complete.
Until then, for you to have open access, you will have to have pay transmission charges at 50% of whatever is determined under the tariff 24.
Lord, the
subject
effect
to
of
the
the
ultimate-
interim order itself goes. The fact that interim order is granted after a learned single judge of this court, my lord, appreciated the contention that this tariff order does not apply to renewable energy projects. That is very clear in the tariff order itself. If that be so, my lord, how can they charge me? That is the main contention. That is the thrust of the arguments. And number two, of course, my lord, making regulations where the act itself does not give such power. And the third one is levy of all these things, my lord, is in the teeth of Article 265. It can't be done by a rule or a regulation. It should be done only by a statutory power under the act. There are a couple of judgments of the Honorable Supreme Court. Lord, even in Mupil Nayar's case, Constitution bench held that was a case of a tax. But under Article 265, tax is defined to include any kind of a levy, fees, including financial burden. If that be so, and what you want to levy should be only under an enactment, not by virtue of using a residuary power to make regulations and then rules thereunder, and the tariff order which is made thereunder exempts me, my lord, under the tariff order. And the separate order, they say, separate order does not refer to RE, renewable energy projects. If this is the crux of the problem, my lord, making me to again pay in future, my lord, it's a little, my lord, I don't know the appropriate word. It works a lot of hardship. On the one hand, we are standing on the rooftops and crying, shouting that green energy, pollution free, we want all this. My lord, so many of them have invested crores of rupees and my lord started these projects. Today you come, after giving all these kind of exemptions, today you come and say you pay. Under what circumstances? Tariff order doesn't say, subsequent order doesn't say. Where do they have power to do all these? This is the crux of the problem. It is not as if I am running away. My entire property is there. So many investments, so many machineries, everything is there. In 1 week, my lord, from today to 19th, a week or 10 days, nothing is going to happen. Continue, my lord. My humble submission is continue this interim order. At least in this case where I have already paid part of it, even before filing the writ petition. If that be so, I have shown, my lord, that I am a law-abiding citizen, notwithstanding that I am not liable to pay, I have paid in advance. Look at that, my lord. And then please continue the same interim order till about 19th. When they make their statements, let them complete their pleadings. I do not know under what circumstances, whether they have pleaded that it should be modified. What are the reasons given? I do not know. I am not served with any application for modification also. Therefore, humble submission is please continue. After having paid this, Lord, I deserve, that is the appropriate word I thought I will use, a continuation of this interim order in 10 days, Lord, when I have an interim order for 7 months. Having paid 50%, nearly, I don't say 50%, nearly 50, maybe 40, 45% approximately. That I have shown my bona fides.
Yes.
Am I not entitled for continuation? That will be my submission insofar as modification. On merits, of course, I can cite a couple of judgments. I won't take more than half an hour. And I will take 25% of the time taken by Sridhar Prabhu. Not even that much.
So he started saying 5 minutes. So you can only take 1 minute.
Yes.
He said 5 minutes and took whatever time.
So I'll have to stand up and sit down.
1 minute.
Yes, anything else?
Your Lordship, the subsequent tariff order that they're talking about is there at page number 162 of the petition, where KERC has held that for renewable energy projects falling under GEOA should pay transmission charges at the rate determined in the earlier order. That subsequent order has been made by KERC. So it is not correct to say that there was no order of KERC enabling us to collect the transmission charges.
Same amount.
Same amount. It is a page number
What is the
162,
total amount due from all of them, all the petitioners?
30 crores,
Only regarding transmission charges?
only the transmission charges.
In all these cases, their agreements are over.
All these cases agreements are over. That's why it's being levied.
That Govardhan and
The earlier agreements are over, new agreements are entered into. New agreements also provide for payment of transmission charges.
except those two which had the agreement with the government.
There also, the earlier agreement has expired. They have not entered into new agreement.
The prayers in this writ petition are lay a challenge to the rules that have been framed by the central government and also the regulations that have been framed by the regulatory commission. These rules and regulations are attacked mainly on the ground that the petitioners have a vested right in securing an annual banking facility as compared to the monthly banking facility that is provided under the present regulations, which are the subject matter of challenge. It is also forthcoming from the arguments advanced by both sides that the petitioners did enjoy the benefit of not paying any transmission charges by virtue of being a renewable energy generator. The imbued regulations, however, do contain a provision which, that's an order, isn't it? That's an order by the KRC.
Order determines the, it quantifies the transmission charge, but regulations provide for payment of the
Which is
transmission.
that annexure?
In which matter, Your Lordship?
ನಿಮ್ದ್ರಲ್ಲಿ ಇದೆಯಾ? ಎಲ್ಲಿದೆ ಅದು? Where is that order?
Yes.
I'll point out, Your Lordship.
Vrindavan, what that order?
Your Lordship may see page number 84. Page number 84 of Brindavan.
Yes,
I'll just point out.
that is not the regulation.
That is a regulation which provides for payment of transmission charges at 11(1)(a).
You said there's an order that is passed. The 2024 tariff excluded RE projects.
Lordship may see
Then,
page
then,
91.
then at 91,
91, 8623, Lord.
91, our relevant pages are 94. Paragraph 5. 94, paragraph 5. This is quantification of the charges. The authority is traced to the regulation.
94?
94, 5.
3,000 rupees until above.
Regulation, the transmission charges, 5(1), transmission charges along with the transmission losses as determined by commission in its tariff order shall also be applicable.
Charging that the KERC has passed an order on 8/6/2023 in the matter of implementation of KERC bracket terms and conditions for green energy open access, close the bracket, regulations 2022, holding that the transmission charges along with transmission on losses as determined by the commission in its tariff order shall also be applicable for a transaction coming under the green energy open access. The effect of this order is that even in respect of a renewable energy generator, there is now a requirement to pay transmission charges at the same rate at which a non-RE generator pays the transmission charges. Next paragraph. Arguments are advanced by both sides regarding the legality of this transmission charges. In fact, the principal argument advanced by Shri Sridhar Prabhu is regarding the very validity of the rules that have been framed by the central government and also on the ground that the regulations framed by KRC is basically on the powers, basically on the obligations imposed under Rule 5 of the central government rules. Next paragraph. Senior Counsel Shri D.L. Rao submits that the petitioner had the benefit of an interim order right from December 2023, and therefore there is no justification for modification of the interim order. Shri Shahbaz Ahmed, no?
Hussain.
Hussain, on the other hand, contends that the present set of petitioners are enjoying the benefit of free transmission charges, though there is a regulation and an order passed by the KERC to determining the transmission charges payable by renewable energy generators. Next, in my view, it would be appropriate in the given facts and circumstances of the case to direct the petitioners herein to pay 50% of the transmission charges that have been determined by KRC in its order dated 8/6/2023, subject to the ultimate result of this writ petition. On payment of these transmission charges, the petitioner shall be granted open access without any further impediments. Relist on 19th for further arguments.
Great. Grateful. Lord, in my case that I had made that payment under protest.
Already
Can
payments
be
already
adjusted.
made, maybe taken account.
No, this is only for future. Whatever is paid earlier, I'm not doing anything.
That may be clarified.
It is made clear that the transmission charge will be paid only in respect of the electricity injected into the grid after the passing of this order.
Great.
The arrears need not
Grateful.
50.
Grateful.
Yes.
Till the next
Collective
date.
benefit
Very well.
Till the next
Yeah,
date.
yes, sir.
Till the next date.
plan 19th ಬಂದೇ ಬರುತ್ತಲ್ಲ
ಬರುತ್ತೆ ಅವತ್ ಮತ್ತೆ ಅವರು 2 ವಾರ ಟೈಮ್ ಕೇಳಿದ್ರೆ ತಾವು ತಿರ್ಗಾ
ಅವಾಗ ಎಲ್ಲಿ ಪಾಸ್ ಮಾಡಿ
But
ಅವಾಗ ಅದನ್ನ ಅದಕ್ಕೆ ಅಲ್ಲಿವರೆಗೆ ಅಂತ ಹಾಕಿದ್ರೆ ಒಳ್ಳೇದು.
But 76 copy has not been given. Where?
for future
Hopefully-
open access ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ಮತ್ತೆ ಹಳೇದೆಲ್ಲ ವಸೂಲಿ
from the date of this order ಅಂತ ಹೇಳಿ
ಅಲ್ಲ ಹಂಗೆ
ಹೇಳಿದೆ.
for availing open access.
ಇಲ್ಲ ನೀವು ಒಂದು ಡ್ರಾಫ್ಟ್ ಕೊಟ್ಬಿಡಿ ನಾನು ಸುಮ್ಮನೆ ಸೈನ್
Payment
ನಾಟ್
to
ಬಿ
be
ಸ್ಯಾಟಿಸ್ಫೈಡ್
deposited in the court.
But the 76.
ರೀಫಂಡ್ ತಾವು ಹೇಳಲಿಲ್ಲ.
ಯಾವ್ದ್ರದ್ದು
ನಾವು ಪೇಮೆಂಟ್ ಮಾಡಿ
ಸಬ್ಜೆಕ್ಟ್ ಟು ರಿಸಲ್ಟ್ ಅಂತ ಹೇಳಿ
and it will be refunded ಅಂತ ಬರೆದ್ರೆ ಒಳ್ಳೇದು. ಯಾಕೆಂದ್ರೆ there are couple of
I
cases
said it's subject to the result. So
and
if
the
you succeed,
authority shall refund ಅಂತ ತಾವು.
needless to state that the transmission charges that are to be collected by virtue of this order shall be subject to the result of this writ petition.
Will be refunded by them ಅಂತ.
Subject to the writ petition, and in the event the petitioner succeed, they would definitely be entitled for a refund.
But in this matter, copy is not given to the AER.
Please collect it. Don't make me wait for. Thank you.
May I mention item 80? May I mention item 80? Yeah.
Nondu, I'll just tell you. Petition matters, don't you? 18th. 18th, okay, 18th, I'm not sure. I'm just sure. Soham is on 19th. We'll check everything. Can you just take a pen and just write down the name?
ಇದು 19th ಗೆ.
19th.
19 ಲ ಯಾವ ಡೇಟ್?
19th.
ಅದು ಎಲ್ಲ ಅವತ್ತಿಗೆ. 19. ನೋಡಲ್ಲ ಹೆಂಗ್ ಮಾಡಿ. Nineteen.
ಇನ್ನೊಂದು ನೋಡಿ ಸರ್.
ಅದೆಲ್ಲ ಹೋಗ್ಬಿಟ್ಟಿದೆ ಇಷ್ಟಿನ ಇರೋದು. ಮಾಡಿರೋದು